GMDRT.
Hello. 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 Can you hear me, ma'am?
You are audible.
Thank you.
ಸರ್ ನಾಳೆ ಕಾರ್ಯ ಹಾಕ್ತೀರಾ?
The bank matters, my lord. They are coming up with the Gunda elements, my lord. Yesterday's photo, my lord. They are trying to vacate me, my lord. I am ready to pay the installment or whatever the balance, my lord. One opportunity may be granted.
The
230,
same
my lord.
matter, what they mentioned.
Yesterday's matter.
What the court can do if you are not complied with office objections?
Officer, I will comply today itself, my lord. My lord, the urgency is that, my lord.
In that matter, notice is ordered and the matter is coming after vacation.
Please, my lord. Now,
Then why should we take up now?
my lord, now the urgency, my lord.
Because the court heard, there is no point it is adjourned.
Please, my lord, I agree, my lord. Today I will comply the objection.
Not for office objections, sir. I ordered notice to the respondents. If I ordered notice to the respondents, I heard the matter and there is no point to grant interim order. I have done so.
Please, my lord, the notice, my lord, they yet to be served, my lord. Till then, my lord, they are coming up with the good elements. Trying to vacate me from the position. Kindly, my lord,
But I will take up tomorrow. I take up tomorrow.
Please.
And because they are coming and vacating you, I will not grant any order unless and until you make a legal
I
point.
will serve them personally, my lord. Please.
I think you are not understanding what I said. Yes.
Notice I will
Take it,
serve.
take it.
Please.
Yes.
My lord, I am the petitioner party in person and senior citizen also. In respect of, by order dated 17/11/25, this honorable court passed order for a one-time settlement of the matter. And I was asked to bring DD for rupees 5,50,000 rupees. And I brought the DD in the next date of hearing. And the learned single judge of the bench passed order that this matter doesn't, I have no power to deal with this. It's maybe posted to before the appropriate bench. Now I inquired in the board bench that my file is with the board bench, and they're saying that it is reclassified as DRT, James DRT, and any plea can be made here. My lord, this in defiance of the order of this honorable court dated 17/11/25, the bank, respondent bank has issued demand notice to me to pay entire amount despite the operation of the interim order and all
Tomorrow,
that.
yes.
I am seeking posting of this matter today.
Tomorrow, sir.
Today at
Malad.
2:30.
It's not
Nale.
My lordship.
There are so many matters today, tomorrow. Yes.
My lordship,
Malad,
bank
with your-
matter.
Yes.
Your Lordship, Malad, one matter, Malad, I have challenged the possession notice before the Assam court, Malad. The Assam court granted interim order, Malad. Subject to, I have deposited that. In the meanwhile, Malad, the respondent bank has taken action notice, Malad. That I have challenged, Malad. The tribunal has granted interim order subject to deposit amount, Malad. I went to the bank along with the demand of check, Malad. They refused to receive the amount, stating that the DRT has directed to pay the amount by 1 p.m. But I went to the bank at 9 a.m. only, Malad. They stating that by 3 p.m. It is already 3 p.m. Therefore, declined to receive the amount. Now, on the basis of the order obtained in the year 2020, Malad, they have affixed the notice on the house property, Malad, that they are taking possession with the help of police at any time, Malad.
DRT has passed an order.
DRT passed the order, Malad.
Now, because the bank has not obliged the order passed by the DRT, now this court will interpret.
No, Malad. Now the possession notice has been affixed, and
Why not you go to the DRT?
Malad, DRT, Malad, Malad, that because Malad, I have challenged the possession.
It also can be questioned before DRT. Why
Malad,
should
that
you
is
come-
Malad, because Malad, at any time Malad, they may take possession, Malad. I am ready. DD check is also ready, Malad. Amount is also there, Malad.
The order passed by the DRT.
Malad, DRT was passed recently passed the order, Malad.
How recent it is?
Please, Malad.
How recent it is?
About 1 week back, Malad.
I don't understand coming, going there.
Malad,
Half of
it
the
has
order
been,
there, half
Malad,
of the
bank
order
is
here.
harassing the parties, Malad, like anything, Malad.
Let DRT look into. We
Malad,
can't-
I have filed application. Otherwise, Malad, they will dispose me, Malad.
pending application, you move.
Malad,
before
the
the
matter is,
DRT.
since I have challenged the possession notice, Assam court granted interim, that also I have complied. What yes, they have given for 44 lakhs. I have already deposited 30 lakhs.
This is a whole problem in granting interim orders.
Malad, I have deposited
People want.
totally 44 lakhs, Malad. Out of that, Malad, 30 lakhs has been this, Malad.
So why
Subject.
should we stay for the other thing?
Please, Malad.
The other amount you are liable to pay to the bank or not?
Yes, my lord.
But then
My lord, I applied the interim order, my lord. I have paid the amount, my lord. But because there is a delay of 1 hour, my lord, 2 hours, my lord.
order is of the DRT, don't tell about
And-
this
and
before
that,
that.
I am not that, I am not on that point, my lord. Only that, my lord. They have affixed the 16th, they have affixed the memo notice on the house, my lord. They will take possession with the help of police, my lord.
Within 1 week,
Please, my lord.
there will be 1 week time in that.
By Saturday, they will evict me, my
You
lord.
should have gone to the tribunal. Why did you come here? That's what I'm asking.
My lord,
We can't, these kind of forum shopping will not do. You are having initiated the proceedings pending before the DRT. DRT will look after that, because even if I give you permission, the same order is going to be. So please, let's not go into that. Yes,
My
next.
lordship, the petitioner is a lordship's wellness and naturopathy hospital, my lordship. The petitioner is a petitioner is a wellness and naturopathy hospital, my lordship. More than 20 workers are staying in the same premises, my lordship. And doctors also staying in the premises, my lordship. Bank matter, we are ready to regularize the loan amount, my
To
lordship.
file that.
ಲಾಸ್ಟ್ ಮಂಡೇನೆ ಫೈಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ, ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
Yes.
Kindly may attend tomorrow, my
If
lordship.
it is, if office objections are complied, list the matter.
We
Yes.
complied, my lordship.
Yes.
ನಾಳೆಗೆ.
The petitioners are neither borrowers nor the guarantors. The respondent has taken my possession.
When was the writ petition filed?
Please, my lord.
When was the writ petition filed?
11th itself. I have complied with the office objections also.
Then why are they not
They have
listed?
raised some more objections here.
And then that has to be complied.
That I am going to, this may be taken up. This,
If the office objections are complied, list tomorrow. Yes.
FC matter.
I will comply with that. Since it is an exceptional case, I am coming up before this.
My lord, FC matter. They're pursuing execution proceeding, my lord. 9 December itself, I've complied the office objection. I moved then also, still it's not listed, my lord.
Take that. If office objections are not complied with, none of the matters, don't list it and ask the office to give back everything with a note and give it to the advocates. Yes.
Please, my lord.
My lord, the petitioner is a farmer.
Huh?
The petitioner is a farmer. Not a farmer and borrower. All objections.
Use the mic. I'm not able to hear you.
Her residential property is under auction on Monday, my lord. Means the matter may be taken today,
When was the
2:30.
notice issued to you? When was the writ petition filed?
On Monday, my lord.
Monday was the writ petition filed.
Yes, ma'am.
When was the notice issued to you?
On 11th of,
Think this waiting for till the last day and moving the matters. Tomorrow is a half day, all of you know. How will the court take all these matters tomorrow? Already in list, there must be 80, 90 matters tomorrow. You can move the vacation court. Yes.
Your Lordship, I appear for the petitioner in the matter. The property of the petitioner has been auctioned off without giving notice to the petitioner.
It is auctioned.
But the auction purchaser has not paid the amount. We are ready to deposit the full amount, Your Lordship. And there was OTS talks going on in the meantime, but without notice, they have auctioned off our property.
When was the writ petition filed?
In the morning, Your Lordship. There was some urgency that we got to notice.
How will you know now? How will you know today morning?
No, we got to know within a couple of days back. We got.
But I have no time today. Yes.
Kindly have it tomorrow,
No,
Your Lordship.
I'll not. Yes.
The application.
Yes. Yes.
Application for examining the additional witness has been rejected by the trial court. Pressurizing the, my lord,
When was the order passed?
yesterday, my lord, and pressurizing the advocate to address the arguments, or else judgment will be passed today, my lord. Without hearing the arguments, the application straight away rejected. And set down for today, if the advocate is not argued the matter, the judgment will be passed.
Why advocate is not arguing?
My lord, the additional examination of additional witness has been filed by the advocate. That's not been
Which year is the MC?
25, my lord. 2025. In the
MC, they are going to pass a judgment.
yes, my lord.
Which court has that much free time?
This is from Chikbalapura district, my lord.
Take.
Should be taken up at the end of the list.
Now for settlement.
Lord, there are two properties in this petition. Lord, the
Is it a fresh
1 crore,
matter?
1 crore,
Is it a fresh matter?
yes, my lord, fresh matter. 1 crore 5 lakhs was the due, my lord. My lord, petitioners have paid 76 lakhs, my lord. My lord, on 28/11/25, my lord, the bank has issued sale certificate only for a sum of rupees 84 lakhs. Only 6 lakhs was pending for the amount.
Whatever happened, That we can see after vacation also.
My lord, kindly see, my lord, because my lord, the school going children are there. My lord, the woman now, my lord, she will be in the street, my lord, otherwise.
So they have taken position and conducted
But
the.
my lord, only 6 lakhs amount was due, my lord. Were ready to pay that amount.
When it happened?
My lord, 28/11/25, my lord.
Today.
But my lord, the yesterday night only they came, my lord, prepared the petition.
You can move the vacation court. Yes.
Reporting settlement, my lord. One has to pay.
Yes.
My lord, my lord, kindly take at least tomorrow, my lord. My humble request, my lord.
Matter is
What is that?
Plus the matrimonial dispute, the matter has been put for judgment in the trial court without cross. It's been listed on 19th.
for rupees 2 crores.
That you can go to the tribunal.
But problem, I will not approach DRT yesterday, my lord. DRT only issued notice. Lord,
So now, when
under
notice is issued, now we have to grant stay in that.
No, I'm under threat of disposition from the house. It is the only house, my lord, I'm residing in. That is urgent. Lord, kindly,
Pending matter, my lord.
Lord, he underwent art surgery in the month of November 21st.
So, no, I'm not able to understand one thing. DRT issues notice now, then that we have to entertain a petition and grant stay.
The DRT has not entertained application for stay. We have filed application for stay.
That's because maybe there are no reasons for that to grant.
The date is given in the month of 12/1. Before that, if they issue,
What did you question before the DRT?
They have fixed the reserve price at 2 crore. I purchased the property in 2018 for rupees of 2 crores. 2 crore 20 lakhs. Now they have fixed the reserve price that it is a clandestine lower value, undervalued property. That is the reason.
Position must have been taken by this time.
No, my lord. I'm in the possession of the house. I'm after my surgery. I'm residing in that house. That is the reason. Kindly have it moved to.
Any of the facts which you have, if I'm not convinced, I'll dismiss with the cost of rupees 1 lakh.
Lord.
If you're ready, then you give the memo. Whatever the facts you're saying now, any of it, if you know this order at much before and you have come before this court, now whatever the fact that you are stating are not correct, I will dismiss with an exemplary cost of 1 lakh.
Please.
Take that tomorrow.
It's a pending matter, my lord. There is an interim order. My possession of my house has been already taken by the respondent bank, my lord. They did not allow me to comply with the order, my lord. I have taken the DD and they said the amount is different. I told them to intimate the amount to make the payment. Till date, they have not told me what
order.
It is actually December, my lord. December 2024, the order is passed, my lord.
For another year. Yes,
for 1 month, I have tried to move the matter, my lord.
Yes.
There is no due, my lord. Respect to credit card.
Is it a fresh matter? When was it filed?
Monday. Observation.
If compared with, yes.
Your lordship, my humble apologies. We only got to know about the auction on 12th, and then we have filed the petition right after that. It has been filed today morning. The auction has already taken place, and they have not given the amount completely. We are ready to pay the amount. If this does not been taken up, then the sale certificate may be.
What will happen is now your position is the moment the auction notice is issued.
It was not issued, your lordship.
Auction notice.
It never came to our attention.
Not your notice. Auction notice is issued. Auction notice is issued. Whatever is your position, the day auction notice is issued will continue to be the same even if he pays or he doesn't pay the amount.
Kindly an opportunity may be given, your lordship. Kindly tomorrow if the matter gets taken up.
Yes, call the list.
Page wise adjournment.
One submission. That's GMFC matter. Twice it was moved, it was not listed. I request my lordship kindly consider it tomorrow.
What is urgency?
That's the petitioner is a senior citizen. Matter was settled. In spite of that, the memo is filed and the Honorable Family Court has directed. My lords had remanded back. We moved an application. It's without consideration of the limitation. My lords, again, it has been rejected. That is the only ground.
So what is the consequences? What is the consequences of that?
My lords, it's listed on 24th, and my lords, the Honorable Family Court would initiate a warrant regarding.
But even the vacation also the court was.
till 25th, it's 24th is the last vote.
When was the order passed?
My lords, it was passed on last week. We have filed, complied with it. My lords, 3 days.
If
back.
office objections or complaint is tomorrow, yes, call the list.
Page wise adjournment, list number 1, page number 7, serial number 28 to 31, page number 8, 32 to 37, page number.
My senior mother-in-law passed
Mother-in-law,
on Sunday.
inform the other side.
Yes.
At the request of land council, the petitioner is this matter.
Pending extended.
After vacation, it is submitted that the same is informed to the council for the respondent. Interim order granted is extended. Yes.
Page number 9, serial number 38 to 40.
My lord, serial number 40, my lords. 40.2, it is a connected matter, my lord. We had engaged the senior counsel. He is not available today, my lord. Kindly post after vacation, my lord.
Have you informed the other side?
Yes, my
lords,
lord.
and the in 40 and 40.1, my lords, it may be taken up after vacation, my lord.
Have you informed the other side?
Yes, my lords, I've informed the bank council. Yes.
Bank council informed.
Yes, my lord. We are for respondent number 1.
At the request of the petitioner, list this matter after vacation. It is submitted that they have informed the bank council and they have no objection.
My lord, I am appearing for respondent number 1, my lord, in this matter.
In which matter?
In
40.
You have
Serial
respondent
number
one is
40. Bank, my lord. 40.2.
Both the bank and the council for the petitioner seeks time. This matter after vacation. Interim order earlier granted is extended. Yes.
Page number 10, serial number 41 to 45, page number 11, 46 to 49.
Serial number 49, my lord. Senior is out of station.
Fresh matter.
Fresh matter.
After vacation.
Page number 12, serial number 50 to 58, serial number 13, page number 13, 59 to 64. Page number 14, serial number 65 to 70, page number 15, 71 to 78.
Serial number 72, my lords. My lord, senior is not in the country, my lord. Matter may be taken up after his vacation, my lord.
Have you informed the other side?
Yes, my lord, I have informed, my lords.
Yes, same. Look at it, if any interim order. No further adjournments. 72.
My lord, senior is not there, my lords.
Why he is not there?
My lord, he went out of country, my lords.
You argue then.
My
That's what the cause list shows.
My lords, one date, my lords. We'll do it in the next date, my lord, without fail.
Yes, after vacation.
Obliged,
Page
my
number
lords.
16, serial number 79 to 85. Page number 7, that is 2. Page number, list number 1, serial number 1 for being spoken to.
Should I appear for the appellant? The appeal is on the question of liability, my lord. The accident took place after the amendment. Lord, the person had no driving license. The lordship pleased to grant an interim order of stay. Lord, on such a deposit, my lord, permitted to withdraw the will.
That's the whole difficulty. They just write it, this quote on 7/11/2025 has passed an order. Whereby where it is observed that the insurance company is questioning the liability. But in the order, it is reflected as on such deposit, the claimants are at liberty to withdraw the same. The order, as far as this, on such liberty to withdraw the same shall be deleted and the corrected copy shall be uploaded. Yes.
My lord, 4 weeks time may kindly be granted to deposit the amount.
4 weeks time from today.
Process already paid, my lord.
Huh?
Process already paid.
Yes.
Pronouncement of order, serial number 2, Venkat Reddy.
The respondents. Yes. Writ petition is allowed.
For dismissal matter, serial number 3, Srinivas Rao for petitioner.
You are for the respondent.
Yes, sir.
You that.
Subject to condition of deposit the 50% of the amount he has not deposited. Is only 1,05,000 rupees deposited.
What is this file? Three you have to give me.
announcement ಅಲ್ಲ 26243.
Interim order is complied with
No, no, out 2,40,000.
2025. An interim order is passed by the coordinate bench of this court. Then counsel for the petitioner respondent submits that interim order
Not complied fully.
is partly complied with. When the matter came up on 10/12/2025, as there was no representation on behalf of the petitioner, the matter is listed today under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, RPFC is dismissed from prosecution. Yes.
Cell number 4.
Except for the appellant, my lord, the matter is arising under the Employees Compensation Act. My lord, we have deposited the entire amount before the tribunal with interest, my lord. I have produced, my lord, the photo, scanned copy of this.
Original certificate for having deposited award amount along with interest before trial court.
Scanned copy has been produced before.
What is the procedure that you tell the court?
Scanned copy, my lord. I will
No,
produce
what is the procedure that is followed usually?
Then, my lord, we have to produce the certificate, copy of the
Original
deposit memo.
Then why you have not done?
My lord, it was not by mistake of communication, my lord, it was not produced. But a scanned copy.
For everything, please don't come up with these
My lord,
kind
I
of
will produce,
submissions.
my lord,
What
you
it's
will not
supposed to do,
kindly.
you should do.
Entire amount has been, my lord, it may be taken as a statement, my lord, it has been deposited.
No, but when there is a procedure for everything, counsel submission.
My lord, the problem is this, my lord. Sometimes they will send it through.
No problem for the insurance companies, you should do.
Through
You are
courier.
not a claimant.
My lord, your
What
lord
is
may
objection
kindly,
shall be
my lord,
complied with?
your lord may kindly, my lord, I will deposit.
That's what I understood. Why the counsel submission now?
My lord, that original copy will be give it to the audit purpose, my lord. Subsequently, my lord, we will produce the same, my lord. The same issue is going on in ECI matters, my lord. We are very much deposited, my lord. There is no issue on that, my lord. That acknowledgement seal with seal also produced.
That is a procedure by the.
Please, my lord, but
It's adopted, you should do it. Your insurance company
for
should
time
do
being, my
it.
lord, they will return the amount, my lord. There is no purpose for pending of appeals.
That's the only difference. Sometimes, my lord, this courier sent.
All counsel submissions.
That's what, my lord.
Oh, that's why you have come. Yours is also
Next
there.
is mine. Audit purpose, my lord. They will send the original with their photo sent by the.
Scanned copy we used to produce.
Please, my lord, I will show that original also, my lordship. They will send it for audit purpose, my lord. The March end, my lord, they will provide again, my lord. This is the certificate, my lord. Yeah.
The petitioner, the appellant has placed before the court the photostat copy of the certificate to show that he has paid the deposited the entire amount. Office has insisted for a original certificate. The petitioner shall place the same before the court
Within 1 month, my lordship.
within 1 month from today. Yes.
Previous matter also, my lord.
Previous matter only.
Sorry.
What is your case on the area? What's your case?
My lord, my submission is, my lord, this, we have not issued, my lord, he was the father and son, my lord. My lord, we issued is this.
This order is passed on 8th January 2025.
Yes, correct, my lord. We have.
What are you doing from 8th January to now?
My lord, subsequently, my lord, they have raised, my lord, regarding interest and other things.
Huh?
Interest part and other things. Then we have deposited it and there was some office objection raised. We have
1 year it took to complete the office objection.
That, my lord, I just.
The order is dated 8th January 2025.
Deposit come also filed along with on 9/10/25. And my lord, there was a delay and there was an office objection. We have complied with. Then it came before the registrar, my lord. Then we have done needful. Then, my lord, it was posted before this honorable court.
Yes, what is the matter about?
My lord, the father and son, my lord, there was no employer and employee relationship. My lord, what has actually has happened is, my lord, he was the driver of the insured tractor. But my lord, that tractor struck in the, my lord, My lord, he was the vehicle which involved in the accident, my lord, had no insurance. He was driving that. Then, my lord, our
relationship of employer and employee. In fact, the son and the father, the court without considering all this, and the insurance company is liable to pay the compensation, and they shall be stayed. Yes. 5 also with regard to the office objection, same. Yes, what is this matter?
ECM matter, when there is no driving license for the driver, my lord, pain recovery order has been passed, my lord. As for Bailey Ram's case, my lord, there is no question of pain recovery, ECM.
It is same office objection is same like in the earlier one, and counsel submits that the court has passed an order of pay and recover when the claimant himself is a tortfeasor.
No, my lord, no driving license.
No, no, he is the one.
Please, please.
It is submitted that the court has held that the principle of pay and recover will apply. It is submitted that in the light of the law laid down in Bailey Ram's case, when the claimant himself is a driver, question of pay and recover will not arise. Considering the same, they should be stay of all further proceedings in both the matters noticed to the respondent.
Chair number 6.
Not to disperse. Not to disperse.
No, I am not saying. I am not said to disperse. They shall be stay as well.
Please.
Chair number 6. Yadunandan.
For the appellant in this.
What is this non-deposit of the balance amount of interest?
ECA amount, my lord, an ex parte order was passed. Compensation amount has been deposited.
It has to be with interest.
Now, my lord, the interest part, we already deposited the compensation amount. My lord. Interest.
No, it has to be with interest also.
Will do. That may be a conditional or deposit.
And there is no condition. That is a precondition
Lord,
to entertain this appeal itself.
only interest amount of 3 lakh something will deposit.
What is it? How much is the interest?
Lord, 3,57,000 will deposit.
Deposit.
100. My lord, meanwhile,
No, you should do it before. This is arising under the ECA. Not that it is a conditional order.
do
Do it. Without that, there will not be any stay.
it within 3 days.
Huh?
Deposit within 3 days.
And I'll list this matter in the vacation court. List this matter before the vacation court. By the time the petition shall deposit the balance amount of the interest. Yes, 7.
Chair number 7. P. Pradeep.
What about this?
This case, my lord, questioning the liability, my lord, now.
No.
Because traveling is
No,
an
no.
unauthorized passenger.
This is also same original certificate.
Please.
Office objection. Same office objection as was in 4 and 5. Yes. What about this?
This case, my lord, the first respondent was traveling in unauthorized passenger vehicle, my lord, there is no relationship between the master and servant. And my lord, income considered, my lord, wages considered 4,800, date of accident, my lord, 2003. 4,000 would be the maximum, my lord. And while calculating the future earnings, my lord,
2003 accident, 2025 is the order. Why is
second
the-
round of litigation.
Oh, remand matter. The insurance company is before this court questioning the compensation on the ground that there is no employer-employee relationship. Employee relationship, and the court had taken the income at 4,800
800.
when the accident had taken place in the year 2003. Yes. Stay.
Chair number 8. T. Vijay Kumar.
And also the question of reputation, my lord. The
Liability on what ground?
Liability, there is no DL for the driver of the car.
When did the accident take?
No, the accident was taken Subsequent to amendment.
Hmm?
Subsequent to amendment.
No, when not the accident. When is that
22
policy?
by 2023.
Policy is prior to the amendment or after the amendment?
After amendment.
Policy.
Yes, my lord. Because the accident itself on 25, 22 by 2023.
No, that you have to be specific whether it is a court has already granted pay and recover.
Well,
Court has granted pay and recover.
pay and recover, no, that they are
Huh?
not. But policy, another.
Let's see the.
23, 2023 to 19, 2024.
20?
23, 2023
Hmm.
to 19, 2024 policy. That is after the
The office has raised objection with regard to the maintainability as the value of the appeal is below 1 lakh. Land council submits that the insurance company is questioning the liability as there was no driving license and the accident had taken place. The policy was issued after the amendment to the act. As such, appeal is maintainable. Office objection with regard to the maintainability is overruled. Next, IA number 1. IA number 2 of 25. Considering the submission that there is no driving license and the accident, the policy is much prior to the amendment, there shall be stay of all further proceedings on depositing 25,000 rupees within 4 weeks.
8.1.
connected.
Yes,
But actually, my lord, by mistake, my lord, the trial court, instead of mentioning the year in the cast title, the date of judgment, my lord, 28 April 2025, but they have mentioned as 2024. That is the only mistake. That's why they have calculated the delay. Actually, there is no delay. All the three connected.
They will calculate unless and until you clarify this dates and all by filing by getting this corrected.
Stay.
Yes, like in this earlier one, stay, no maintainability, only on the stay. Yes.
8.2.
What is the amount granted in this?
In this 1,90,000.
In this 50% of the amount to be deposited in this.
56.
In 8.1. Yes, 8.2.
My lord, in this case, my lord, 50,000 rupees award. Same, all the three are connected.
Huh?
All the three are connected.
Connected. Maintainability is also same. How much is awarded?
50,000.
Huh?
50.
Entire 50,000 to be deposited in this.
Still number 9.
Respondent number 1 is concerned, my lord. The postal share shows it's left, my lord.
R1 for second time. Who is R1?
My lord, R1 is the original RC owner, my lord. Presence is required. So far as respondent number 4 is
3 weeks time.
So far as
No, it says for R4. Notice to R4 returned with the postal share refused amounts to deemed service of notice. Yes, list is after vacation.
Date may be given. Insisting for stay, my lord, because service to respondent number 1 is mandatory, my lord. In this case, my lord, liability is fixed against the purchaser of the vehicle, my lord. But
who are you?
I am the purchaser of the car, my lord. Accident taken place, but RC is in the name of respondent number 1, original owner. It's not changed, my lord.
As on the date of the accident, your car is with you, not RC car.
Car is with me, but Supreme Court held that even RC is not changed, my lord. The liabilities goes to RC owner. That's the recent verdict of Supreme Court.
When did you purchase a car?
2023, my lord.
When was the accident taking place?
In the year 23. Therefore, my lord, virtue of Supreme Court judgment, my lord, is very clearly held that, my lord, the RC owner is liable to pay the compensation. Therefore,
how much is the compensation awarded?
My lord, 50% had been fixed against me. It comes around 11 lakh 55,000.
It's a case of death.
It's case of death. We have
by an auto. They are, after lapse of 3 days, they will lodge a complaint stating that he was traveling in a trailer as a passenger, unauthorized passenger. That contamination also we have taken. Both liability, both grounds are urged before this court. Delay, 3 days delay in lodging complaint. The history of accident in the MLC, hit by auto rickshaw. After lapse of 3 days, he stated that he was traveling in a tractor and trailer.
Now, where is this employer-employee? How he is claiming that?
That's what my lord. If my lordship in another MLC is showing that hit by auto to the trailer. Two versions are there. My lord. Initially, my lord, it is only written as hit by auto. Subsequently, my lord, one more MLC, my lord.
No, it is
Yes,
arising out of the ECA proceedings. What is that he says that he's the employer of the?
Is not, there is no relationship also. My lord.
No, what is his case?
His
Claimant's
case is that he was traveling as a
working as coolie under employment of respondent
Yes,
number
my
1
lord.
and 2 in tractor.
2 and 3. Respondent number 2 and 3.
Tractor.
Tractor owner is different, my lord. Driver is different.
Tractor owner is different.
Tractor owner is second respondent. Trailer owner is third respondent.
He's working with.
Stated that he was working with the.
I think the same analogy applies. Whoever is.
Please, my lord, but the case is different.
Case of death or injury?
Injury case.
How much is granted?
Tribunal has awarded, my lord, 13,63,290.
So if you look at paragraph number 11, Exhibit P1 first information report that incident in question took place when petitioner was going as coolie in tractor and trolley belongs to respondent numbers 1 and 2. Though PW1 has been cross-examined at length, these documents have not been disputed. As such, have remained unchallenged. With regard to the relationship.
Para 22, please, para 22, it has been. Para 22 regarding
Please
liability.
read.
It has held that, my lord, the tribunal has not discussed with regard to MLC and accident register. My lord. The tribunal has coming to the conclusion that, my lord, once it is held that petitioner is entitled for compensation, quantum fixed liability has to be fixed. It is specific contention of the respondent number 3 that the respondent number 1 and 2 have violated the.
No, where did you raise such a contention in the? Where did such a contention raised with insurance company?
Please, my lord, the document itself has been produced and doctor also examined RW4.
Where do you get that?
Please, my lord, I have a document. Not well. Shall I provide?
No, there is no discussion in this.
No, ma'am. That's what. There is no discussion.
What are the?
Straight away, they
Let's
coming
see
to the conclusion with regard to traveling in
let us see the exhibits.
exhibit. Please. Exhibit R2 is a case history, my lord, and exhibit R3 is the MLC case sheet and MLC.
There are two MLC.
No, case register and MLC Chitteri Hospital. Exhibit R2 may kindly be seen.
This is not discussed by the tribunal.
No, my lord. Kindly peruse the exhibit R2 and R3.
Please come. When transfer the apparent insurance company submits that. When there are contradictory, when the version of the claimant in the claim petition and the exhibit R1 and R3 speaks contrary to that, the court has failed to take that aspect into consideration, which goes to the root of the matter, the manner in which the accident had taken place. Hence, as such, the insurance company is not liable to pay the compensation. Considering the same, there shall be stay of all further proceedings.
Okay.
Notice to respond.
Question number 11. Kartik, Kiran.
For the petition.
Complaints of office objections on IA.
My lord, I had filed a fresh application for continuation of delay upon.
That is IA4.
IA4, my lord.
Then what are the objections on that?
My lord, it is the objections is that, my lord, the pagination should continue upon the fresh IA in continuation with the main petition, and that a fresh index sheet has to be affixed to it.
Then why you have not done it?
My lord, I'll comply with it during the course of the day, my lord. If I may kindly be heard on the application for stay and the.
How much is the delay?
My lord, the delay is 797 days.
What are the reasons come to the application, that affidavit?
My lord, the facts of the case, my lord, is that I got married to the respondent on 2011-2013 at Tongal, Andhra Pradesh. And thereafter, my lord, I set up my matrimonial home in Bangalore. From 2013 to 2015, I have been residing in Bangalore, my lord. And thereafter, in November 2015, the respondent she got pregnant, and under the pretext of prenatal care, she goes to Mysore to her natal home. And then, my lord, in 2016.
Read from your affidavit.
My lord, that since the initiation of the impugned proceedings, my lord, I was not aware of aware that the proceedings for maintenance had been initiated against me, my lord. I was placed ex parte in this particular petition. Thereafter, my lord.
How do you substantiate this 10.1?
My lord?
10.1.
10.1. The 10th point, madam.
10.
Lord, after the first, there were two execution petitions.
Read that. What I'm not able to understand. What exactly that does that mean?
Throughout the pendency of the recovery proceedings, I could not approach this honorable court in a timely manner due to bona fide reasons. I state that I was placed ex parte in the trial court proceedings, as my correct address was not furnished to the honorable court below by the respondent number 1. Hence, despite having sufficient knowledge to my correct address.
The recovery proceedings came to your notice long back. That's what you're saying in 10.
Please, my lord. I got to know that the proceedings for maintenance had been initiated against me only through the recovery proceedings, not through the main petition.
That is when. That's the date of your knowledge.
My lord, the date of knowledge, my lord, for me was when the proceedings was initiated in criminal measure 688 of 2023, my lord.
Date.
The date, my lord, I have a memo of documents.
That's not required. You tell the date. Your affidavit should have contained it. When an affidavit is filed under Section 5 of the Limitation Act, and with this kind of delay you're coming, you have to be specific.
Please,
when is the date of knowledge?
12/10/2023. 12/10/2023.
Then why should we condone the delay from 12/10/2023?
My lord, the reason, my lord, is that from 12/10.
That's why all the more reason that it should go for notice, no interim order. Notice to the
My lord,
respondent.
kindly, my lord, if I may submit, my lord. Throughout since the execution proceedings had been initiated, my lord, I have already made a arrears payment of around.
You
8
might
lakh-
have done
9
from
lakhs.
2023 after the knowledge, you don't come to the court. And now with that delay, why should we grant an interim order? And what is the sanctity of the order that is passed by the court?
My lord, the trial court proceedings, my
I'll
lord.
not interfere, Mr. Counsel. I told, I made it very clear last occasion. Notice to the respondent.
Till
This
number
is
12.
matter once the notice is served.
12.
This case appearing for respondent bank, my lord.
Number
For the petitioner, Your Honor.
Yes.
Your Honor, the bank is not giving me the exact amount to how much
And
to
that one,
pay.
that 30 lakh, 36 lakh rupees, my
But
lord.
when I approach the bank, they're telling pay only the 6 lakh.
No, my lord.
I think that you can settle with the bank. I
Yeah,
will, there is no reason to keep this writ petition pending.
Allow me to go to DRT at least, Your Honor.
That's what ultimately from 2022, you enjoy an interim order without paying anything.
Yes, my lord.
And now you say, allow me to go to DRT. How will you go to DRT?
Sana, I'm ready to make the 20% into
No. Why 20%? Is it written in the Surface Act?
The exact amount, Your
They have already informed.
Person is telling
And even if they're not
36 lakh,
informing, that's between you and the bank. We can't help it. 2022. What is outstanding?
36 lakh, my lordship.
But
No amount is paid from that day.
No, my lordship. After calculating entry out, after that, they are not any. They are not
Please come.
Any display.
The writ petition is filed, seeking the following prayer. A coordinate bench of this court on 13/12/2022 had granted interim order on the condition that the petitioner shall deposit 10% of the outstanding amount within 4 weeks, remaining 10% within 4 weeks thereafter. And that interim order is extended from time to time. When this matter came up before this court on 15/12/2025, this court has directed the petitioner, observing that the outstanding amount is 36 lakhs. The petitioner shall file an affidavit by 18/12/2025 when the petitioner is going to pay the amount. If the affidavit is not filed by 18/12/2025, this court will dismiss the writ petition on that ground. Today, when counsel submits that, the bank is not giving the correct details. Bank has already submitted before the court what is the outstanding. Without any legal ground, the petition is enjoying the interim order from 2022. This court do not find any reasons to grant any relief in this writ petition as the petitioner has an effective alternative remedy. Accordingly, the writ petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy, provided the same is within the limitation. Yes.
Till number 13. Mallikarjun.
Please come. This court, by order dated 29th July 2024, has directed the family court to dispose of the matter as expeditiously as possible, but not later than 1 year from the date of receipt of the copy of the order. Now, the learned judge has addressed a letter seeking extension of time. Considering the reasons that are stated, it is extended till March 15th. No further time will be granted. Yes.
Serial number 14.
Sir has filed this application seeking permission to not attend graduation conference in San Francisco. Not between the period from 8/1/26 to 4/2/26, 8/1/26 to 4/2/26. On an earlier occasion also, not this Honorable Court was pleased to permit her to attend not the admission of her first daughter, and she promptly.
What is this writ petition?
The petition is filed by the petition challenging the.
Tribunal passed an OA number so and so.
I'm not opposed to the application subject to certain conditions being laid down. If your leadership may have the order dated 25th of July 2024 passing this writ petition. Leadership may please come to para number 4 and 5. Earlier permission was granted, they have traveled, she has compiled the order. Similar order may be passed along the lines. If I may seek for 4 things, your leadership. First, an undertaking before this court that they'll return on, that she will return on such dates mentioned in the application, in the affidavit. Second, an undertaking not to alienate the properties while during the time of a travel. Third, direction to deposit the passport when she returns before the DRT1. And fourth, to report compliance before this court. If that may be done, if that is directed, then I have no issues with I number 1 of 2025 being allowed.
No, I'm not able to understand why this issue of traveling has come before this court.
Earlier, they had.
Not the DRT had directed the petitioner to surrender the passport. Now, during that order, is challenged in this petition. But during the last year, the petitioner wanted to attend to admission of her first daughter. But this Honorable Court was pleased to grant an interim order permitting her to travel. And accordingly, she traveled and surrendered her passport in terms of the order passed by this Honorable Court. Now, at the time of granting earlier permission, this Honorable Court had observed paragraphs 4 and 5 of the interim order. That your lordship.
So where is the application now?
Yes, I have produced IA number 1.
1 of 2025, your ladyship.
Para number 5 and 6, it stated, it is humbly submitted that in the light of her daughter's degree conferral ceremony on 8/1/26, the petitioner has purchased air tickets. It is bound to depart to San Francisco on 2026 from Bangalore to return to Bangalore 4/2/26 from San Francisco. The copy of the itinerary with which is produced at Annexure B for kind perusal of this Honorable Court. It is most humbly submitted that her daughter's degree conferral ceremony is an emotional and vital event, etc. Now, my lord, she wants to travel between the period from 8/1/26 to 4/2/26.
What is that you are submitting?
I appeal for respondent number 3, the bank. I don't have any objection to this application being allowed, subject to certain conditions being laid down. Those 4 conditions
As it was in the earlier order.
Earlier. Undertaking that they'll return on such date, undertaking not to alienate properties, direction to deposit the passport when they return, and also to
All
compliance
these things
report.
are not there in the earlier order.
But it is there, madam.
Even if it's not there, the compliance, it was reported before this court by filing an affidavit. Your
But
ladyship
may
may
I-
have the affidavit filed.
Petition would file an affidavit of undertaking and submit passport to the back to India, file an of so and so. Travel abroad in terms, where is this? There is no condition with regard to that they should not alienate the property and all.
But paras 4 and 5 of the
4 and 5
interim.
ladyship may have the order. This undertaking was filed before the DRT1. If I'm not wrong, my senior may clarify on that point.
This undertaking was filed before DRT.
We have filed an undertaking.
Undertaking not to alien properties was filed before the DRT.
Oh, this is another order.
Yes, please. Compliance may be reported before this court because they have already filed an application pursuant to complying with the previous order. On 28th August 2024, they have filed an affidavit of compliance.
Yes. Please come. The writ petition is filed, questioning the order that is passed by the DRT in I number 1735 of 2023 and I number 1028 of 2023 in OA number 2465 of 2014 dated 23rd April 2024. In the order passed by the DRT, where is that with regard to not to leave the country?
But yes, page 49.
My lordship, the main petition may be kept pending. I number 1 of 2025 may be allowed.
Doing anything with that. In order to ensure the tribunal, while passing the order, has observed that in order to ensure the presence of the defendant number 2 and 3, in order to ensure the presence of the defendant number 2 and 3, and to ensure further progress of the trial, to surrender their passports before the tribunal on the line of order dated 24/12/2014, passed by the tribunal. As the said order was not complied, the High Court had directed defendant number 2 and 3 to deposit their passports, which were subsequently deposited before the Registrar General of the High Court of Karnataka. It is submitted that earlier, when the daughter of the petitioner joined in Stanford, they have come up with an application earlier, and the coordinate bench of this court on 25/7/2024 has passed an order permitting the petitioner to leave the country on the condition that the petitioner would return back to India on 27/8/2024 and submit the passport to the Detectory Tribunal, and also file an affidavit of undertaking that she would not alienate any of her assets for a period of 1 month from the date of order. Accordingly, the petition is permitted to travel in terms of the interpreter, subject to the petitioner depositing passport before the DRT immediately upon her return from abroad, and also filing an affidavit of undertaking within a week from the date of order. She will not alienate. It is submitted by the counsel appearing for the petitioner that now they have filed this I number 1 of 25, whereby it is stated that the daughter of the petitioner has successfully completed her
Graduation.
graduation, and the graduation is on 8/1/2026. The petitioner wants to travel to the petitioner has made arrangements to depart to San Francisco on 2/1/2026 from Bangalore and return to Bangalore on 4/2/2026. And the copy of the itinerary is also produced as an Annexure B. Then counsel appearing for the respondent bank submits that.
Respondent number 3.
Respondent number 3 submits that. They have no objection. But however, the court may impose the same conditions as were imposed in the earlier order. Accordingly, the present IA is allowed, permitting the petitioner to travel to the US to US on 2/1/2026, and she shall return to Bangalore on 4/2/2026. Immediately after coming back on 4/2/2026, she shall surrender the passport before the debt recovery tribunal and also the debt recovery tribunal, that is one. Then she should file an undertaking before the court to the effect that she would return back to India on the date so and so. And she will deposit the passport before the debt recovery tribunal. Number two, she shall also file an undertaking that she will not alienate any of her assets for a period of 2 months from today. Accordingly, IA is ordered.
Abhilash.
In which case? So and so. Yes. Next.
Till number 15.
I'm for petitioner, Your Honor. I'm ready to pay 1 crore 81 lakhs. But condition that only 1 crore on or before 25 12 they are requested. I'm ready to pay 46 lakh on or before 30 12.
Counsel for the petitioners has filed an undertaking affidavit stating that we will further negotiate with the bank. The same cannot be accepted.
I paid
Have you seen
amount.
that?
I have seen it, my lord. This month we had requested them to pay 1 crore. However, they have agreed to pay only 46 lakhs on or before 30/12/2025.
Remaining amount?
Remaining
Take
amount.
that undertaking. Let's read that.
Page number 2, Your Honor.
The petitioners have given a representation. Petitioner ready to pay the OTS amount as agreed by the respondent bank for a sum of rupees 1 crore 81 lakhs. 46 lakhs on or before 30/12, 45 lakhs on or before 31, and 90 lakhs on or before 28/2.
Yeah, agreeable since they have agreed to close down before even 1 month before. It is we accept.
If it is,
this, my lord.
I
Only
already
thing, my lord,
take our loan.
let this matter be kept pending. If they don't, in the event if they don't pay the first installment, they will not be
For
entitled.
that, not necessary that we should keep pending. If they don't pay the first installment, you go ahead.
Yes, my lord, that may be.
I undertake that as per.
My lord, voluntarily they have to hand over the position because already we had taken position. Forcefully they have occupied they have.
That also I'll record.
Please, my lord.
The writ petition is filed seeking the following prayer. Was there any interim order before?
Yes, sir.
When is that?
Starting earlier.
Initially, on 29/8/2024, a coordinate bench of this court has passed an interim order on the condition, subject to the condition that the petitioner deposit a sum of rupees 7.5 lakhs within 4 weeks from the date of order, filing which the interim order would automatically stand vacated. Then on 6/12/2024, an order was passed observing that the petitioner, in the light of the interim order dated 29/8/2024, deposited a sum of rupees 4 lakhs and balance amount of rupees 3.5 lakh was not paid due to his ill health. As such, the bank has taken the physical possession of the mortgaged property. The petitioner undertakes to deposit the balance amount of rupees 3.5 lakhs, and upon deposit of the balance amount of 3.5 lakhs, the respondent bank is directed to redeliver the physical portion of the subject property. That was not paid.
My lord,
That is paid.
3.5 lakhs was paid.
There was a direction to you to redeliver. How can you say it is forcibly taken?
No, my lord, by then already they had taken.
No, you have taken. On 6/12/2024, court observes that because he has not paid, you have taken possession. Then court passes an order. If he pays the 3.5 lakhs, you should redeliver the possession. That is on 6/12.
That is what my instructions, my lord, that they have forcefully
So,
entered into
any
the
court order is complied with.
premises. They have complied. I'll correct
No.
my words.
in its
I'll
sense, it is
stand
complied
corrected
with
my submissions, my lord, because this was
such a
the
subject property to the petitioner
instructions.
forthwith. When this matter came up before the court, before this court, on 10/12/2025, a submission is made that the petition is ready to pay the entire outstanding amount for regularizing the account on or before 31/3/2025. This court had directed the petitioner to file an affidavit in that regard, and if the undertaking affidavit is not filed, this court will not hear any further arguments, and the petition will be dismissed on that ground. So today, the land counsel for the petitioner, today the petitioner has filed the affidavit. As per the affidavit, it is undertaken that they'll pay as per the bank, for regularizing the account, for the one-time settlement, an amount of rupees 1,81 lakhs has to be paid. The petitioner will pay an amount of rupees 46 lakhs on or before 30/12/2025, rupees 45 lakhs on or before 31/2026, 90 lakhs on or before 28/2/2026. It is stated that the petitioners have approached the ICICI Bank and SBI Bank for takeover loan, and the bank has agreed to sanction the takeover loan. If the bank sanction the takeover loan to the petitioners, immediately the petitioners will pay entire OTS amount even before the stipulated time. It is also stated that if the petitioner fails to pay the OTS amount, the bank can proceed as per law. Next part, the affidavit of undertaking is taken on record, and in the light of the same, the petition is disposed of in the following manner. One, say all that conditions should come. The petitioner shall pay 46 by so and so, so and so, so and so. Next, number two, if the petitioner fails to pay, and second, if the petitioner if the loans are taken over, the petitioner can pay the entire OTS amount even before the stipulated time. Number two. Number three, if the petitioner fails to pay any one installment, the respondent bank is at liberty to proceed further. Number four, if the petitioner fails to pay any of the installment as undertaken by him before the court, he has to voluntarily give possession to the bank. Accordingly, the petition is disposed of.
God bless.
Achha.
Yes.
Serial number 16. Serial number 16.
For the respondent number 2, Malak, kindly maybe passed over, Malak.
May request 230 million.
My lord, in this case, my lord, I am filing additional statement of objection and also the valuation report. Let them go through it, my lord. Their amendment application is pending for consideration. My lord, after the sales, my lord, they have filed an amendment application to challenge the sales certificate. In the previous date, this court directed us to provide the valuation taken at the
The
time.
only issue is court wants a clarification on that. Nothing else to be argued on.
I am
that.
placing all the documents.
Like when if I remember what he said on the last occasion, 24,000 square feet and 13,000. And what is that? If that is clarified, nothing else will not, this court will not go into other issues.
Yes,
Pass over.
230.
Serial number 17.
Copy. Last minute,
Respondent. Who appears for the petitioner?
Pass over the
I
matter.
think this is unreasonable on your part.
May the respondent address that.
You that?
That file is already passed over. No, 17.
What happened?
15 passed over. 17.
Call the, I think file is not there. I'll immediately they'll check.
File
We'll call. Please wait.
Very
Call the next matter and search for that file.
Serial number 17. Pass over. Serial number 18.
No passover. Call it immediately after the.
18. Praveen Kumar, Nirvani.
Then, yes.
Till number 17. 17.
Don't give everything. Give me one. First give 17. 10807. Yes.
That's 24367 is the main matter, my lords.
24367.
367.
Give 17.1. Yes.
This matter, my lords, we have challenged the NPA. On the ground, my lords,
Yes.
that the NPA is wrongly classified on the bills of exchange, which is clear. My lords, we come to know about the fraud paid to the bank only after we file a complaint before the banking ombudsman, my lords, in the year 2023. Thereafter, my lords, they replied to the banking ombudsman stating that on the which bills the accounts were crystallized and the account was classified as NPA, which my lords may kindly see a synopsis, my lords, which I filed in 24367, dated 16/12. I filed a synopsis, my lords, 16/12.
Yes.
Page 360.
There is 15.
369, my lords, page number 316 of the synopsis filed on 16/12/2024 in 24367.
What are all these documents?
My lord, these are the
There
sanctions.
should be some set of documents for the petitioner, for the respondent. Half of the time is going in the searching for the papers. Yes.
My lords may kindly come to 369, my lords, page number 369. This is the reply, my lords. Nine.
I think these are not the documents which he is referring to.
Synopsis 16.
269 is something.
369, my lords, 369. Synopsis dated 16/12/2024, my lords. Which runs up to 381 pages, my lords.
Yes.
369. My lords may kindly come to 371, my lords, in that.
Yes.
There, my lords, in the last para, the charge deducted for the export bill collection dated so and so for invoice number so and so from GRPP form number 3710034. That is the bill number, my lords, on which the account was crystallized, stating that the particular bill was not clear and the rest of the bills were also not clear. Whereas after this reply, my lords, the very same Canara Bank other branch, my lords, issues a mail, which is at, my lords, 340 of the same synopsis, my lords.
Page number
340, my lords. My lords may kindly see the bill number, my lords, the tabular column.
Yes.
My lords, the bill number in the left, my lords, the second tabular column, 3710034, the same bill number. Not the right corner, my lords, the BRC, the third column. It says CNRB 001069 so and so so and so, dated 2020-12-2023. And my lords, in the third, it mentions the bill number, which says it is clear. Lords, in the bills which were clear, they classify my account as NPA. I give many representation seeking for the reason for NPA. They don't provide me any reason. They start proceeding with the CFIC. They issue 13-2. We ask for restructure. They don't provide restructure. They issue 13-4. There be series of errors committed in 13-4 as well. Possession, I mean the property.
13-2, you ask them that there is no reason for the bank to declare your account as NPA.
But we sought for restructure, my lords.
How can you? When you say
Please,
that the classification itself is bad, you should have asked them.
Lords, we learned about this only after they replied to the banking ombudsman. Until then, we didn't know on this bill they have crystallized my account. Because the bills will be certified by me and then sent to the customer. After customer assents it,
On the 13-2, you have not raised this ground at all.
Please, my lords. I was not aware about this. I came to know only in 2024 after they reply. That is when I filed this petition, my lord, before my lordships. This particular bill shows that these bills are clear. And the one more ground they raise is, my lord, there was no sanction.
Where is that letter issued by the ombudsman?
Sorry, Lords. Lords, we are the customers of this bank from 2013. By pledging about 14-15 properties, we have been borrowing. The same 15 properties are there from 2013. No new properties are mortgaged for the present loan transaction. We are entrepreneurs who are servicing certain export contracts. Basically, implementation of certain infrastructure projects abroad. Lords, this particular finances are covered under a specific scheme of the RBI, PCFC scheme. Now, under this scheme, we have been borrowing money and we have been repaying. Borrowing takes place, Lords, usually what happens, these are all the loans which are given in the foreign currency, maybe US dollars, it may be euros or whatever. Now the repayment also takes place in terms of the foreign currency, because it would not be difficult. The conversion rates may vary on a day-to-day basis. So whatever is the foreign currency in which the financing is given, foreign currency is how the transaction takes place is the financing is given either for purchase of the raw materials or for extending the services for which the contract between the Indian supplier, that is the borrower, and the overseas person who is taking our services, we will have a contract where we would be giving a staggered payment or one-shot payment. It is dependent on the contract. These are called as the export bills. All these bills will be submitted to the bank. As and how we reach the milestone, they concur, I concur to the bank saying that yes, you are entitled to present this export bill and they can take this money. Now this money, whatever they would have given, let us assume, Lords, that they give us 1,000 crores. 1,000 crores will remain as 1,000 crores because interest will be serviced by me. Interest is not dependent on the export bills. Only the repayment of the principal amount is dependent on the export bills. Interest I will have to keep servicing. This is essentially the terms with which we borrow the money. I have done a transaction in about 7 years, about 650 to 700 crores. I have produced the document to show 700 crores. I have done the transaction. I have cleared all the debts. I have executed the projects. This is only to indicate a female entrepreneur is not some fly-by-night operator. We have been in the business. We have done the business. We have done this business with the same bank. We have also prospered. Bank has also prospered. It's one of the projects for installation of a crane services, it's overseas, was spilling into an area where the COVID intervened. Lots export bills were there. Contract was already entered into. How the export takes place is whatever raw materials are collected. I don't say it's actually raw materials, but the materials which is required to be exported for the purpose of delivering the services will be in a custom bound warehouse of the custom bound area in a port. It will be in the port. This will be a port to port transaction. So everything is in the port. The report is given and the export bills are generated. Export bills are deposited with the bank. COVID intervenes. When the COVID intervened, it was in China, so there was a longer duration. They said there is a requirement of some enhanced services other than the services which was originally agreed. We brought it to their notice. This is what is required to be done. So what they did, they extended the date or the project date. Usually it will be given for a project date. There will be 2 dates which will be given. The date on which the facility will expire, date on which the project is to be completed. Date on which the facility will expire is to facilitate the finance will remain as it is. Project completion is to enable because this one account is the account through which the export bills will be deposited and foreign currency will be generated. Now, this process was undertaken. They extended this period to July 2021 and project completion date up to September 2021. No doubt about this. There is no difficulty. We have produced a document. It's not a disputed document. In May 2021, when the project is still there, they said your account is declared as an NPA. We don't know what reason. To treat an account, PCFC account as an NPA, the export bills, upon saying that yes, this because we'll be servicing the interest up to July 2021, I am entitled to service the interest. If by July 2021, if I have not serviced the interest and I lapsed by another 3 months, then it will be treated as an account as NPA, so far as the non-payment of the interest is concerned. But the other contingency is where the export bills we concur and say that yes, you are entitled to encash this. If the export bill cannot be encashed, then there is something called as crystallizing of the export bill. What is crystallizing is whatever is the due under that export bill will be converted in terms of the Indian rupees as on that date. So that will be notified to us from that day, 90 days. If I don't pay the money, my account will be NPA. I don't come under the first category. I have serviced the interests. Now they say, no, your account is treated as NPA. We have absolutely no clue what has happened. Then we started communicating with them. You please extend the time at least up to October. We have already committed to complete the project by October. 1 month extension. That's project extension is by 3 months we are asking. We'll complete it and then make good the entire payment. Please accept this. They never acceded to any of our requests. We were kept completely in dark. We are having a transaction minutes from the past over 7 years, 8 years by the time when we have entered into this transaction. So it is happening on a regular basis. It's just happening as though it's a routine basis for us. Then when nothing happened, they are not extending the time. They sent one mail to us saying that we are requesting you, that is in the month of August 2021. They say that you give us the consent letters for the export bills with a retrospective date, antedated. That is when we start suspecting, why are they asking for this antedated? We said we cannot give it. Antedated, how can we give the antedated consent? Export bills, the presentation is dependent on the consent by both the parties. Then they can export. Till then I'll have to service it. The outer limit is the period for which the finance is extended. Now after this mail is sent, we send to them, we go before the banking ombudsman. We are not aware what has happened. For the first time before the banking ombudsman, they say that your project was valid only up to 2020, not July 2021, but only up to 2020. Therefore, this is what we have done. We have treated this account as NPA, is what they said. I will just take your lordships to that particular statement. We said then, no, this, because by that time they had given these copies. We pointed out to them that my project is valid up to July 2021. And then they say, second reason, no. The export bill for 9/8, what is the date? No, export bill dated 23/20/21.
Where is that first communication?
Not sir, if your losses were to take page number 369 of the synopsis.
300.
369. 31/1/22, not 20. Notes, I was mentioning 21 minutes. Your losses may permit to correct it as 22. That's 31/7/2022. I stand corrected. Page number 369 of my.
It's here. Yes, 369.
Where is this letter? The extension letter. I just read this and take your losses to the other letter.
Yes.
Notes, if your losses were to see, this is by the bank to the banking ombudsman. Representation given by the director of so and so, Srimati so and so. Gist of the complaint is the customer complained that our bank has crystallized the export bills pertaining to the subject company on 24/5/22 and also deducted export bill collection charges on 21/2/22, whereas the borrower had not requested for export bill collection. Not export bill collection is on the request. As I submitted, there is a concurrence. We furnish below our reply. Listed below are details of PCFC ST. Not PCFC is a particular, ST is single transaction. That means if I am exporting to multiple people, I don't come under ST. If it is one single transaction, one single servicing, it is called as ST, because ST itself is a very distinct transaction. I will take your losses to the RBI guidelines. Listed below are the PCFC ST permitted bid a last sanction refer number so and so dated 14/12/2021 and other sanctions dated 29/11/21 and 30/10/21 for an amount of USD 1,18,05,780 to execute the works order of BMB Limited New Zealand. The PC period permitted was 270 days and tenability of the PCFC ST was for a period of 1 year. Further, Vide sanction letter number so and so were extended up to 31/1/22 as per the terms of sanction Vide above mentioned sanction letter duly acknowledged by the borrower. So they are referring that this is extended only up to 31/1/2022. Next page. Notice they make a reference to all the bills here. 2020, 2021, if your losses were to see. All the above bills were crystallized on 24/5/2022. Crystallization of a bills will be only in the event of the export bills being requested to be submitted. The moment they extend the term, then the term for the payment of the bills gets extended, because until and unless I complete the project, I'll not get the money. That's something which the bank definitely knows. RBI guidelines and the internal policies for crystallization of the bank are as follows. Purpose of crystallization is to transfer the exchange risk involved in the belated receipt of the export bill payment to the exporter. Accordingly, where the proceeds of the export bill is not realized within 15 days from the expiry of the normal transit period in case of unpaid demand bills, and within 15 days from the expiry of the notional due date or actual due date, as the case may be, in case of unpaid usance bills, foreign currency element of the transaction is dealing and the customer's liability is crystallized in Indian rupees. Delinking is done in TT selling rate of foreign currency ruling on the date of delinking. In the case of usance bills, wherever the actual due date is advised by the foreign correspondent, ostensible date for delinking shall be revised accordingly. In other words, the branches should dealing such usance bills if remains unpaid on 15th day after the expiry of the actual due date, irrespective of whether such due date falls beyond or within the ostensible date of delinking arrived at by the branch at the time of purchase, discount or negotiation. The delinking procedure is introduced with the sole objective of minimizing probable loss to the bank due to prolonged non-payment of the purchased export bills. In the current instance, whatever they have said is okay. In the current instance, PCFC ST crystallized on 24/5/22 after a period of more than 1 year. That is taking into account that it was extended on up to 31/1/2022 by an order dated 14/12/2021. We have extended it by this. The charges deducted, this is again very important. The charges deducted are for the export bill collection dated 23/2022 for invoice number so and so Forum number 3710034 dated 9/8/2021 as per the request letter submitted by the borrower. Now, there is a request letter which we have submitted, on the basis of which the only bill which is crystallized is 9/8/2021. Two facts which emerges from this. One, my facility has already expired as on 31/1/2022, and the export bill which they say is crystallized is dated 9/8/2021. I will address these two issues immediately and then go to the next issue. Lordships may kindly have a look at page 301.
Yes.
We are pleased to inform you, Lords, this is dated 1/1/2022.
Yes.
We are pleased to inform you that the competent authority has permitted the further extension of the PCFC ST USD so and so with rollover permitted against the project specific work order for a period of period till 31/7/22 as under. Further, the limit shall be reviewed on or before 36/22 subject to compliance of the terms and conditions stipulated hereunder as well as in annexure hereto. Then nature is PCFC ST, amount is mentioned, then purpose is mentioned. Lordships may kindly see the period. Margin is 10%, period is 270 days, then tenability extended till 31/7/2022. However, the limit shall be reviewed on or before 36/2022. So up to 36/2022, this is valid. This is an account which cannot be treated as NPA on this ground. That my account is not valid, it's not the ground on which it can be treated. Now next, if your lordships were to see the date which is granted for the purpose of implementing the project is at page number 307. Clause 11, conditions. Bottom of the page. Borrower to ensure project is completed and ensure the closure of the project specific limit by September 2022.
You get that?
Well, it's bottom of the page at page 307. Clause 7 of the conditions.
Clause 7.
Clause 11. Clause 3 is conditions. In that clause 11. Page 307.
Yes. Yes.
Now, the first reason which they had given before the banking ombudsman as to why my account is treated as an NPA is not correct. They actually made a misrepresentation before the banking ombudsman. Notes, this is where I wanted to submit this. Probably after treating my account as NPA and bungling this up, later they realized in the month of August that my account could not have been treated as NPA. Then they shot out a letter to me. I will take your lordships to that letter. But the first and foremost question is, regarding this validity of that period, I have brought it to your lordships notice. The period was still there. I was servicing. It is not their allegation that I had not serviced the interest as on 21/5/2022. The date on which they say that we have crystallized this bill, 24/5/2022, as on the date.
When is the date it is declared as?
24/5, my lords.
24/5.
5 is the date on which they say we have crystallized the bills.
24/5/2021.
2022.
2020.
Now, so first part is not correct. I'll be in a position to demonstrate further as to why it is not correct, but I'll take your lordships immediately to the other letter. But so far as this page number 340, your lordships may kindly see, we are speaking about this export bill dated 9/8/2021.
Yes.
Not 340
Yes.
is a mail from Canara Bank. Notice your lordships will see, kindly juxtapose this with the page number 371. I'm just referring to the export bill number 3710034. 3710034.
Yes. Yes.
Now this is the second column, my lords.
Yes. Yes.
Whatever they are referring to on the right side, right hand side, is the clearance of these bills. The CRNB is the transaction number 1, 2, and 3. So transaction numbers indicates that this bill in fact has been realized.
On 23/12/2020. What is
Let's,
it?
we do not, because this is on 5/1/2025. We don't know when they have realized it. This is money which they have actually realized as per the mail which has been sent to us. The amount is mentioned in the first column.
Yes, that I've seen.
1110430 That amount is there. They have realized this. So second,
BRC means?
which one, Milos?
BRC, like you have 3 columns. Number,
BRC.
remarks, BRC.
That I'll have to ascertain. Milos. BRC.
What does it mean, Mr.
Bank reconciliation. Bank reconciliation.
Bank reconciliation?
So now, so far as this 9/8/2021 bill is concerned, the money has actually been credited into the accounts. Next page is very important. The rest of the bills is not lodged. Unless they lodge the bills, the treating any of the bills as having been bounced or not negotiated for the purpose of crystallization is not permissible. The bill which they have lodged is a bill which is even according to the records is already recovered by them at whatever rate which they have done it. These are the 2 reasons which they gave us. We brought this to their notice. There are several email correspondences which we have given. I have spelled out everything, Lords, in my synopsis. I'll read everything to your Lordships. Then they realized there is something which is amiss. Bank has not done anything in a right way. It may be a mistake. Bank might have committed a mistake because probably they would have taken into account that the project was financing was valid up to 31/1/2022, and they would have done it probably. Now, in order to circumvent this, what they should do, they could have easily rectified all these things, permitted me the time, and my properties are there from 2013 with them. I have never taken the properties back. They say we are appointing a forensic audit for this purpose. When is forensic audit appointed? Is there any bungling of funds by me? Forensic audit, is the difference between the audit and forensic audit is on the basis of the available records, the clarifications or the tally will be made. Forensic audit is a manner in which there will be third parties through whom the confirmation is obtained. If there is a transaction shown 100 rupees is paid to X, they can get this confirmation from X 100 rupees is received. This becomes a forensic audit. But for what purpose forensic audit? These are the facts. Why forensic audit? They wanted to find out several things pertaining to my account. I had never defaulted. If not for the COVID, I would have implemented the project. They would have pocketed their interest. I would have pocketed my business profit. They bungled up this entire issue. Then forensic audit, somebody writes a letter to me. I request that auditor, please send me the letter of authorization so that I can share all these details with you. He sends this letter to the bank saying that this is what is being sought for by the borrower. Please give clarification. They don't give any further clarification. The forensic audit is submitted. I'll take your Lordships to each one of the statements in the forensic audit. I will show my Lords as to what is that which has been done to this borrower. Then in the forensic audit, they say that the property documents pertaining to two of the properties, which we have deposited before the bank, is a color photocopy and not the original records.
No. What did they do with this, with the complaint of the petitioner about how the
Ombudsman,
bank is, how the account is declared as an?
Lords, Ombudsman has closed this account, closed this complaint, saying that this is the explanation offered. We said we don't know why they have done. They have given the explanation why they have done. Banking Ombudsman closed the matter. Then we started. Then what we started, my Lord says, because by then they started issuing 13-2 notices, 13-4 notice, possession notice. Then we started running helter-skelter because we did not have any documents in our hands. How your people are dealing with our accounts? In the forensic audit, whatever they got this done without our concurrence, because we said that you give a letter of authorization so that, because somebody cannot ask me saying that you give me all the details. I said, you give me the letter of authorization or let the bank indicate that you are authorized. The bank has to communicate to me wherever it's a forensic audit. I will share everything with you. They say, no, this is what has happened. And two, the stock which is lying in the stockyard of the port in the custom bound area, the value of that is also diminished. If I buy a computer minutes today and after 2 years, my computer will not be of any value. That's how every material counts. Technology as and how it is growing, it happens. There may be a diminishing, there may not be, but the face value or the book value will remain the same. The bank is concerned with the book value because this is not something which is going to be utilized or by them. This is going to be utilized elsewhere, as a result of which I generate business and then pay the money to the bank. But once this was done, they say no. Now we have realized that the reason for treating your account as NPA is because RBI guidelines says that if there is a diminishing in the value of the secured assets, you can treat it as an NPA. Third reason.
Where is that?
Lots of
Page number?
forensic audit, your lordship. The statement of, because I'm not given the forensic audit, but after they have given, I have filed the statement of objections. Lordship may kindly take the statement of objections, the forensic audit.
Dated?
I'll just point out. This one. This is our objections. Where is the forensic audit? Yeah, copy. No, just point out. My apologies.
That's with the synopsis or objection?
No, this is along with the. Just take the statement of objections. We have marked it as statement of objections. Yeah, all right. Master Circular, page number 85 of the statement of objections filed by them.
Where is the statement of objection?
Filed by the respondent on 39/20/24.
Yes, 39.
Yes. Notes in this page number 85 it starts. RK Doshi and LLP, page number so and so, page 86. In that, your lordship may kindly come to the index at page 87. Hmm. 6.1 and 6.4. I will answer each one of them. I will take your lordships to me, lords, and refer to this. 6.1. Dwell. We had marked it. Inspection report. 5. Collaborated method idalla. I'll just point out once. Yesterday we had marked it. Next 7, page 25, 13, page number 12, page number 98. The last paragraph, I'll mark at page 99. Based on inspection report attached at Annexure 1, branches sought legal opinion from the panel advocate R. Rajashri on the subject matter and confirmed the same. From the above, it is understood that the borrower company, guarantors and their directors has manipulated the bank by submitting fake title deeds for the properties mortgaged.
No, this has a reference to any dates.
There is no reference to any dates, but if your lordships were to see whatever documents which is submitted there, these are the documents held by them from 2013. There are 15 loan transactions which I have entered into. On the basis of these very documents, I have not taken it back from 2013. All right. If there is a manipulation of the bank accounts, I have an answer for this also. they brought all these properties within the purview of section 13 for proceedings. If this is a manipulation, if this property does not belong to me, why would they include these properties? How there is a diminishing of the value?
No, how is it further explained?
Not, this is not explained any further. They only say that whatever we have given is fake. That is the color photocopies. Properties are with them. I don't have the original documents. The property documents are with them. They bring all these properties to sale. They take section 14 orders. They bring these properties to sale.
When you have given your reply for the 13-2 notice.
Yes.
In their reply, did they say anything?
We were
about
not
this?
aware of anything at the stage of giving a reply to 13-2. We were taken under shock.
Did they say anything in that notice under 13?
No, 13-2 notice says that your account is treated as NPA. Lots, I'll point it out to section 13-2 notice.
When this forensic audit started?
No, it's forensic audit. There is a date notes on which it is given. 15th December 2007. I'm sorry, that is the period. 9/8/2023, after 1 year.
9/8?
2023.
So this must not be the reason for declaring your.
At that time, definitely not.
So now
Now they have made this statement in their statement of objections that this is one of the reasons.
We don't have to look at this because as on the date when the account was declared as NPA, what was the reason? That has to be
These are the two reasons.
One is like you have shown the bill. That is one.
Yes. One is the recovery of the bill. The other one is they say that my facility is expired as on 31/1/2022. Therefore, we have declared your account as NPA. It is valid up to 21/7/2022. And my project completion date is end of September 2022.
I think without further going into the other things, let's have a clarification on this aspect.
Very well, my lords.
Yes.
That's my apologies, my lords. There's one matter which is going on. Because this matter reached, I had to rush here. Yes. My apologies, my lords.
Yes.
Lord, I want your lordship to kindly see what is the ground on which the writ petition has been filed. All that has been argued is on the basis of a synopsis. It is not the contention in the writ petition. Please see the writ petition, my lord, so that your lordship will kindly see what is the controversy before this court. And before I proceed further to take your lordships through the contents of the writ petition and the contention advance, I want your lordships to kindly
No,
see
before going into that,
Yes.
that, you have declared their account as NPA.
Quite, and I have admitted it.
What is that?
No,
That's
they
the
have filed
bank
a
thing.
petition under section 10 before the NCLT. They have filed a petition under section 10 of the IBC. Kindly see section 10 of the IBC. It is not a petition filed by a creditor. It is filed by the financial debtor, corporate debtor. And I showed your lordship what they have said in that. Initiation of corporate, I'm reading section 10 of the IBC, my lord.
Yes.
Initiation of corporate insolvency resolution process by corporate applicant. Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiating corporate insolvency process with the adjudicating authority. Adjudicating authority, the NCLT. The application under subsection 1 shall be filed in such form containing such particulars in such manner and accompanied with such fee as may be prescribed. The corporate application shall, along with the application, furnish the information relating to books of accounts and such other documents for such period as may be specified. The information relating to the resolution professional proposed to be appointed as an interim resolution professional, and C, the special resolution passed by the shareholders of the corporate debtor or the resolution passed by at least 3/4 of the total number of partners of the corporate debtor, as the case may be, approving the filing of the application. The adjudicating authority shall, within a period of 14
When
days,
was this application
etc.
filed?
My lord.
Section 10 application, when was it?
Yes, my lord. Section 10, kindly see our synopsis, my lord. The
Date, please give the date, that's sufficient.
Your lordship, kindly take our synopsis that we have filed. We have produced a copy of the section 10. It is filed on 18/9/2025.
18/9/2020.
Yes, my lord. Your lordship be kind enough to turn, my lord, to page number.
No, the moratorium is in place.
No, my lord. They have filed it. And then, my lord, after having realizing that they have already approached this court and all that, they allow that to be dismissed for default. And I want to show to your lordship the admission in that petition. Today, all that has been argued before your lordships and your lordships' valuable time has been taken on this. Not one whisper in the petition before your lordships. And all that has been argued are subject matter of 3 proceedings before the DRT. I showed you all lordships. Kindly turn to page 8. This is a very vital suppression, my lord, that has been done before your lordships.
Yes.
And this is filed in 2023. I ask myself, when they have filed a voluminous 350 pages of written submissions, should they not have produced this document before your lordship? Now, my lord, please be kind enough to turn to page 8. It is filed, my lord, by the petitioner.
No, I think this is filed in the year 2023.
2023, that's what I'm saying.
No, I thought it's 2025.
No, no, 2023. No, no, my point I'm making is that
Order
when
is
the-
on 22/3/2024.
Now, my lord, please be kind enough to turn, my lord, to see who is the party who has filed it. It is filed by the petitioner, saying, I am a corporate debtor. Why am I a corporate debtor? Please be kind enough to turn, my lord, to page 21, part 3.
Yes.
Kindly see part 3, particulars of financial / operational debt creditor wise as applicable. This is like a debtor asking for insolvency. Your lordships, debtor moves for insolvency, similar provision. Where a corporate debtor moves saying, please declare me, put me under CIRP. Now, my lord, please see serial number 3. Total debt raised and amount in default.
Serial number 3.
Yes, my lord. Name of the financial creditor, Canara Bank. Amount in default. My lord, amount is 82 crores 50 lakhs. Amount in default 99 crores 52 lakhs. And then, my lord, when did it become when will the default occur? Date when the financial operational debt was incurred. Name of the financial creditor, Canara Bank. Date when the debt was incurred, 31st December 2013. Date of default, August 26, 2022. And now, my lord, your lordship may kindly turn to page number 23.
Yes.
A letter dated 22/11/2022, addressed by the petitioner to the bank. The company directors, guarantors have mortgaged the properties for the facilities availed by so and so from your esteemed bank since the account has slipped into NPA. We intend to dispose of all the properties within the present financial year. Hence, we request you to issue NOC for the proceeding to the sale of the properties in order to close the loan account with your esteemed bank. But I ask myself, where is all this what was argued before your lordships even whispered? And if that is so, why did they file a section 10 proceeding before the NCLT? The first thing they should have was, sorry, there is no NPA. We are not in default at all. Same amount, 85 lakhs, 85 crores, I'm sorry, which has now become 99 crores.
Yes.
And now, my lord, I want your lordship to kindly see what has been contended.
No, you're saying about some.
Please see the petition.
No, no, you were referring to some DRT proceedings.
My lord, yes. Kindly see, my lord, the synopsis itself. I'm grateful to your lordship for pointing it out. Please be kind enough to turn to page number 6 of our synopsis. The petitioner challenged the SURFACE proceedings via the following cases pending before DRT. TSA number 5 of 2020 after filing of this writ petition against the order under section 14 of the SURFACE Act. SA number 21 of 2024 challenges a sale notice dated 31/11/2024, where property was sold and sale certificates issued. SA number 7 of 2025, challenging sale notice dated 5/2/2025. It is submitted that the respondent bank was compelled to invoke possession and sale under SURFACE provisions due to petitioner's admitted default and misconduct. It is humbly submitted that approaching the High Court after exhausting remedies under SURFACE and DRT is an abuse of process of
When
law.
is this
and
writ petition filed?
When
When is this writ petition filed?
a writ petition was filed in the year 2024, and I'll give you a certificate.
Yes.
My lord, can I see your lordship record and give your lordship the date? I'm sorry, I might the date.
What is it?
I will see your lordship's record and give your lordship the date. I'm very sorry, my lord.
No, that I can see from this, when the writ petition.
I
Yes.
don't, in my copy, unfortunately.
Yes,
it is.
yes.
But I know, my lord, it is filed in the year 2024. And these are proceedings initiated in
That's on
2025.
39/2024.
Yes, 39.
30th May.
30th August. My lord, I am given to understand, my lord, it is 30th of August 2024. And
It's not statement of
13. And this essay number, my lord, 21 of 2024 was challenging the sale notice.
It's
That is
38,
11/2024 afterwards.
Hmm.
Now, my lord, what is the prayer in the writ petition? My lord, all this that has been argued about, my lord, it sounds, I learned a lot, my lord, as to how crystallization takes place with respect to foreign, a loan in a foreign currency with respect to a project outside the country. My lord, all that is my erudition of my learned friend, my lord, I am begging. But what is the ground in the writ petition now? Please see the writ petition, my lord, if your lordships are kind enough. May I trouble your lordships to kindly turn to the grounds. Only contention raised is with respect to this bill number. Please see the facts at para 2 of the writ petition.
Now, when you challenge the several proceedings are pending before the DRT, why can't all these, whatever the contentions that are raised before this court, why it can't be decided by the DRT?
My lord, the only reason is, my lords, this involves URC 522 code, my lords, which DRT cannot ascertain. It is that guidelines, my lords, issues a proper guidelines how the bill can be realized.
Why it can't?
My lord, the DRT tribunal is restricted with respect to surface, my lords.
Not at all.
I will be sorry to
Respect to that serial canvases arguments.
That is not.
In
that
fact,
is not.
Supreme Court has said.
That is the DRT is a body which is constituted to deal with more than this court. They'll be able to understand the banking laws and the banking, that all the transactions better. Because they are the specified tribunals constituted for this purpose.
Please understand. my lords.
Whatever is a senior counsel contending before this court, it would be appreciated better by the DRT. That too in the light of the fact that several other proceedings are pending. And why didn't the senior counsel address about your section 10
My lords, in fact,
application for the
section 10 was withdrawn on 23 Jan
No, it's
2024 itself.
default, not withdrawn.
Please, my lords, it was dismissed for default on
But you have filed it.
Please,
That
my
has
lords,
to be-
on that date, I was not aware about this fraud played with the bank. I realized only later.
Please let senior counsel come and say, I'll not entertain these writ petitions. Whatever is your relief, go before the DRT.
Lord, may kindly pass over, my lord. Let the
Now,
senior
I just
counsel
want to
address
show
this
your
argument.
lordship the judgment of the Supreme Court saying exactly what my lord is saying. Please see, my lord, 2020 volume 4 SCC 440. Judgment, my lord, in Virupaksha and another versus state of Karnataka and another. You can why take the time of court?
Take the copy.
Lords, may kindly pass over the matter, my lords. Senior counsel will address arguments on the maintainability
No.
itself, my lords.
Let him complete his argument. No,
Please.
I have already made up my mind. It's a matter of.
My lords, in fact, my lords, the
Give
earlier
it
bench, my lords,
feedback.
erred on the
That's what I'll
maintainability,
hear
my
him.
lords.
I'll hear him. So now nothing much to, let me look at this judgment and then I'll pass over. Let senior counsel come at 2:30.
Please.
But I'm indicating that I'm not going to entertain this. Yes.
But please see para 15, my lord, of the judgment. Directly covers the issue. And exactly what fell from my lord is what Honorable Supreme Court is saying too. The para 15, my lord, if I may trouble your lordship.
Yes.
The Surface Act is a complete code in itself. which provides a procedure to be followed by the secured creditor and also the remedy to the aggrieved parties, including the borrower, in circumstances as already taken note of by the High Court in writ proceedings. If there is any discrepancy in the manner of classifying the account to the appellant as an NPA, exactly what was contended, that you could not have classified my account as NPA, or in the manner in which the property was valued or was auctioned, DRT is vested with the power to set aside such auction at the stage after the secured creditor invokes the power under section 13 of SARFAESI Act. This view is fortified by the decision of this court in IOB versus Ashok Sawmill, wherein it is held as under. Then, my lord, all that is quoted, and please be kind enough to turn to para 16. We reiterate that the action taken by the banks under the SARFAESI Act is neither unquestionable nor treated as sacrosanct under all circumstances. But if there is discrepancy in the manner the bank has proceeded, it will always be open to assail it in the forum provided. And now, my lord, in this context, just see the prayer in the writ petition.
Yes,
All
yes,
that
yes.
is.
I've seen that. This pass over.
Well, the other two writ petitions were connected to the main petition. The only thing is, well, I suppose to give some documents as per the directions made by this honorable court, which you have complied. That writ petition also can.
Well, may I make submission with respect to
What are those two writ petitions?
Well, there are two writ petitions.
17 is what?
There are two writ petitions. Earlier on litigation, the came before this honorable court, sought some direction against me, to give the documents to them. In fact, I am not able to do it in time because documents are voluminous. And we filed an application for extension. In the meantime, there is no stay operating before this honorable court. I issued the action letter, SARFAESI Act, and put the property for auction. The petitioner filed two writ petition before this honorable court, stating that I have not handed over the documents as per the order made by this honorable court, and she sought stay. And this honorable court considered and passed an interim order not to sell the property. But subsequent to that, I complied. I placed all the documents to them, and I filed the entire documents before this honorable court also. And memo also.
Anyhow, when everything is going before the DRT, then let it be decided
Please,
there. Pass over.
Serial number 18. Praveen Kumar, Nirvani for petitioner, 14 JM.
No representation after vacation. Yes, 19.
Serial number 19.
Lord, last occasion, your lordship has directed me to make a representation, my lord. My lord, I filed a representation, my lord. They have to consider it.
It is the bank.
I made a representation 15/12, my lord.
The petition shall give a proposal to the respondent bank, and the respondent bank will come up with their response. If the proposal is not given by the next date of hearing, the stay granted by this court will stand vacated.
They are given a proposal, my lords, which is not acceptable. As against the dues of 60 lakhs, they are telling they'll pay only 45 lakhs. Sorry, 30 lakhs. 30 lakhs is the proposal. Let them go before DRT, my lords. All the contention.
My lord, they have, my lord, only the outstanding is only the for 36 lakhs is the only the principal, my lord. The interest rate said that according to the 42 lakhs. My lord, loan is 45 lakhs, my lord. They are already discharged at 65 lakhs, 1 minute.
No, please understand one thing. Whatever it is, whatever that is applicable, what are the RBI guidelines, what is acceptable to the bank, that's how they will do the OTS, they will accept the OTS. Court cannot say we can't discuss about it, about what is the principal, what is the interest, at what amount they should accept for the OTS and all. Only issue is whether the OTS is acceptable to them or not. They say it is not acceptable. If it is not acceptable, you have the.
I made a representation, board has to take a decision, one more. That secondly, my lord, they have already discharged 65 lakhs. The borrower is not there, he's died, she died, and the guarantee is also died, my lord. They are nowhere, the legal heirs, he is voluntary go, and they take a coursive steps now.
If you tell the court, can the court tell them what to do?
That's what the validity of that notice, my lord, we have challenged before this court.
But that we cannot. You have to go before the DRT.
Yes, my lord, reserving liberty, my lord,
yes.
Protection has to be continued.
Yes. On the last, this writ petition is filed saying the following prayer. When the matter came on 4/11/2025, this court had directed the bank not to take any coercive steps. Recording the contention of the land, counsel for the petitioner that a notice was issued on 13/2/2025 and 16/4/2025. And Section 13B of the Surface Act, reply was given on 25/2025. For that, a bank replied on 16/7/2025. The counsel for the respondent bank submits that no acknowledgement is filed and they have not received the same.
We have produced but later subsequently I produce the acknowledgement.
Then counsel for the petitioner submitted that he has an acknowledgement and he'll file the same before this court. And this court has directed the matter to be listed on 24/11/2025 till such time not to take any coercive steps. On 9/12/2025, when this matter came up, this court has passed an order that the petitioner shall give a proposal to the respondent bank and the respondent bank shall come up with their response. If the proposal is not given by the next date of hearing, the stay granted by this court shall stand vacated. When counsel for the petitioner submits that they have given the proposal to the bank, then counsel appearing for the bank submits that is not acceptable to the bank. Then counsel for this petitioner further submits that what is the amount that is taken, what is paid, and what is the proposal. This court is not inclined to go into all those issues because this court cannot compel the bank to accept for an OTS. Now the writ petition that is filed is seeking to quash the demand notice dated 13/2 of the Surface Act. This court do not find any reasons to quash the notice under section 13/2. If the petition is aggrieved by any of the action that is taken, where the bank is at liberty to approach the debt recovery tribunal. For a period of 4 weeks, from today, the petitioner shall not, the respondent bank shall not take any coercive steps. Yes, 20.
Bill number 20. DVM record.
But I may be permitted to comply with the objections in the course of the day. Typed copy is ready.
Yes, what is the matter about?
It's about the possession notice issued by the respondent bank. The typed copy is ready.
No, you can argue.
Yes,
Forget about the.
but the NPA is due to not because the whole home loan. It is because there's because of the credit card as well as the personal loan. It is not because the petitioner could not pay the loans because her daughter is undergoing a complicated surgery. The time was not rendered and notice was issued. That's the reason we are before this honorable court being aggrieved.
Outstanding is 70 lakhs 27,784 as on date.
My lord, the NPA is only because of the credit card as well as the.
How much is that amount to regularize?
1 lakh something. The credit card amount and the personal loan.
My lords, there are 3 loans in this, my lords. One is home loan, one is personal loan, and one is credit card.
No, to regularize the account.
Regularize the
How
account.
much it has to be paid?
Regular is 25, my lords.
25 lakhs.
And 25 lakhs, my lords.
My lord, we need some time because of the complicated surgery the daughter of the petitioner is undergoing. She's undergoing, I don't know whether I should disclose it or not. She's undergoing gender change, this thing, 15-year-old daughter. It's very complicated surgery. She's not finding time to come. She's hospitalized in Nagpur hospital. She's not finding to come down to Bangalore and settle the matter. We need some time. Until then, try to stay may be granted. And it is not that we are not here to settle the issues. The property value is more.
Liberty may be given for them to approach the DRT.
We'll do one thing.
Well, I
Whatever
can-
time that has to be given before this court, I'll say bank should not take any steps till 4 weeks.
Again, going before the DRT is again because Lord, I don't know what will happen to the surgery.
Either
Lord,
this court, no, with all the grounds that you're raising, court can't pass any order in this. And there is no purpose keeping this writ petition pending here. We'll say, like, if not 4, I'll grant you 6 weeks, but
Well, again, the surgery 6 weeks, I don't know, because it's a very highly complicated surgery.
that can't be a reason for this court.
Well,
Whatever you can do.
Well, Lord, we are ready to come out with the settlement of the credit card as well as the home loan.
That's 25 lakhs, you're saying.
It's not 25 lakhs. That's still, credit card is not 25 lakhs.
No, there are 3.
Once the credit card loan is cleared, we'll come out of the NPA.
Once account has been NPA, my lords, all 3 accounts will be posted as NPA, my lords.
Still to, but still we stand the chance of clearing the credit card and coming out of the NPA.
That you can do it. But that kind of orders I can't pass. Please come. The present petition is filed in the following prayer. Petition has questioned the 13.2, the notice issued under 13.2. And also the position notice under section 13.4. 13.4 of the Surface Act. It is submitted that the petitioner's daughter is undergoing a critical surgery. And as the petitioner could not come, is not in a position to approach the bank and settle the disputes, hence some reasonable time may be granted by this court. May be granted by this court. When counsel appearing for the bank submits that the loan amount is
70 lakhs 27,784.
Total and to regularize the account, the amount that is supposed to be filed paid is 25 lakhs and all. The petitioner, if he is agreed with the order passed under section that, hence the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy for a period of 6 weeks from today. The respondent bank shall not take any coercive steps. Yes, next.
Still number 21.
Last occasion, my lords, your lordships are ordered to serve the copy of the writ petition on the counsel appearing for the respondent before the trial court.
Who is the counsel?
One Mr. Abhilash J, my lords. I have also stated in my memo stating that the name of the counsel will be shown in the cause title for having served the copy on the writ petition, my lords.
What is the urgency now? Can it be posted after vacation?
Now, your lordship itself has given directions in their matter. Within 6 months, the matter has to be concluded, my lords. Even my simple prayer before the honorable court is that, my lord, even my application has been rejected in the same lines, my lords.
Then we do one thing, we'll print the name of that advocate. What is the name?
Abhilash J.
Tomorrow it will come.
Please, my lords.
Tomorrow
Abhilash J, my lords.
It is submitted that as per the order passed by this court, the petitioner has taken out hand summons on the counsel appearing for the respondent and filed a memo to that effect. Memo is taken on record and registry is actually print the name of so and so. Look at it. Yes, next to
Obliged, my lords.
tomorrow.
Please.
22.
Still number 22. Still number 22.
Appearing for the petitioner, my lord.
Kaushik.
So far as the matter is pertaining to one consumer dispute, my lords. That matter, bank has to make submission. It was on their part.
That happened, my lord. Sale, my lord, SL before this honorable court. Sale notice, my lord, SL before this honorable court. Challenge before this honorable court. In the context of, my lord, they filed, my lord, the consumer for application before the consumer forum. It got allowed. Subsequently,
No,
my
I
lord,
think if I remember what is the stage and all, that's why it is adjourned.
my lord, may direct the state commission to, my lord, dispose of the matter. My lord indicated other day. It's pending for consideration.
Till such time not taken.
Within 1 month or 1.5 months, whatever.
We'll
Tomorrow is the auction. It may be stayed, my lord.
What it will be. The writ petition is filed, seeking the following prayer. Extract the prayer. The facts of the case are the petitioner has availed the financial benefits in the PME-GP scheme and started a bag manufacturing and retail business in the year 2021. On 5/8/2021, a fixed deposit is opened by the petitioner in the respondent bank and continues to remain intact and unmatured. The facts are not at all, you have not stated the facts.
Facts are very my lord, this is a voluminous facts is there, my lord.
No.
Series of events have happened.
Basic facts should be there when you're filing a writ petition.
I will file a.
The respondent bank has sanctioned a term loan rupees 15 lakhs for machinery procurement and an ODCC facility of approximately rupees 10 lakhs for working capital. The respondent bank has also sanctioned a home loan facility of rupees 20,50,000 in favor of the petitioner. And the petitioner was allotted a POS machine for business receipts and counter sales.
Allegedly, there was chargeback of rupees 6 lakh.
The bank, without any notice or what is this petition?
7 and
Will
9.
anybody understand this? Where is
Plus-
our state commission's order? Please come to that.
Plus, there is lot of voluminous.
It's not
facts are there, my lord.
voluminous. Whatever voluminous into in one page, you can tell all that.
We'll place it on record. My humble apologies.
Where is the state commission order? We'll get it from there.
Annexure P,
The next year?
P, page number 300. Page number 300.
Let's talk of all those, the petitioner has availed the, petitioner is having an ODCC account with the POS facility with the respondent bank. The complainant, the credit limit for the ODCC account oblique POS facility is 10 lakhs. He used the swiping machine for his day-to-day business activities. And the customers of the complainant, customers of the petitioner also use the swiping machine and credit amount by swiping the machine to the complainant's ODCC account, and such swiped amount would directly credit to the complainant's account. It is a case of the petitioner that the bank, without the complainant's permission or consent or use of swiping machine, had directly debited an amount of rupees 6,36,371.18 and thereby caused an exceeded credit limit of the petitioner's ODCC account. And the credit limit of the said account had exceeded up to rupees 16,96,639. Immediately, the petitioner has stopped this transaction through the swiping machine. When the petitioner came to know about this illegal and fraudulent debits, he informed about the same to the respondent bank and requested them to rectify the same shortly, but they failed to correct the same. He gave a request letter to the bank on 28/2/2023, but the bank had not given any reply. Then on 6/3/2023, the petitioner has issued a legal notice and the same was received on 7/3/2023 by the bank, but they have not given any reply to the petitioner. Thereafter, the bank has initiated the proceedings under the Surface Act. The petitioner has filed a complaint before the UDP District Consumer Disputes Redressal Commission. That is the consumer complaint number 109 of 2023. That came to be allowed by order dated 31/1/2025, whereby the Consumer Forum has directed the bank to recredit 6,36,317.18 to the complainant's account along with 10% interest per annum from the date of the respective debits till realization. Additionally, the bank is directed to pay an amount of rupees 1 lakh as compensation for mental anguish and rupees 10,000 towards the litigation expenses. Against that, the bank has filed, has carried it in appeal before the District Consumer Forum, that is numbered as
State consumer,
Yes. Number
state con-
has carried the same before the State Consumer Forum. It is numbered as so and so.
Wait,
Give give that number. Now, and the State Commission
Granted interim one
has granted an interim order of stay.
against the order passed by the district.
In the meantime, the bank had proceeded with the surface proceedings. Now the petitioner is before this court questioning the notice dated 18/11/2022 issued by the respondent bank. What happened to that notice?
My lord,
Auction sale notice, not conducted.
This one report directed me, my lord, not.
Questioning the auction sale notice dated 18/11/2025.
Tomorrow.
it is tomorrow.
It is prior to the order or subsequent to the order? 18/11/2025. No. As on the day, the auction was not conducted.
No, auction will be conducted tomorrow.
Tomorrow.
My lord is.
No, 18/11/2025 and the date of auction is tomorrow.
Tomorrow, 19.
1912.
19/12.
1912. This one report direct, my lord, not to take the position of the property and which.
Yes, the auction sale notice dated 18/11/2025, whereby the sale is scheduled to be held on 19/12/2025.
Please.
And also to quash the consequential newspaper publication, the symbolic position, and the action of the bank in initiating classifying the petitioner's account as a non-performing asset, and also invoking the surface proceedings. Land counsel appearing for the bank submits that the order of the district consumer forum is stayed by the state consumer forum. The petitioner, if is aggrieved by any of the proceedings initiated by the bank under the Surface Act, he has the alternative remedy to go before
which is already before the DRT. In essay number, my lord, 35 of 2020.
DRT, my lords, they have not considered it. We have already approached DRT. I already paid 5 lakhs. 20% was already paid. But my lord,
questioning what you went to the DRT.
questioning the 13-2 notice.
Why are you coming before this court again?
Lordship, that was disposed a year back. In 2023, that matter was disposed. Subsequently, my lords, I have won the case before the state consumer.
Forget about state commission. You went before the DRT, questioning the surface proceeding. Why this proceeding you should come before this court? Why can't before the DRT?
In fact, DRT, my lord, upheld, my lord, all my measures.
All
13.4 and section 14. That is, my lord, page number 3.
I have already exhausted that remedy, my lord.
It is submitted with the land counsel appearing for the bank that it is not exhausting the remedy. Then you have to go further. Land counsel
My
appearing
lords,
for the
this
bank.
NPA itself by default, they cannot apply
That
straight
can
jacket
be,
formula.
all those
my lord.
measures can be questioned before DRT.
But my lord,
It is submitted that the petition has already availed the alternative remedy before the DRT. Now, after the order passed by the district consumer forum, he has come before this court, which is not available to the petitioner. The petition has to be dismissed on that ground. Next, this court has perused the order that is passed by the district consumer forum, which clearly discusses about how the account has been declared as an NPA. And in fact, considering all the aspects, the court at the consumer forum has in fact directed the bank to pay damages of an amount of rupees 1 lakh to the petitioner. Generally, when there is an effective alternative remedy, this court will not interfere with any of the proceedings that are initiated with the bank under the Surface Act, considering the order that is passed by the district forum, wherein all these issues were discussed in detail. In the facts and circumstances of this case, this court deems it appropriate to pass the following order. The state consumer forum is requested to dispose of the pending. Give the number, Mr. Vignesh.
Please,
I'll pending so and so within a period of 2 months from the date of receipt of the copy of the order, till such time the respondent bank shall not take any coercive steps. Thereafter, if the petitioner is aggrieved by any of the orders, he shall approach the DRT but not this court.
Some finding on my lord, essay filed by them. Some finding on my lord, essay filed by them. The DRT passed an order on my lord, 20, what is that page number, my lord?
No, I recorded it. Yes. Next. Yes.
Serial number 23. Ashok Kumar Shetty.
Petitioner in this matter.
Yes.
Lordship, and then aggrieved by the order dated of the bank, Lordship, which has bank has been forfeited my deposit amount, my Lordship, 25,000.
Forfeiting the deposit amount.
Yes, ma'am.
Yesterday's matter.
Yes, ma'am.
What we can do? It's
Lordship, we are ready to deposit
It's not
the
that
remaining
bad.
balance within 3 days, my Lordship.
Court cannot direct the bank to take your money. When you're not paid the amount, being an auction purchaser, after 6 months you come to the court
Due
and
to
say,
the
I'm
bona
ready to
fide
pay the
reason, my
amount.
Lordship, I was
They have already forfeited your amount.
my Lordship, by the bona fide reason, my Lordship, I was approached another bank to sanction the loan, my Lordship.
No,
They have
that I
rejected my loan.
understand.
Yes.
When was the auction conducted? You come before this court on 4/12. Auction was conducted when?
26th, my Lordship, 6,
In the
26th,
month of, in the month of June.
Yes, ma'am.
We are in December.
Yes, my Lordship. Within 3 days, my Lordship, we are ready to.
Because court can't pass such an order. If court has such power to pass, I would consider that.
In fact, my lord, I also tried to do some research on this. If
Hmm.
any judgment is any with the benefit of petitioner, not even one judgment except addition.
Did you get instructions from
Yes, my lord.
your
Yes,
bank?
I got an instruction. They can't do it. They can't do it. That's difficult. My lord, kindly see one case, this honorable court interpretation, given the benefit to the auction purchase. That is also my lord, set aside by the division bench with heavy votes.
Kindly have it on the first week of January.
This is
my
a
Lordship.
judgment, recent Supreme Court judgment.
Senior is in.
Then I'll adjourn this matter. He'll have his, he'll take his
Time, my lord, I
chance.
understand, my lord, it's hard earned money, but we are
After vacation,
Yes, my Lordship. In the first week of January, my Lordship.
first week of Jan.
Oblige me.
Serial number 24.
Yes, Lord.
But still number 24,
Edith Timaya.
Yes.
there is a connected writ petition which has also to be listed, 38415 of 25, because both of them arise. So if both could be listed and it could be taken up on 6th,
Yes, the post along with so and so.
38415
After
of
vacation.
25.
Yes, 25.
Yes,
Serial number 25. Serial number 25.
Yes.
25th, 6th,
Petition.
7th.
Yes.
Lord, this pertains to my lord. The wife, she was residing with husband. All of a sudden, she goes to Chikmagalur and files a case and obtain an interim order, my lord, 2 interim order, restraint order. And 2 order has been passed, my lord. And restraining, I mean, preventing the father to look, at least visit the children, my lord. And the order is in nature of, my lord, is a blanket nature and taking away the right of the father to at least visit the children.
Where is that?
My lord. Page number 33, ink page number 32, my lord. Operative portion, your lordship would get it in page number 34, my lord. The respondent and his relatives, agent, representatives of henchman are hereby restrained from entering the residence and disturbing the petition or residence at Chikmagalur. The respondent, the second order, the respondent and his relatives, agents, representatives, henchmen are hereby restrained from threatening, intimating, communicating the petitioner through any media, phone calls, messages, pending disposal of the petition till the next step. Now, subsequent to this, my lord, the petition is also filed for restitution of conjugal right by the petitioner, my lord, in which 2, application came to be filed. One is not to, take away the children out of the country, and other application being, my lord, visitation right. The trial court, the family court was pleased to say this, the application filed by the husband, the petitioner, kept in abeyance since the order of the Chikmagalur court is operating. And now, at the present scenario, my lord, the husband is unable to.
If the court has given such an order, we need to hear the other side.
No doubt, my lord. Now, absolutely, your lordship, kindly see the blanket order, my lord. I am not able to see.
No, we'll understand what it is. The notice to the respondent, petition is permitted to take out and summons on the council. List this matter immediately after the memo is filed.
Kindly have it.
26.
My lord, 6th of.
Once the memo is filed, it will come because there is no purpose in. If you
Please.
file the memo serving the hand
Please,
summons,
please,
then
please.
it will come.
Please, ma'am.
Yes, 26.
26. Hearing on IA.
This matter, your lordship, mediate at least this will settle, my lord, because of one day dispute, my lord, only one day quarrel, then she went away and
filed a case, my lord. And
After vacation, I'm at Dharwad. Yes.
Oh my God.
26. Yes, 26.
please,
Upper for appellant.
Yes.
This matter was posted on 4th.
IA number.
I was not there.
1 of 25 to recall the order dated 4/12/2025. What is this order?
This order, my lord, the respondent
Withdrawal of
not filed
depositing
withdrawal of the amount.
Uh,
For that he is not entitled. This is for the reason that, my lord, the admittedly, my lord, the Maruti car, my lord, which is, my lord, belongs
Not
to.
present on that day.
My lord,
You were not
I
present
am
on that
not
day.
present
Then
because, my
what
lord,
to
I was
do?
in, my lord.
No, one order for, one for withdrawal, other for recalling that order.
Sorry,
When
my
you
lord.
are, if you are present on that day, this order would have been, court would have heard you.
That is the reason, my lord, I filed this application for the car. Sorry, my lord, I was with.
Who are you? You are the owner of the
Earlier, my lord, I was the owner. Lord, I sold the car to the complainant. They responded himself. He admitted in the evidence that, blood, he has purchased the proper concerned car, blood, in the year 2009, but accident in the 2020.
Who is the RC owner as on the day?
As I am the RC owner. As on the date, I was RC owner, my name, it was in my name. But admittedly, in the cross-examination, blood, the complainant, the petitioner, blood, has admitted that he has purchased the car, blood, in the year 2009 itself.
You are the claimant. He is the claimant.
He is the claimant.
At the time of accident.
In the evidence, it is.
Sir, please come. On 4/12/2025, this court has permitted the respondent to withdraw the amount. When counsel appearing for the petition submits that petition has sold the car to the respondent and the respondent is a claimant. We'll hear the matter. Respondent is the claimant and he being the owner of the vehicle is not entitled for he's not entitled for any compensation. And he cannot be permitted to withdraw the amount accordingly. Order dated 4/12/2025, passed in I number 1 of 2025, is withdrawn. Registry is directed to call for the TCR. This is matter for hearing.
My respectful submission is that, my lord, I am the claimant, my lord, I am suffering multiple injury.
But you are the owner of the vehicle.
My lord, nowhere is stated, my lord, is,
Kindly
my
peruse
lord,
it.
at the time of accident, my lord, kindly peruse.
We have, no, when the respondent are objecting, we have to hear the appeal. I'll ask, call for the TCR once it come, we'll see. Yes, sir, 27.
Any date may be fixed, ma'am. Date may be fixed.
25 matter, how the date will be fixed now, it will come.
My lord,
TCR has
because,
to
my
come.
lord, some inconvenience to the claimant, my lord.
But that's a procedure, he has to pass through that.
So, my lord, otherwise, my lord, amount may be harder to withdraw, my lord. Because, my lord,
Yes, next matter.
Bill number 27, Ringraju HS for appellant.
Right. Appeal is by the insurer. It's a case of injury. I have taken a contention of contributory negligence. Two motorcycles were involved. Admittedly,
There's a contributory negligence on behalf of the claimant.
yes, on behalf of the claimant also. But that has
How much
been
is the
not-
amount granted?
6,20,000.
6,20,000. Even if it
Multiplier
is,
adopted is more because
land counsel appearing for the claimant, insurance company submits that there is a contributory negligence on the part of the claimant and the compensation that is awarded is on the higher side. The respondent insurance company shall deposit 50% of the amount and the appellant insurance company shall deposit 50% of the amount within 4 weeks. And on such deposit, the respondent is at liberty to withdraw. Notice to the respondent.
Bill number 28,
Just for the appellant, for the insurance
Yes.
company.
Yes.
Sir, the appeal is on the question of quantum, my lord. 18 lakh has been awarded, 50% time deposit.
No. If you say 18 lakh, what is the amount that is disputed that you have to?
My lord, disputed is, my lord, around 11 lakhs I have calculated.
Let's calculate what is, how it is 11 lakh.
My lord.
It won't be that much
3
difference.
lakh 25,000, my lord, medical bills they say. But some of the medical bills are duplicate.
So let us deduct 3 lakhs, it comes to
And then,
15
my lord,
lakhs.
regarding the income, my lord, your Supreme Court held that, my lord, in respect of minor, 5 lakhs is the compensation in.
Oh, Master Mallikarjun's case.
Yes.
What is the age of the?
Death case, my lord. This is death case. Was aged about 14 years, my lord.
Hmm.
So tribunal has taken the notional income as if is earning. And father himself said that he was doing the business, he is not dependent on the disease. He was a student at disease.
It is submitted that the amount of compensation that is awarded by the tribunal is on the higher side. It's a case, the deceased is a minor who aged 14 years. The court had taken the notion in considering the submission 50%. The respondents are at liberty to withdraw as per the conditions laid down in the award.
Bill number 29.
Notice to the respondent.
29.
Appear for appellant, my lord. 29 is delay of 167 days, my lord. 29.1
You appear
withdrawal
for
of
the
amount.
RTC. So and so, find the vakal, other.
Permit me to serve copy.
25 is filed to condone the delay of 167 days opposed by the reasons stated condone on the condition that they are not entitled for interest for the said period. What about you?
29.1 filed application for permission to withdrawal of money. She is
It is on the, on what ground you are before this?
Milord, on two grounds, I am seeking even contributed negligence as well as the future income is on the higher side.
You know, that's a 50% your deposit, let him withdraw.
Opposed.
IA number 1
This
of.
may be mentioned as opposed and then may be released.
IA number 2 of 25 is filed, seeking to withdraw the amount by the respondent. Land counsel appearing for the appellant RTC submits that the amount that is awarded by the tribunal is on the higher side. And the matter may be heard finally, considering the fact that the ground on which the RTC is before this court is on the contributory negligence and only 50% amount is deposited. Hence, this court finds no reasons to consider the submission of the land counsel for the RTC. Accordingly, I number 2 of 25 is allowed. And the petition is for appellant, the respondent claimant is permitted to withdraw the amount 30.
Please,
29.1 is there, my lord, that is from the case at 29.1. Maybe connected with that, my lord. 29.1.
Already connected, 29, 29.
both are connected.
Directed to take notice ಆಗಿದೆ. Bill number 30.
Please, ma'am.
Halima Amin is directed to take notice in 29. Serve the papers on her. Yes.
30. Ravi Shankar CR.
First, appellant your lordship. In the case of injury lordship, the insured vehicle was given the license your lordship. After searching the license your lordship, is a fake license. We are writing to West Bengal. He is from the West Bengal license as given. That is, we are produced the document. That's why we are unable to produce before that court, and we are producing along with the documents by the filing application. They are not in existence by the RTO by the West Bengal.
So pay and recovery has to pass now.
That's why after that you can notice.
The amount.
11 lakhs.
Land counsel appearing for the insurance company submits that the driver of the offending vehicle is having a fake, has the license of the offending driver is a fake driving license that they could not produce before the tribunal. Now, before this court, they have filed an application to receive the same as additional evidence. It is submitted that that in that case, once it's a fake driving license, the insurance company is the court entitled for pay and recover. In that way of the matter, there shall be a stay 50%, 4 weeks, and the respondent is at liberty to withdraw as per the case of injury. You said
injury case
as per the conditions laid down in the award. Yes, next.
Notice to seal number
Notice to the respondent.
31. 31 D Vijay Kumar.
Lord, I am for the appellant. Appeal by the insurance company challenging the liability, negligence and quantum of compensation. It's an ex parte judgment. It's an ex parte judgment. Our insurance company is
Liability on
not served.
what is according to you?
My lord, there is no DL. DL is not produced. Though the owner appeared before the court and contested the matter, and he denied the very negligence and involvement of the lorry. He himself cross-examined and denied it. But
The
he has
charge
not
sheet is
produced.
filed that there is no driving under the provisions of. No, so that ground is not there. Next.
Then, my lord, ex parte judgment, my lord, owner himself denies the involvement of the vehicle.
No, that is a different. So on liability, you have nothing.
Liability because he has not produced a driving license at all.
The
When we have not
land
appeared.
is
my
submitted
lord,
that the court has granted it's an ex parte order and the appellant insurance company. Notice is not served.
Notice is
not served on the insurance company, and there shall be stay 50%. And within 4 weeks, the respondent is at liberty to withdraw.
Cell number 32,
Yes, 32,
Rudrappa.
In the past or my lord?
pass over. 33,
Cell number 33,
Get for the petitioner.
Manira.
Petition by the husband.
how much is granted by the court?
My lord, pardon, my lord.
What is impugned order?
The interim order is, the order has been passed by the trial court has been directed the petitioner to pay rupees 7,000 per month, my lord.
So
And-
what is your income?
The petitioner is being the coolie work.
You
The
will get
petitioner is
15,000 per month.
3,000 per month for the wife, my lord, and 2,000 per month for the each respondent number 2 and 3, my lord. That is, they are children's, my lord. Children's of
But I
the
understand. What is the difficulty for the father to pay? That's what I'm asking.
the petitioner being doing the coolie work.
How much is
very
earning per
difficult.
month?
Earning per next date I want to know.
3 people, 7,000. What is wrong in it?
The income is very less. The income is very less of the petitioner, my lord.
We'll see. Notice the respondent.
Cell number 34,
For petition in this case, my lord, delay is 187 days is delayed.
Notice the respondent.
cell
My lord, 187 is delayed, my lord, and I have not taken the notice from the family court, my lord. I have not provided an opportunity to participate in the trial.
When
So
did
my
you come to know about the
already I
proceedings?
paid. Already I'm paying.
When did you come to know about this
No,
order?
it came to my knowledge on 27th June 2025.
Where are
When
we
my
now?
case,
Where
when
are
my
we now?
divorce case is transferred to the Mysore court based on the High Court order, and it came when I appeared before the Mysore court, it came to my knowledge that there was an order against me. It was shocked to me, and immediately applied for the certified copy. And 8/7 I filed before this the court for challenging the said order. And addition to this, my lord, addition to this, my lord,
If
I
it
have
is
not
filed
received
on
any notice from the court.
If it is filed on 8/7,
I'm
what
in,
is it
yes, my
doing
lord.
from now till now?
Till now, it is in the stage of objections only, my lord, for complying the objections.
That is whose problem, not complying the objections.
I'm struggling with the pending guys because of their repeatedly
Or not.
this.
Petitioner is struggling. You are here to comply with office objections.
Yes, my lord.
Why did you not do it from the month of July?
My lord, that was a difficulty, my lord, because there keep on rising repeatedly. Objections have been raised. I'm keep on complying all the objections, and finally I could succeed with the request of them. And now the matter has come before the court, my lord. My difficulty is, my lord, already as per the order, 30,000 and 20,000 to the respondent. Already I paid more than 50%. 4,50,000 already paid to the respondent before the family court. My difficulty is, my lord, I am ready to pay the 20,000 every month to the respondent for the survival, but till disposal of this court, my lord. I'm requesting to stay the operation of it, my lord. Let the matter here before the court. What is my difficulties and what is
your
that, my
income?
lord? So I'm ready to pay the 20,000 every month.
I think it's not about you arguing. You have
Yes.
to hear what I'm asking.
Yes, my lord.
I said, what is your income?
My income is 3,000. My lord, I am the US citizen. I'm staying in the US, and my average my income is 3,300 rupees per dollar. Out of it, $2,500 it's my lodging and boarding. I'm staying in the staying in as I'm staying in accommodation kind of a rent kind of a things, my lord, in there. So I could able to save only 250 US dollar per month, my lord. So so my parents are 80 plus parents are depending on me. My first wife is also depending on me. My first wife daughter is depending on me. And now the second wife and daughters are got the impugned order against me. It was difficult me to survive myself, my lord. Even though I'm paid 4 lakh as per the order, as on the date 7 lakhs I supposed to pay as per the order. I paid 4,50,000 to the honorable
to the respondent as on date, my lord. My difficulty is that order has been excessive and exorbitant, my lord. So my request is, I'm ready to pay the 20,000 to survival my the respondent number 1 and 2 till disposal of this honorable court. Kindly grant the stay the operation of it, my lord. That is my request.
I am coming back to the same question again.
Yes, my lord.
Please quantify what is the amount. Don't tell me all that. What is the amount you have? What is your income?
My
Income
lord,
is like whatever, all the deduction, what all the, you have narrated.
I could
101
save
issues.
only 25,000 per month, my lord. Out
So
of all the
25,000 per month.
per month.
You will pay 20,000 to this, to the wife.
Yes, my
You
lord.
will pay some other amount to your first wife, some other amount to your second, your first daughter.
No, no, my
How
lord,
can it be
because
20,000 amount?
50,000 I'm not in position to pay, my lord. That's the reason I'm requesting the 20,000 I'm ready to pay.
The present petition is filed with a delay of
187 days, my lord.
187 days. It is the submission of the land council that the notice is not served on it. The court had granted 30,000 per month to petition number 1 to the wife and 20,000 per month to the child. Petitioner number to the respondent 1 and respondent number 2. It is submitted that he is ready to pay an amount of rupees 20,000, the 20,000 to both the respondents. The court had granted 50,000 for both of them. Hence, they shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 15,000 each by 5th of every succeeding month. Notice to the respondents. Arrears also at the same amount.
Serial number 35.
Much obliged, my lord.
Petitioner, my lord, there is a delay of 12 days.
Yes.
We condone, my lord.
What is the order?
My lord, order to pay 7,000, my lord.
What is your income?
My lord, he is electrician, my lord. He is earning around 15 to 20,000, my lord.
Only wife or daughter is
Only wife, my lord. They have lived,
7,000 will not interfere.
my lord. Age-old parent is depending on them.
Notice to
My
the
lord, they are in
respondent.
rent
Notice
and,
to the respondent.
oh, my lord.
Petition is permitted to take out handsome. No, it's a RPFC. Just notice. Yes, 36.
Serial number 36. Lata Shetty, for petitioner.
Yeah, for the
Shetty
petitioner, my
respondent.
lord.
They are given some representation.
For the-
We consider and have it application. Because they are seeking a one-time settlement of the same matter. I sold 2 property and 2 SA got dismissed. Subsequently, this firm directly to consider the representation. We given a reply and thereafter they are given certificate. So we consider and we give them that.
After vacation. This is
Interim order may be extended. Interim order may be
Interim
extended.
order only granted is extended.
37
Much ob-
adjourned. Serial number 38. Sunil S. Sridhar AG for respondent.
This matter was disposed of on 29/7/2024 itself. I filed the application for correction of the operative portion of the order.
What is that?
In this case, my application has become infructuous because the main execution petition itself filed by the petitioner is dismissed. So it doesn't require for consideration. Main execution petition itself filed by.
Why should you file that it doesn't require?
It was filed in the last year, September 2024.
You can tell the court itself. Why should you ask for reviewing this order?
No. The thing is, instead of the order passed on IA number 3 in execution number so and so family court is confirmed. Instead of that, the impugned is set aside. The order passed by this honorable court. So for correction of the.
1 minute. Let me read the order.
Please.
What is the order impugned before this court?
Or the.
Agreed with order passed in execution number 56 of 2023.
Yes, ma'am.
You have questioned that order before this court.
No. I have not questioned. Petitioner had questioned the order.
Where is the petitioner?
Petition is not.
Yes, after vacation.
And moreover, my lord, the petition, the application itself is not sustainable because already main execution.
Let's see 1 second.
Please.
list after vacation. Yes.
Seal number 39, B.M. Alaswamy.
Petitioner in this case, my lord. My lord, there are two connected matters in this case, my lord. Both the matters was disposed on 24/6/25, my lord. My lord, the only thing is one petition is filed by wife and one is filed by the husband, my lord, for reduction and for enhancement, my lord. My lord, while passing the order, my lord, the court had in order, my lord, in column number 1, it should have mentioned as both the children, my lord.
Like where you get that?
My lord, in the order, my lord, column number 1. Now, by taking advantage of this, my lord,
That's why, where is that?
my lord, the
Number?
column number.
Operative portion. The husband shall pay an amount of 10,000 to both the children.
My lord, 10,000 each. It has to be made as 10,000 each, my lord.
No, that's what is discussed before. Let's see.
My lord, yes, my lord.
The family court had granted maintenance of 10,000 to each children.
Yes, my lord.
Then counsel for the husband that the wife is earning more and you will pay an amount of, then the such submission made by the father is not acceptable. Sought for maintenance for herself or for the educational expenses. Father to take it. His concurrence. In the order, the court has discussed about the maintenance that is awarded by the. This court has passed an order on 24 June 2025, where the operative portion of the order says that the husband shall pay an amount of rupees 10,000 to both the children. It is now the petitioner has moved an IA seeking correction of the order. Land council submits that in the order it is discussed that the family court has granted 10,000 each to both the children, and this court do not find this court do not find any infirmity with the said order. But when it comes to the operative portion, instead of mentioning 10,000 each, it is mentioned as 10,000 to both the children, and the respondent is taking advantage of the same. Next, this court has perused the order. In the discussion, this court has clearly held that the order that is passed by the court granting 10,000, it cannot be interfered with. In view of the same, in the operative portion, at point number 1, it shall be read as the husband shall pay an amount of rupees 10,000 each to the children. The uploaded order, the corrected order shall be uploaded. Yes, next.
Grateful, man.
41.
In terms of the interim order, but order dated 2025, my lord. This I have filed, my lord.
Why the respondent side there is no advocate named in 39?
Avatar is there, I think.
41.
No, not in your case.
Sorry, I'm sorry.
This is
41, my lord.
correction is 39. Just now what is then why the respondent side there is no advocate's name is not mentioned?
Lord, there are both connected matters, two connected matters, my lord.
Which one?
One is petition 29037 of 24 and another one is 2804 of 24, my lord.
In which you have filed? In which case you have filed the IA?
I filed in both, my lord.
So then
I mentioned
advocate must have appeared, no, in the
I have
for
served
the
the copy.
respondent.
Yes, my lord.
That his name should have been reflected in the order in the cause list. No, without notice, why it will be?
Put the interim order in favor herein. Accordingly, my lord, the
I am looking at WP 45.
Yes, my lord.
Uh,
Wherein, my lord,
order of stay of possession notice.
yes, my lord.
All further breaking the neglect subject to the petition deposit. How much is the outstanding?
Outstanding is, my lord, now it is closed, my lord. Account is closed.
Close.
Yes, my lord. This is the my lord account. Madam. 41.
41 is the.
41.
40 who appears?
127. It is adjourned. my
Oh,
lord.
morning it is adjourned.
Sorry.
Oh. Mm. Yes,
The court officer. Please hand out.
yes, 41.
Yes, ma'am. 41.
My lord, it's not closed. In fact, my lord.
No,
after
I will complete. My dear sister, please.
Lord rejected me twice.
Well, wherein, my lord? Your lordship may kindly see the, my lord, the last page of the account, it is 0. After that, my lord, intention of the manager by handwriting plus pending interest of rupees 12,63,212 and charges to be added and paid. This is the endorsement, my lord. This is the bank. How the, my lord, this lady, my and husband and wife is, my lord, from
My lord,
KGF.
yes.
Let
My
me.
lord, in fact, this is as per my lord, interest is only at the time of filing the OA. After that, interest is not charged to the account. That is why additional amount is mentioned. Plus, my lord, the same cause of action subsequent to the IA file by the petitioners for restoration of possession, they've gone to DRT. Section 14 order is challenged in DRT.
No,
We filed objections. What?
DRT passed the
Yes.
order.
No,
DRT
we
passed.
filed. No, let me
Then
complete.
why this court has to deal with this merit petition?
My lord, when matter is pending, my lord, before the DRT, we have, my lord, against the possession, physical possession order, we came before this honorable court. Accordingly, pleased to granted the interim order with certain condition. After that, my lord, we have paid the, my lord, as per the terms and condition of the this honorable court, we paid the amount. Then, my lord, the learned DRT court has disposed on dated 2/5, my lord.
That's OA, my lord.
That is OA 501 bar 2008.
Essay is pending, my lord.
No.
Yes, I filed objections. They are, in fact, the other counsel. My lord, may kindly see, I've, yes, my lord. Last page. Essay diary number 2575. Immediately after filing this application, because the vacation happened, my lord, they have actually approached DRT. DRT is seized of the matter. And DRT is, in fact, we filed objections. DRT is of the matter, they have not.
No.
May kindly see. No. What no? My lord, may kindly see page 35. Page 35, essay. My lord, 2593 of 2025. Kindly, my lord, see the petition of Malati RB. Section 14 order challenge. We filed objection. Matter is about to be disposed of. Interim order was not granted because they were pending dues. If they appear, matter will be disposed of. DRT seized of the matter. They have suppressed that fact. This application for restoration of possession was filed on 29. My lord, and then, my lord, the vacation happened, Dasara vacation. Immediately they rushed to DRT. So this entire proceedings is seized off by DRT right now.
No, my lord. DRT has pleased to pass the order. This is the order of.
OA, my lord.
This is the OA order, wherein OA order.
No, she is
Easy to understand.
I think your client is not instructed you properly.
My lord, she has instructed. She has said.
No. Look at page 35 of what she has filed.
35, my lord.
Yes. (2593) of 2025. Next listing date 9/3/2026. Petitioner same Srimati Malati.
Yes, my lord. This, my lord, facts has stated, my lord, in this writ petition.
It is before the.
Yes, my lord.
And once the essay is pending,
Please, ma'am.
whatever your the other proceedings, whatever your grievance, it
Please,
can be
ma'am.
addressed by the
My
tribunal.
lord,
We will not interfere.
one humble submission, my lord. If my lord is permitted, I will make, my lord. My lord, this type of extortion, my lord, are not good for anyone, my lord. As a husband and wife has admittedly borrowed, because of the, my lord, intervention of this honorable
This
court,
I will.
I have a ample
let the court
opportunity to
decide
repay.
that. Let the DRT decide that it is bad.
DRT has decided. Now, my lord, the OA has.
OEA, this is SA.
Yes,
You're
sir.
getting confused between the
No.
two.
Essay in the essay also, my lord. The OA, why?
It's coming up on 9/3. It is not decided yet.
Correct, my lord. That is correct. But
We decided. Let all this. I'll give liberty to you to go before the right on the same issue. Let that be decided. Why piecemeal? One essay there, OA there, writ petition here.
my humble submission, my lord. Kindly, my lord, give the findings about the, my lord. The account is, my lord, now become 0.
I'll not give
That is 0. When it is 0, my lord, that is the
But
duty
that
of the,
is
my lord, bank. Because
in a
my home is
piecemeal
here.
basis, in a piecemeal basis, we will not decide the cases. I'll pass order after lunch.
I will come back, my lord.
Yes.
Please.
Miller, one submission, Miller. Miller, RPFC, it's coming, we are challenging that 125 CRP, Miller. This one is maintenance, Miller. That wife is filing, already filed that.
I think you can't
That
make a
is-
mention
no,
at
we already
1:30.
moved, Miller.
ಕೋರ್ಟ್ ಆಫ್ ಸೀರಿಯಲ್ ನಂಬರ್ 42 ಇದೆಯಾ ಪಾಸ್ ಅಥವಾ ಅರ್ಜನ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಮೇಡಮ್?
ಕೋರ್ಟ್ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಅಂತೀನಿ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 42 ಇದೆಯಾ ಮೇಡಮ್ ಅವರ? ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಹಲೋ ಮೇಡಮ್ ಅವರ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಮೇಡಮ್ ವೀರಣ್ಣ ತೆಗೆದ್ಬಿಟ್ಟು ಅದನ್ನ ಪೇಪರ್ಸ್ ಕೊಟ್ಬಿಡಿ. ಅದು ಇದು ಬೇಡ, ಫ್ಲಾಟ್ ಫೈಲ್ ಬೇಡ. ಮಿಸ್ಟರ್ ಚಿದಾನಂದ್, ಇದು ಕೂಡ ಅದು ರನ್ನಿಂಗ್ ಕವರಲ್ಲಿ ವಕಾಲತ್ ರನ್ನಿಂಗ್ ಕವರ್ದು ವಕಾಲತ್ ಇದೆ ನೋಡಿ, ತಗೊಳ್ಳಿ, ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಮೇಲೆ ಯಾವ ಪೇಪರ್ಸ್ ಇದು ಕೊಟ್ಟಿದ್ದಲ್ಲ ಅದು ಬಿಟ್ಬಿಡಿ, ಅಷ್ಟೇ. ಏನಿಲ್ಲ, ರಿಟರ್ನ್ ಬ್ಯಾಕ್ ಫೈಲ್ ಮಾಡಿದಿರಾ? ಇದು ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿರಿ, ಫ್ಲಾಟ್ ಫೈಲ್. ಅದು ನೋಡಿ, ಯಾವಾಗಿದ್ರು ನಿಮ್ಗೆ ರಿಸ್ಕೆ ಸರ್ ಅದು. ನಾನು ಇವಾಗ ಹೇಳಿದ್ದೀನಿ, ನಾನು ಅವ್ರಿಗೆ ನಿಮ್ಗೆ ಸದ್ಯಕ್ಕೆ ಹಿತ ಕಾಣಿಸುತ್ತೆ. ಐ ಟೋಲ್ಡ್ ಇವನ್ ಇವ್ರಿಗೆ, ಪ್ರಣವ್ಗೆ ಸದ್ಯಕ್ಕೆ ಹಿತ ಕಾಣಿಸುತ್ತೆ. ವೈ ಯು ಕಾಂಟ್ ರನ್ ದ ಕೇಸ್ ಲೈಕ್. ನಾನು ಇರ್ತೀನಿ, ಇವಾಗ ನೀವ್ ಯಾರೋ ಒಂದು ಅಡ್ವೊಕೇಟ್ ಏನೋ ಮಾಡ್ತೀರಾ, ಅವ್ರು ಬಂದು ಏನೋ ಬೇರೆ ನಾನು ಇರ್ತೀನಿ ಅಂತ.
ಏನಾಯ್ತು, ಈ ವಸಂತ ಅನ್ನೋರು ನಾವೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬರ್ತೀವಿ. ಪ್ರಣವ್ದು ಯಾವುದೇನೋ ಸಮಸ್ಯೆ ಆಗಿ ಅವರು ನಮ್ಮ ಕ್ಯಾಸ್ಟರ್ ಆಗಿ ನಮ್ಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ.
Madam Court Officer, one request, Madam. Hello? Hello?
ಪಾಸ್ವರ್ಡ್ಸ್ ಇದೆ ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ಬಿಡ್ತಾರೆ. 42 ಇಂದ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಇದೆ.
Madam Court Officer, Madam, serial 42 is the next. Serial 42 next matter. ಅದೇನಾದ್ರೂ ಅರ್ಜೆಂಟ್ ಆಗಿದ್ದು ಇದೆ ಮೇಡಮ್?
ಸರಿ ಇದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಪ್ಲೀಸ್.
Your Lordship, if I may be permitted to mention an urgent matter. There's a restitution of conjugal rights that is.
Not mentioned in the morning.
It was filed this morning, Your Lordships.
No, you didn't mention in the morning. You can only mention the matters in the morning. I'll not hear any, whatever is urgency. Yes. Passos.
Passover matter, cell number 16, 1-230 matter.
Just call the passos.
Passover matters, cell number 16. List number 2 in the month of February 2026, urgent.
Yes.
Cell number 16.
It's appearing for the bank in this matter. Filing valuation report as directed by this honorable court and the.
Have you given him a copy of it?
Yes, sanction building plan.
Take that. Yes.
So, Milords, without getting into the other nitty-gritties, I just wanted to say this, Milords. In view of the principles laid down in Celir LLP, Papna and Celir LLP, now the yardstick is to find out whether there is any prejudice caused or not. That's the simple yardstick. Milords, ultimately, Milords, if the Lordships is otherwise satisfied, there is a prejudice caused to them on the on an abysmally low or a value at which it is shocking the conscience of the court, then your Lordships can interfere. Is the series of judgments. I'll not dispute that position of law. Lords, the contention which has been raised by the petitioner is that the valuation at which we started the sale process was lower, number one. The property which is brought for sale is lesser than the property which is actually in existence. 2. 3, the valuation which they have provided clearly indicates that it is having a higher value. These are all the 3 contentions. That's the only 3 factual aspects I'll. Lords, 1 and 2, which I said now, is only for the purpose of determination of the market value of the property. Whether it is a smaller extent or bigger extent of the property, it's purely on the market value of the property. Can I just persuade your Lordships may kindly have a look at the valuation filed by the petitioner? At Annexure E, page number 52.
It's a comparison.
Yes.
In that, if your losses were to take page 56,
Yes.
the market value of the property is 21 crores 16 lakhs 57,000. Realizable value of the property is 19 crores. Forced value is 16 crores 93 lakhs 25,600. Notice what is necessary is if your losses were to see the pleadings with reference to annexure E. At page number 6, just 4 lines above paragraph number 6.
Yes.
Only to indicate, Peanuts, for better appreciation of this honorable code about the value prevalent in the area, valuation is made by the registered valuer. So that is what they are lying upon. This is the admitted fact. I just want to say that this is something which the petitioner wants this honorable court to believe. No difficulty.
No, where is that?
Peanuts, paragraph number 6 is there, just 4 lines above that. There is something in bold, annexure D at page number 6. For better appreciation of this honorable court about the value prevalent in the area, valuation made by registered valuer, ali comma haki, would clearly indicate the reserve price fixed is so and so, so and so. This is the valuation report which they have got.
This is page number?
This is page number 52 is the valuation report, page 6, Peanuts, paragraph number 5. The last sentence in paragraph number 5.
Valuation report is at page number?
Page number 52. And the relevant page for your lordship's consideration is at page 56.
Yes.
So 16 crores is the first sale value. This is admitted by them. This is what they are asking this honorable court to believe. Look, this is what we are producing. Therefore, we want to say that this is grossly undervalued. Now, if your lordships were to see the property is presently sold at 20 crores and odd. Now I can understand. There may be, instead of 100 square feet, it is shown as 50 square feet.
No, it's not. It is 24 is shown as 24,000.
That's the reason why I said. Now they have got the valuation. They are bound by their pleadings. In the pleadings, they admit that this is the proper valuation of the entirety of the property over which they claim the rights, which has been mortgaged to us. According to them, 16 crores is the realizable value. The first sale value on realizable value is 19 crores. The penultimate market value, which would have been sold in private negotiation, is 21 crores. We have sold at 20.5 crores.
No. What do you say about when it is 24,000 square feet is a property? Why it should be mentioned as 13,000?
Lords, can I just persuade your lords? We are having some difficulty, my lords, when it comes to the question of reflecting what is the area which we are required to sell. After the series of judgments by the Supreme Court, my lords, regarding OC, etc. Now, what the bank is doing is, whatever be the value, whatever be the construction existing, what we are doing is we are strictly going by.
I actually asked him for the valuation report.
No, now the plan, your lordships may kindly see the sanctioned plan. Now, the property, if somebody has constructed an illegal construction over the property, I've just wanted to put this, minutes. Let us say he is entitled to construct 10,000 square feet. He constructs 40,000 square feet. When I want to sell the property, I am required to tell the buyer that the sanction plan is only for 10,000 square feet.
That's what it should have been reflected in the
it is there. That's the reason why I said. Kindly have a look at the sanction plan.
Yes.
Sale note.
No, not the sanction plan.
You'll not suspect.
At the time of granting the loan to him, have you granted the loan only for, by mortgaging 13,000 square feet?
We have mortgaged the entire extent of the property as it was then available. There is no difficulty. We have produced the valuation report of what is the extent to which we have valued the property and given it. All these questions will arise for consideration. That's the reason why I said, now the yardstick for consideration is the theory of prejudice. Now, if he shows that there is any miscarriage of justice or prejudice caused to him in terms of monetary loss caused, I can understand that. Now, fact remains, he comes before the court and says that whether it is 13,000 or 24,000 square feet as is being debated presently, the entirety of the property which he has mortgaged to us will be valued at 21 crores market value. 19 crores is the.
So in that case, bank can say whatever it is. They can sell the mortgage property is 10,000 square feet,
Building,
they can
Milords,
sell it
I
for
would,
$1,000.
if your lordships were to say, I'll go on the first principles, Milords, that land includes buildings. Under the Transfer of Property Act, if you go by the definition of land, it includes buildings.
First of all, bank should substantiate. Why is it so?
Milords,
They cannot say what is the prejudice. First of all, you have to act in a manner which is known to law.
Lordships, may I kindly see the, may I just request your lordships, may I kindly have a look at annexure R13.
Page number.
Page number, the symbolic position though, just 1 minute. Lords. I just pointed there is some, idalla. Just open this. I just point out, Milord, the sale notice is there. Sale notice reflects the entire extent. I'll just show it. We have the sale notice. Clear agilla antana? You have a copy of the sale notice?
You have filed a sale notice?
Yes, yes.
Yes, Milord. I have filed
Annexure
the sale notice.
R20, page 211.
There is one more volume.
Lords, this is the statement of objections filed on 17/3/25, 211. I don't know whether if it's in 2 volumes, my lords. It's 211. I'm sorry, my lords. Hey, really, where have you produced this? Annexure R20. Annexure R20. Give me English version.
Sale notice annexure A, page 15.
Page 15.
Yes.
I will sale notice.
Page 16 is the schedule.
For entire extent of 24,415 square feet. That's the sale notice. Publication is also for the same extent. The same thing we have replicated, Milords, in the paper publication. So whatever is brought about, Milords, now something like this. At the stage of Rule 8.5, when valuation is obtained, whatever has happened, now we have published the sale notice as this is the extent of property. Now the next question is, all right, if I have published it as 10,000, but actually there exists 20,000, as a result of which the bidders have bid for abysmally low price. That 20,000 square feet of construction is completely not taken into account and we are seeking to sell the property, I can understand. My sale notice is for 24,000 square feet.
Then where we get 13,000?
That's what happened. Originally, this valuation when we obtained, see, this is something which happened like this, Milords. We are required to supply all the documents to the valuer. Now, valuer's guidelines will be there. Now, what the valuers are doing is they are going by the sanction plan, whatever is the sanction plan, they will do the valuation and they will give the report. When we gave it for the valuation for the purpose of distress sale, he has gone by the sanction plan saying that 19,300 square feet is the construction. Therefore, I am giving the valuation for this. Now, notwithstanding this valuation, because we are aware what is the extent of property, original valuation is also there with us. Present valuation is also there with us. We have the mortgage of the property. We know what is the extent of property mortgaged. We have brought to sale the entire extent of property which is mortgaged to us. And we fixed the price which was given by the valuer a little higher than what is given by the valuer. After this exercise is undertaken, from 14 crores, I can understand. His contention is 16 crores should have been the value. Distress sale value should have been 16 crores. Instead, we have published at 14 crores. So if your lordships were to see para 5 of the writ petition, this is essentially their pleadings. 14 crores and 16 crores. 10%, 15% is not the, I can understand 50%. Some cases I have seen it is 1/3 also. That is shocking. Even to the registration value, it will be 1/3. I can understand. If your lordships were to see paragraph number 5 of their pleadings, Milords.
So I'll take the senior counsel submission that when these kind of variants are there in the sale notice, the property, we shouldn't, this is not a small variant.
Prejudice, Milords. No, sale notice, there is no variation.
No. It is when a borrower comes before the court and says something, it's a different. You are a bank. Bank is bound by certain rules and regulations. We can't assume and
no, not at all, Milords. Milords, I am not requesting your lordships to assume anything.
My first question is, at the time when the property was mortgaged, when you have valued it, In that case, in that day also, you have to, your valuer should say that it is remaining is unauthorized construction. Only 19,000 is a construction. For that only we will value it. That only will give you the loan.
What happens, Millards? The evaluators,
The valuer,
reserve
what he has not
valuators, if
realized
your
that
lordship
day,
wants
you
that,
can't
Millards,
realize it
there will
now.
be, Millards, because we come across such cases, there will be guidelines which will be issued from valuers from time to time. It may be possible that there was a valuation guideline at that time and valuation
But let them
guidelines
say
at the
that,
present
bank
time.
has
No
to say
difficulty will. But Millards, ultimately, Millards, the reason why I am submitting this is all these things is necessary because it has to safeguard the borrower's interest in ensuring that the best property price is secured.
And also there is transparency in the manner
Absolutely,
in which
Millards.
the bank is conducting its affairs.
Absolutely
That
no
is also-
difficulty, Millards. Now, transparency, I have already explained, Millards. Once the first valuation takes place, 24,000 square feet, we have taken 24,000 square feet valuation and we have given the loan. NPA is not in dispute. Then after the NPA, we bring the property to sale. Millards, if your lordship were to see section 13 to notice, it is 24,000. 13 for possession notice is 24,000. We send it for valuation along with all the documents. The valuator says that 19,000 square feet is the authorized construction for which this is the valuation. We put it a little more and then put it for the auction. 14 lakh crores is the valuation at which we had put the property for auction. So this is the first value. Now
if you value the property at 24,000 square feet, if it is coming to so and so figure, now what you are selling is only half of it.
Millards, 24,000 is the actual built up area. What we have proposed for auction is 24,000 square feet only.
Sale certificate is given for?
24,000 square feet only.
Where from we get 19,000?
Millards, 19,000 is because it is there.
Let's because I don't remember which page I have seen on the last occasion. Where is that?
6,040, Millards, is the cital area.
187.
If your lordships were to see.
187 to my writ petition. There was a statement of objections, page number 187.
Millards, cital area is not 24,000, Millards. It's only the built up area. The difference is in the built up area of about 5,000. Cital area, there is no difference.
Page number 187.
Yes. Built up area, there is no
R15.
difference. Millards, what I am submitting is, Millards, in an internal, because valuation is something which is for the purpose of my guidance. Now, valuation is not some document which requires the concurrence of the borrower.
Kindly see the next page.
Page 187.
This is their valuation for the purpose of fixing the reserve price.
Where do you get that?
At page number 188. Totally measuring cital area is 6,040.
Correct.
Equivalent built up area as per FAR 13,590.
Lords, 189, bottom of the page, serial number 4. We have said everything. FAR prakara, yes.
FAR prakara eshtagutte? That was the reserve price that has been fixed.
Sorry, Milord, that the fourth bulleted point at the bottom of page 189. Everything we have stated, not that we have hidden everything. Built up area as per the FAR is 13,590 square feet. Then bottom of the page, as per the provided details, subject property is having built up area of 21,415 square feet as per the FAR 2.25. Arrived BUA is 13,560 square feet. Hence, leased BUA of 13,590 square feet has been considered for valuation. Then next page, the prevailing market value for the similar properties in the vicinity of the subject property, which are already occupied and identifiable at site, will fetch the value of 23,000 rupees per square feet. Millards, it is not that, Millards, this transparency, what your lordships, the transparency is required to be reflected to your lordships because borrower is not a part of the valuation process. Now, how we have valued the property, now we have explained. The valuator's report itself clearly explains how the valuation he's arrived at. He's taking the total FAR value, what has been given under the plan, that is 2.25, and he says this will be taken and thereafterwards valuation is given. Now, this explanation is there, or what your lordships asked us as to where we get this, this is there, very much in the valuation which we have secured.
Where is the sales certificate?
Lordships may...
Lord, I placed one memo on record with the registered sales certificate pursuant to the orders of this honorable court. I placed one memo on record, my Lord, 16/12/2025.
Along with my amendment application, it is produced. Copy of the sales certificate.
My Lord, may kindly see.
24,415 square feet built up area. Lords, except in the valuation, which is an internal correspondence between the valuer and the bank, where he says that when you are valuing the property, this is the method which we have adopted. Now, after valuation is given and we come with the valuation, if your lords so to see para 5 of the writ petition, that's the whole gamut of their case. But now that case falls flat because we have sold the property at least 4.5 crores than the value which he says is the actual value of the property. Paragraph number 5. Writ petition.
No, where is this sale certificate is referring to?
Let's in the sale certificate, the last page, the schedule is mentioned. I think my learned friend is produced. We have also produced along with
the
that
amendment
plan.
application, it has been filed. Page number 8, is started page number 8. And
Your amendment application is dated?
it is application dated 28/3/2025.
Sale notice is for 24,000. Sale certificate is for 24,415. Same.
According to you, what is the price of that property?
The valuation certificate of what I have produced along with my petition, is the valuation taken as of 2023. 23. The sale has taken place in 2025, April 2025. The difference, there is a difference of about 22 years in between, or at least 18 months in between the date of the earlier valuation and the date of sale. 1.5 year difference is
So they
there.
have sold
In
it,
my valuation certificate,
Sold it more than 4.5 crores, they say.
Yes.
Then if there won't be that much, more than that difference will not be there.
No.
In a matter of 18 months.
it is there, Millard. Guideline value as per the
Produce
submission.
something and say, how will the court assume that?
Lords, this
Millard,
can be,
may
I
just-
would
may
respectfully
just-
submit this.
now,
Lords. Now, if they
along with
want
the-
to get into this
along with
disputed
the-
arena, what might have been or what ought to have been.
No, Millard.
On the face of it, I'm in a position to demonstrate, Lords, on the
Millard,
base of the pleadings.
May
put
just
forth.
now, they have produced the valuation certificate taken by them at the time of sanctioning the loan. Kindly take the valuation certificate. They have produced along with a
Along
memo
with
today.
these documents.
They have produced along with a memo today.
Along with this?
No, separately it has
The
been produced.
valuation report, my lord, at the time of lending the.
It's produced separately along with the
Yes.
memo, my Lords.
Keep it here.
As per this, as of 2018 itself, the valuation of the property according to them was 18 crores 91 lakhs 33,000.
Now it is sold for?
20 lakhs.
20 crores.
12 lakhs 50,000, more than 4.
Can I just persuade your Lordships, may I kindly have a look at the same valuation report
It is
on the
after 7
previous
years.
page number 2. The total, because your Lordships wanted to know where is this 19,000 square feet. Built up area in square feet as per sanction plan, built up area is 19,542.47 square feet.
No, actual built up area is sold now.
I just wanted actual built up area, my Lords, is there, but what I wanted to clearly point out is that there is some discrepancy in the sanction plan and the actual built up area. We have sold the actual built up area, whichever is available. He is not disputing the fact that the actual built up area is what is reflected in the auction notice and the sale certificate. Only question, my Lords, is because he cannot traverse beyond the pleadings at this point of time. I should not be taken by surprise. His plain and simple contention before your Lordships is very, very, very simple. My valuation says 16 crores is the forced value. Property is brought to sale at 14 crores. That is his pleading. Lordships, may kindly see paragraph number 5.
That is as per their sale notice. But as per their valuation, according to the first value is.
No, it is the valuation which is obtained by him. The valuation is obtained by him. Whatever is produced at annexure E, that's
No.
not our valuation.
No. What, this annexure E is dated?
Lords, annexure E is dated.
Millard, is dated.
I just point out, Lords. 5/10/2023.
Page number?
Lords, page number
Page number
56. So if it is 16 crores is the forced value, 20 crores, 12 lakhs is obtained. It is more than reasonably good appreciation which he has got. And this is the valuation which he has produced, saying that this is the correct valuation.
Yes, please come.
My lord, my lord, the area, everything has been mentioned. Kindly now see the valuation certificate that they have produced along with their statement of objections. No description of the property details, nothing is mentioned. The movable property is available there along with the movable property that has been sold. Movable details not forthcoming. Even in their first valuation report also, the valuation according to them as of 2018 is 18 crores 91 lakh 33,000. Post market value would be about 15 crores 13 lakhs. In the present sale notice, the the reserve price that has been fixed is after 7 years, it is fixed at 14 crores. It is the reserve price that is required to be looked into for the reason that, and the details of the property also is supposed to be looked
Reserve
into.
price is 14 crores.
Reserve price 14 crores. 14 crores, they show the reserve price in the notice, sale notice, 14 crores. As of 2018 itself, it is about 15 crores. 7 years gap in between. That is this valuation that has been taken. Valuation certificate suffers from total suffers from particulars. Nothing is mentioned in this, and according to them, they say that no entry restricted. Even the building area, they say that floor of the building is also not applicable. How many floors are there? How many area is the total area? They mention even total area is mentioned as 13,590. From where they get this? 13,590. It is even according to them, as per the sanction plan, it is about 19,000 square feet. The very sale certificate suffers from uh, illegalities. There is totally, I would say that it is contrary to Rule 8 of the security enforcement rules.
I would suggest
It
this,
is
my lord.
based on
Sorry.
this only the sale has taken place.
I don't want his rights to be foreclosed. I don't want his rights to be foreclosed. If he is right, he can definitely establish. But having admitted this, he should not. If he still wants to pursue his remedy, he can be relegated to DRT, where he can still have another round. But his conduct may not permit him to do that. That's essentially, my lords.
That petition is filed.
May I just pass on the movables that was available in the property as on the date of sale. There are about
In the case of the petitioner, that he is absolute owner and in peaceful person enjoying the property.
Because the entire property was in the occupation of tenants. That's what they have stated.
No, the sanction plans for hostel.
It is situated at Marcosa Road, Malleshwaram, Bangalore, with a built-up area approximately measuring 24,415 square feet. The petition in the year 2018 sought and obtained equity loan of rupees 6 crores 90 lakhs for creating equitable mortgage in respect of the subject property, and rupees 1 crore 11 lakhs as well as another plot owned by her bearing number 016/2-1 measuring about 1925 square feet with a variable interest rate at 10% per annum. Petition was regular in payment of the loan till COVID-19 pandemic. And because of that, and during that time, the Reserve Bank has issued a circular dated 5th May 2021 granting moratorium during the period of pandemic. On the basis of the request of the petition, the respondent too has restructured the loan. The restructuring of the loan is in total contravention of the circular of the RBI dated 5/5/2021. Without any basis, the respondents have classified the account as NPA and a notice was issued under Section 13(2) of the Surfacer Act. Thereafter, the Persian notice under Section 13(4) of the Act was issued by the respondents. The petitioner has made substantial payment pursuant to the directions of the court in earlier rate petition. However, without giving the details of the amount, the respondents have brought the subject property for public auction by fixing the reserve price at rupees 14 crores, which is substantively less even compared to the value by prevailing in the area. The petitioner has raised contention with regard to what is the outstanding amount. It is stated that the respondent bank has issued a e-auction notice putting the subject property to sale on 7/3/2025, fixing the reserve price of the subject property at rupees 14 crores, and also called upon the petitioner to pay the entire loan amount of the sum of rupees 8 crore 9 lakh 634 616 payable in respect of the all 4 loan accounts. It is a grievance of the petitioner is the property which was valued in the year 2013, 2023 at 18 crores. The bank has put the reserve price fixed at 14 lakhs. Further, as per the valuation certificate placed before the court by the bank, according to the petitioner, the extent and as per the sale notice is 24,000. Where do you get that?
Annex A, page number 60, 24,450.
Is 24,415. But as per the valuers,
Page number 188 of their statement of objections.
as per the valuation report placed before this court, they've considered 13,590 square feet. It is a contention of the then counsel for the petitioner that the manner in the auction notice is issued and fixing the valuation at the reserve price and also the extent of the built up area all suffers from there is a clear violation of the rules under the Surface Act. It is submitted that as per the 2023 valuation, which is placed before the court,
Page number 52, my lord, starts at page number 52.
52.
Relevant page. Page number 56.
it says that the market value of the property is 21 lakh 16,057, 21 crores 16 lakhs 57,000. The realizable value of the property is 19 crores 4 lakhs 91,300. For sale value is 16 lakh 93,000, 16 crores 93 lakhs 25,600. The guideline value of the property is rupees 14 crores 53 lakhs 75,740. It is submitted with the land counsel to the petitioner that there are movables in the property, and along with the movables, they have sold the they have put the property to auction. There is no list. The notice does not. It is submitted that the respondents have failed to follow the procedure as contemplated under the securitization, the surface rules. The London Senior Counsel, appearing for the respondent bank, submits that the Property is now sold at rupees
20
21
crores,
lakhs.
12 lakhs.
21 crore,
20 crores, 12 lakhs, 50,000.
20 crores, 12 lakhs,
50,000.
50,000.
There are 6 bidders who have participated in the auction.
And 6 bidders have participated in the auction. The valuation report of the bank is also placed before the court. It is stated that the, where do you get that permission, that
Along with the memo, they have filed it today, Milord.
Building plan.
wherein they have mentioned that sanction plan of as per the sanction plan, built-up area is 19,542, but the actual built-up is 25,000.
25,808.
24,415 actual built up area.
Physically available is 24,000.
Physically available area.
25,808.
According to them.
Available area is 24,000.
What is physically available is 24,415 square feet.
That is the super built up area.
Super built, including super built up area.
Compound, beampound, up. They have computed all those
all
things.
corridors, everything.
Possible, but
Actual
the
built-up
actual
area.
built-up area which is available is to 24,415 square feet.
Super built up. Actual built up area is about 21,000 odd, which is
Where
shown.
do you get that?
My lords may kindly see in the
No,
valuation report
from
itself.
this,
In the valuation report
The
itself.
same
is
report
there.
it is
For where,
there.
which
At the
column?
bottom, road for point
Well,
four,
now you
which was. My lords may kindly see the valuation report which was filed by the bank itself. At the bottom, my lord, built up area is 21,415. Super built up area is 24,000.
Where do you get that?
Bottom of page 186.
My lord, the learned senior counsel had pointed this out also. My lord, if my lords were to kindly come to the valuation report of the bank.
It is not in this. They said
It's in the
they are
statement of
trying to
objection,
rely upon the,
which was
rely
just
upon
pointed out
the,
towards the bottom.
rely upon the valuation slip, valuation report produced along with the statement of objections, not in this.
186. Page number 189, I stand
From
corrected.
this I am asking.
Same, this valuation, Lords. In this valuation, your lordship will get at page number 2, 19,542. Actual built up area is 25,808.
Correct, your lordship.
At the
right.
time, Lords, when the valuation is taken. Now, whatever valuation is taken is of the existing construction as on the date of sale. 300, 400 square feet, my lords.
Everything has to be supplemented by arguments.
Lords,
Paper doesn't say
it is,
so.
Lords, it is there in, if the report is seen at 189, it very specifically says what is the actual area of construction available.
So then whatever that is, what, everywhere it should be reflecting the same. It won't be one paper,
Can I just-
one valuation
May I
report.
just, Lordships may kindly see the security agreement, my lords. Because they cannot go beyond the security agreement.
Bank can go beyond and find all these documents.
Lords, now what happens, this is outsourced. They will give us the report based on the inspection because the bank will not
The
conduct any.
bank will blindly go with whatever that is.
Lords, so that is how, because bank will not go for a physical inspection of any property. That's a fact. The Lordship is aware, no bank goes for the physical verification of the built up area.
There shall be some connection between the documents that's placed before the
Lords,
court.
yes, can I just pursue, may I just pass this on, my lord, security agreement. Because it's a registered instrument now. Nobody can go beyond this instrument. It binds both parties.
Security agreement is used along with the
Then your
statement.
valuation report also should be in consonance with that.
My lords, my lord, that is at the time of granting the loan. Now, whatever is now being sold, it is in consonance with the security agreement.
No, the built-up area have come down from that time to
My
now.
lords, that's the reason why I said, my lords, if the built up area is in consonance with the security agreement indicates what is the secured asset. If your lordships were to go by the definition of secured asset, it is what is included in the security agreement.
Apart from going to the definitions and everything, the bank itself.
I understand, my lords. My lords, this 300, 400 square feet of difference, if this has really resulted in some miscarriage of justice, I will definitely say, my lords, it should not be.
If that
Some
is the case, we
miscarriage should
can't-
be shown.
If that is the case, we shouldn't, bank will do whatever they want to do. They are governed by certain rules.
They are,
And
lords,
they have to look at it.
this is the reason
Every
why I
time-
said,
No,
lords.
every time the bank councils will come and tell the court what is law, what is rule.
No.
That should apply
Lords,
to
I am
them.
not getting into the rules at all, my lords. What I am submitting is, so far as valuation, physical verification is concerned, the bank officials, this is the set procedure as per the RBI guidelines. This is not something which the bank is doing.
Which generally banks doesn't follow.
Lords, no, RBI says that you will have to get it from the registered valuator. We send the valuator, whatever report he gives, we will take it. This is so far as valuation is concerned. He will say location, this, that, everything he will say. Now, on the basis of the documents which are available, let us assume, my lords, if the evaluator gives a report saying that there is 25,000 square feet as has been done in this present matter.
No.
He would have given the
No,
application.
On the lighter vein, that's how the senior counsel is here. Because one paper is not connecting to the other paper. Now the senior counsel is brought in to make the court understand by supplementing with your arguments.
13,000
Please come.
equivalent here is from here.
And in the actual built-up area, as per the valuation that was done in the year 2000, when the property was mortgaged, it is shown as 25,808. Now, it is submitted that as per the mortgaged, as per the document, it is 24,415. 415. It is submitted that the property, there is no discrepancy in the extent of land, and the property that is put to auction as fetched, even as per the 2023 valuation report that is placed before the court by the petitioner, it has fetched more than 4 lakhs or 6 lakhs?
4 crores 12 lakhs.
4 crores 12 lakhs than the amount that is mentioned in the 2023 valuation report that is placed before this court.
By the petitioner.
Before this court by the petitioner. And it is submitted that now the sale certificate is issued in favor of the auction purchaser. The petitioner cannot question when already the sale certificate is also issued. At this point of time, the petitioner cannot seek these release before this court when he has an effective and alternative remedy to approach to file an appropriate application before the debt recovery tribunal.
May I just intervene here, Miller? The writ petition has been filed prior to the sale, even prior to the date of, it is filed on 5/3/2022. Yes.
As on the date the writ petition is filed, the sale was not conducted and the sale certificate was not issued. It is now he has filed an amendment petition.
Yes.
Questioning the sale certificate.
Yes.
Questioning, it is not ordered.
It is not ordered yet.
Questioning the sale certificate. The land council appearing for the auction purchaser submits that you are put in possession of the property.
I'm in possession, my lord. There was an order passed by this honorable court in a different matter where the registration happened pursuant to the orders passed by the honorable court.
Submitted that as per the orders passed by this court.
In
The
WP
registration,
number.
the bank has registered the sale certificate.
Sub-registrar has registered the property in our favor because the sub-registrar is not registering.
The property was registered. They submitted that there is no illegality with the sale and this court exercising the jurisdiction under 226 cannot interfere with the same. Having heard the land counsel for the petitioner and the land senior counsel, the counsel appearing for the auction purchaser, there is a material available on record. The petitioner has raised several questions before this court with regard to the reserve price fixed by the bank with regard to the extent of the built-up area. This court has perused the different valuation slips, valuations at the time of granting the loan in the year 23, and with regard to the extent of the property also. There is somewhere it is shown as 25,000 actual built-up area. According to the bank, it is 24,400 and odd. The submission that is made on behalf of the bank, as far as these discrepancies is concerned, this court is not able to appreciate the said submission. there should be some connection between the submissions that are made with at least with regard to what is the extent of the property. It is submitted by when a senior counsel is, bank is conducting all this, in consonance with the guidelines issued by the Reserve Bank of India from time to time. They are following the procedure. At this stage, when already the sale certificate is issued and registered, and several disputed questions are raised by the petitioner before this court, which this court is not inclined to go into the same. However, the petitioner is at liberty to question the sale certificate that is issued and the manner in which that is sale conducted by the petitioner. The petitioner shall approach the DRT within 4 weeks from the date of receipt of the copy of the order. Uninfluenced by any of the observations made by this court, the DRT shall dispose of this. Not necessary, that is not ordered. Yes. Yes. Don't have to tell, that will be there in every order. Yes. Oh, it will be there in, yes.
15.1.
Connected, my lord, same, it's by a tenant.
Petitioner in this case, my lord.
And should be a tenant, my lord. Tenant, my lord.
You also go when the 16.1 is filed by the tenant in view of the orders passed in WPD 6538 of 2025, filed by the owner of the property. Whatever the remedies that are available to the tenant, you can avail the same before the DRT.
So grateful, Madam.
Yes, next.
Bill number 17.
This go before the DRT.
I'll just point out, Manoj, I'll just leave it at that. I will just point out. Facts narrated by me, they have no answer to that.
No, before that, you approached the NCLAT, filed an application under section 10. Thereafter, the same was dismissed for default, non-prosecution. Then before the DRT, 3 applications are.
I just point out, Manoj, this is.
Section 14, you have questions, and you have questioned the sale notice. No, this measure also what is taken under 13, I mean the NPA, that also can be decided.
I'll just point out, Manoj, why your lordship is required to exercise the jurisdiction in the matter of this kind. Manoj, I'll just place some reliance on the judgments, because the entire exercise which I can see from the bank is, I said, look, bank is defaulting on 2 aspects. Your lordships, the third aspect your lordships clarified, I'll not get into it. So not even a single statement made in that regard, because this is born out of the bank's records. Whatever I am now submitting is born out of the records which they have given me. Now it doesn't end here. Lordship wants to go to the DRT, NCLT. On what basis do I want to contest the proceedings? I still remember, my lords, when I was watching this, the American lawsuit series, one of the common term which is used is you bury them in paperwork. There's a very common phrase which is used. That's what we did from the day one when we went before the DRT or the NCLT. We said, we don't have documents, please give us the documents. We have made a list of the documents. I'll take your lordships to that order. Then that there in that NCLT, when before the DRT and NCLT, when we made this application, the application, they did not even file objections and they kept on taking time. First time we came before this honorable court saying that, look, the documents are not being given. What did the bank say? I mean, that's what we are asking. We are asking for our own documents. That is the documents which is maintained by the bank pertaining to my accounts. They said, no, they are already made this request before the DRT. Let them make the same request. We again went back. Again, they started taking adjournments. Then again, second round, we came before this honorable court. After one of the rounds, we said, you are asking us to go there, here, where, everywhere I'll go. But where are the documents on the basis of which I can build my defense? All the documents are in your custody. Where should I go and contest these proceedings? This is essentially what I said. Then, my lords, the coordinate bench intervened in the matter, directed that you are required to give, my lords said, ask them to give about 7-8 documents, but this Honorable Court directed about 5 sets of documents is required to be given in relation to each transaction.
He says they are
Lords,
given now.
pardon me, Lords.
He says here they are given now.
That is the reason, my lords, if they file an affidavit of affidavit, because they can't just like that casually make a statement. I will show from the records which they have given to bury us in the paperwork. They have given, can I just persuade your lords, my lords, I'll just file this memo. Unconnected papers, not pertaining to my transaction, they have given it.
What did you ask? Where is that? In
Lords,
which
kindly have a look at
petition?
the order, my lords, first.
In which writ petition?
Restriction number, sir.
I'll just point out to that order and then place the memo, my lords, what documents they have given us till date.
Which writ petition?
Lords, that is 411 in the synopsis, correct? Huh? No? Lords, if your lords were to take WP 10807, 401. I'm sorry, 411. In WP number 10807 of 2024.
Yes. Order. Which date is the order?
Lords, this is the order dated 27th February 2025. Lords, I'm sorry, my lords. This is the order passed by the coordinate bench in another writ petition, which is produced as annexure. Lords, it is produced as at page number 411 in the writ petition papers. That is in volume 2, annexure CC.
Yes.
Lords, learned counsel for the petitioner submits that the petitioner is availed packing credit limit, that is PARS and PCFC ST, for execution of work orders, and the petitioner is before the court only seeking directions to the respondent bank to furnish certain information.
The documents given to you.
My lords, now I'll just place this memo, my lords. If they want to dispute this memo, let them file an affidavit. As your lordship said, I'll straight away go to the DRT. No difficulty. I don't have anything to defend myself. They are hoodwinking the entire process.
What is that memo?
Lords, this memo shows whatever documents they gave pursuant to the direction of this honorable court is not even 10% of those documents which was directed to be given. They have just multiplied the papers and then given because they wanted to bury us in the paperwork.
Yes.
Let them file an affidavit that they have given every single document as directed.
Can I make a submission? Please look at the order in WP number 1439.
I'm looking at.
Please see what the honorable court says. Now, my lord, they wanted, they invited the paperwork. And my lord, I thought that they were happy to be buried in that paperwork. Kindly see the paperwork that they wanted. Having gone through the, kindly see para 2. Having gone through the prayer, this court finds that the petitioner is seeking full details of petitioner export bills, which the respondent bank has considered for crystallization, which were claimed to have been signed by the petitioner and petitioner's customer for export bill collection, negotiation, purchase, discount, signed application for request for payment from petitioner customer, and their bank details and details of payment sought and rejected. Statement of current accounts, all accounts. Everything has been produced now. If the paper is,
I'm telling, let them file an affidavit. With reference to each one of them, I demonstrate that they'll be filing a false affidavit. If they're making that statement, it's a false statement. I'll file this memo. Let them go through the memo and make their submissions.
There is no need. I will make my submissions if my lordship will permit me.
Lords, this is already served on them. It's already served on them.
Yeah,
Milords, we have filed a memo. That memo is already filed. It is sent by mail, is what I am instructed. That's all right. If it is not, sir, let them have a look at it. Whatever single scrap of paper which they have given, I have described in my memo, saying that this is what you have given. This is not in any manner related to the directions issued by this honorable court in WP number 1439.
Can I respond to what my learned friend is saying, if he will kindly permit me? Well, in response to the court directions, we have produced all the documents. Now, my lord, even if there are some documents which according to the petitioner is not available, they are not helpless. Even in the proceedings before the DRT, they can ask for discovery. They can ask summoning documents. Please look at the rules of the DRT. They have the powers of a civil court insofar as discovery is concerned.
Into any day, but there is an order
By
against
the
you.
High
That's
Court.
been done.
But
Well,
you have
according to us, we have done it. In WP number 1439, there is an order. Now, kindly see the document that have been produced. Please see the document that have been produced.
That's filed when?
My lord, it was filed in 10. Oh, and there are two writ petitions, my lord. I think both of them are filed on 12/8/2025. It is filed on 6 September 2025. I mean, I think it must be a fairly bulky. It's a bulky. I don't know whether it's here. But let them take copies. Let them do inspection. Let them do everything. In fact, they can do whatever is necessary. Now, my lord, my learned friend.
There are 7 volumes.
My learned friend submissions, my lord, because this is, if I may respectfully say so, my lord, we are going beyond the discipline of pleadings. Kindly see the pleading in the writ petition. What is their case? All that has been produced today is against the order passed by this honorable court. Please see one order passed in this writ petition, where your lordships have said, kindly, synopsis. Lord, I am now asked to defend in arguments whatever has been told by them in arguments.
Can
Lord, what your lordship said, my lord,
persuade my learned senior friend to look into the rejoinder. We have said everything.
If you don't mind. Yes. As I indicated to your lordship, my lord, I have been educated on the crystallization concept by my learned friend. I am grateful to him. In many cases, my lord, what happens is,
the compliment you gave, he didn't hear, he was not there.
I know, I'm giving it, and that's the reason why I'm saying it. In many cases, my lord, the fee we earn in a case, we forget after some time. We don't even know how much money has been, what fee we have charged. But what remains with us forever is what we learn by opposing counsels like my learned friend. By what we are told, my lord, by lawyers like Vignesh. These remain with us for all time. So, my lord, I do not consider, from my point of view, as a waste of time, but from the court's point of view, it's a waste of time. Though, my lord, because I'm not talking about the individual judge, my lord. For the individual judge, it is always a pleasure to hear a counsel like my learned friend, for whom I have not only respect, I have great affection. But as an institution, it's a waste of time. That's a serious issue. Reason why I say so is, please look at your lordship's order. Synopsis. It should be in some pages and there.
246.
Please look at one order that your lordships have passed in this writ petition. And I want to show to your lordships what is the ground in the writ petition and what has been argued and what are the documents filed.
WP?
We have gone beyond that point. There are multiple orders passed by the court because this was the very stand taken. Because we have traveled beyond that point, my learned senior friend was not there. This was the preliminary objection which was raised on behalf of the bank. If your lordships were to kindly have a look at the order sheet. Then this honorable court.
I'll just, if you don't mind.
Pause. If you
want to argue, finish it off. Once and for all.
I just point out, because what my learned senior friend is telling me is essentially what they had stated at the first instance. I'll just show it, and then I.
Order date.
8/4. This is one order. If your lordships were to see the order dated 8/4/2025.
Yes.
Lord, this is where this honorable court took cognizance of the fact that the documents as directed has not been given, and therefore this will be remaining in force. Lords, this is essentially what I said now, my lords, is what was taken cognizance of by the coordinate bench and this order was passed. Then your lordships may kindly have a look at the orders passed on 31/7/2025.
Yes.
Same submission, my lords. So and so submits, the learned counsel for the respondent bank are heard whether there must be some interim arrangement given the interim orders that are granted by the coordinate benches in the disposal of writ petitions. So and so must be disposed of by relegating the petitioner to canvass all grounds in the pending applications before the DRT concerned in view of the apex court judgment in Virupaksha. So and so proposed to contend that court will have to examine the petitioner's grievance against the declaration of the loan accounts as NPAs in the light of the fact that documents which are directed to be handed over are not yet handed over. Learned senior counsel submits that the proposition exposited by the apex court in the aforesaid decision may not apply. These and the other submissions will have to be considered essentially address the question whether the writ petition number must be disposed of, relegating the petitioner to pursue the proceedings pending before the DRT with a consequential decision in the other two petitions. Significantly, it is brought out that the documents as required by the court's order are not yet handed over, and when queried, it is stated that the documents would be handed over within a week. Incidental question for the present would be whether there should be any precipitation until the next date of hearing. Given the history of the litigation and the fierceness with which it is fought, the court is sure to ensure there is no multiplicity of proceedings in view that there should be no precipitation until the next date of hearing, ordered accordingly without prejudice to the respondent's bank to oppose to continuation next date of hearing. Then again, my lords, if your lords were to see orders dated that is 4/9/2025.
Yes.
So and so submits, then so and so senior if there could be any error, it would be for the decree tribunal in the pending applications to consider and will not be for consideration in the present proceedings. At this stage, the court opines that the petition must file very short synopsis, facts germane to its case, along with short synopsis of arguments, with liberty calling upon the petitioner to ensure the copies are served. Then this is adjourned again. Then on 18/9/2025.
Yes.
Then the matters come before. As a matter of fact, you know, I had argued this matter for almost substantial time on 31/7/2025, as also on that is on 4/9/2025. Substantial arguments which we had canvassed. After canvassing, you know, this honorable court expressed.
Surface rules.
This honorable court expressed very expressly that yes, you file the synopsis, we'll consider these issues. If there are contentious issues, we need to consider. Not after the hearing took place, of course, the court did not treat this matter as parted, and we directed us to file synopsis, both of which we have done. We have filed a synopsis in the first instance, and thereafter another short synopsis is filed. Both we have done. So to say, my lords, that this juncture, that after the hearing is commenced, that we should be relegated, is on the touchstone of two aspects.
While you were arguing the matter, you have not brought to the notice of the court that you have already gone before the DRT. Three essays were pending before DRT.
Lords, that is only so far as violation of Rule 8591 is concerned. I have not raised, Lords.
So, but why the DRT can't consider this?
Lords, the reason is this, Lords. Kindly have a look at the language under Section 17. Lords, may kindly have a look at Section 17, Lords, of the Act. What can be looked into? Lord, these are all special tribunals, my lords. We cannot confer them with extra jurisdiction than what the tribunal itself has. Lords, may kindly see Section 17(1).
Yes. Yes.
Sorry, my lords, yes, 17(1). What can be challenged? Any person, including the borrower, aggrieved by any of the measures referred to in subsection 4.
But the Honorable Apex Court has clarified.
I will clarify that, my lords. The
13 to even the other issues, whether it can go back to the classification and all, that can be decided.
Just open that judgment and give. I'll just point out, my lords, the Supreme Court did not go into this aspect at all, whatever I am now canvassing. There are 3 judgments which I'll be relying upon, which specifically went into this question. Of course, it's not by the Honorable Apex Court, but specifically dealing with this issue as to whether the nature and scope, because this is stage-wise process. 13(1), there is a stage. 13(2), there is a stage. 13(3).
I can understand when the other proceedings have not
it
has not come to 13(4). At the stage of this, if you come to the court, then it's a different issue. Now the much water has flown.
Lords, that's the reason why I said, Lords, we are in a position to point out without any facts being in dispute. If they had disputed the facts which I had now narrated, Lords, it's a different matter. And I am really started, my lords, with the submission saying that when we knock at the doors of the court, plenary jurisdiction of the court and the court is hearing matter to say that this is a waste of time of the court. I'm really startled. Not the way. Not ultimately, I may succeed or I may not succeed. If your lordship says that you'll have to conclude, now the Honorable Chief Justice says that all it, the courts can fix. But as my learned senior friend said, my lords, this is a learning process for me and there is a learning process for everyone else. So in this process, my lords, we may take 5-10 minutes extra. That's nothing more than that. But ultimately, when we are knocking that the court's jurisdiction of this plenary jurisdiction of this honorable courts, it can't be said. At the threshold, my lords, it is not that this is something which explicitly there is something which is an express bar. There is something which is created as an impression, which I will read it out to your lordship's consideration, my lords, under what context it has been stated. Not in the context with which they are reading the judgment at all. I will just read the entire judgment because the principles laid down should be understood in the context with which the judgment is laid down.
Without even considering the judgment of the apex court in Virupaksha, what they are relying on in the facts and circumstances. When three applications or three.
That's all the three, yes. It's only challenging the sale.
This also you challenge.
Lords, now that's the reason. Now,
we'll give you the liberty to
Lords,
do
if
so.
lordships, now your lordships are aware, my lords, I have argued the other matter regarding limitation. I'll go back. I just wanted to say this, my lords, how this is happening. This is something where I find that there is something which is amiss. I'll just point out, my lords. Lordships may bear with me for 1 minute, not more than that.
1 minute. And as of now, the outstanding amount is about 100 crores. 100
Lords,
crores.
I wanted to say that 100 crores, whatever they are saying, my lords, it is not.
Council, 1 minute. So 3 petitions here, 1 petitions there, another petition here. These are all like, it is not going to go anywhere. There should be some finality to the litigation.
Lords,
In the pending matters, if this also be decided, then otherwise it's all money that is involved, public money.
My lords, I wanted to say this, my lords. To say that there is a involvement of public money
Yes.
is definitely an aspect which your lordships will consider. If handling the public money, if bank bungles up things and risks the borrower to the present state of affairs, which I'll demonstrate, then who should be penalized? I'll be in a position to demonstrate.
No, once the adjudication is done, courts will not leave.
I will now, my lords, the reason why I'm submitting this to your lordship's consideration is this, my lords. Under section 17, the limited jurisdiction conferred, I will read that judgment, my lords. In the entire context of the judgment, the scope of power exercisable under section 17, subsection 2 and subsection 4. If your lordships were to see what is that the DRT can consider. Its jurisdiction is laid down by bulleted points. You should do only this. That's all what is said. In the context of some criminal matter is said, my lords, in Virupaksha's case, I'll read the judgment. Lords, what I want to submit this is that we are not aware when this NPA is treated, why it is treated. We come to know about it. Before that, these things are done. One thing which I wanted to just point out for your lordship's consideration, my lords.
Yes.
Lords, now there is something called as IBC. We are a company. Lords, in the IBC, the secured creditor is a financial creditor.
Yes.
Who is called as a secured creditor here will become a financial creditor under section 7 of the IBC. And there is a reason why I am submitting this, my lords. If they file an application under section 7 and if it is admitted, board of directors gets discharged. Now, who is required to come and question the fact that there is an error committed by the bank in treating this account as an NPA is the board of directors on behalf of the company. Now they file this application under section 7. My cash flow is restricted is what is reflected, and then the admission takes place. Notice the board of directors gets discharged. Secured creditor comes and sits as the committee of creditors. He is the prosecutor, he is the jury, he is the judge, and he is the ultimate authority who will decide. Who is required to come and question all these things? I say that this is because secured assets is kept out of the purview of IBC proceedings, but not the secured creditor. Secured assets, only if the secured creditor consents it to be a part of the IBC process, it is only then, my lords, this secured assets will become the part of the IBC process. The reason why I am saying this is, they have initiated proceedings under the SURFACE. They have taken this to this extent. Backdoor again, they go back to the IBC and say that no, this liquidate this the resolution professional is required to be appointed.
Now, we have not gone to the
They have
IBC.
not
Sorry.
gone to-
They have
Oh,
gone to the
no,
IBC.
no. You filed
Their
section 10.
application numbers. No, I think my learned senior lords, they are referring to my section
I
10
remember
application.
Yes.
They have gone to the IBC. They have gone to the IBC. They have gone to the IBC. Do they want to make the dispute that statement? They have gone to the IBC.
What I relied upon was the section 10 which they filed.
No, I'm saying
Remember
about.
what I'm saying? What is
I'm
this?
saying about something else.
I don't know what.
They went before the IBC. Not after we raised all these disputes, saying that this is what the difficulties we are facing.
No.
We don't have the documents.
That application under 10 is filed by whom?
Lord, section 10 application is filed by us.
That's
Lords,
what is. That's
no,
all
no, Lords, what I am submitting is something else. I am not referring to section 10 application. I am referring to a fact that a secured creditor becomes a financial creditor under section 7. After initiation of proceedings under the SURFACE Act, where the secured assets is completely out of the purview of the IBC proceedings, unless the secured creditor consents, they go and file an application under section 7 before the NCLT under the IBC. Now, once the moratorium is declared or once the matter is admitted, the interim resolution professional, subsequently the resolution professional comes in. Result of this order is that the board of directors are not there. Who sits as the board of directors? He goes and sits there as the board of directors.
But anyhow, that we don't have to go.
Milords, the reason why I am submitting this is
Default.
Milords, where is that? If I am knocking at the doors of this honorable court, Milords, because we have gone to the DRT. I'll just point out, Milords, Lords, may kindly take this WP number because we have a difficulty. It's not that we just like that come. Lords, may kindly take page number 332 and onwards in WP number 10807 of 2024.
Yes. Yes.
Lords, from page 333.
Yes.
IA 101 of 2024 was filed seeking documents. Then put up this matter for arguments on IA 101 as requested. Adjourned at the request, next page, page 334. Adjourned at the request of the counsel for the bank to hear on 18/12/2024. Applicant so-and-so seeks time to file reply on IA number so-and-so and also to furnish copies of the documents if found with them. Defendant's Yamini advocate put up this matter for reply and arguments. Counsel for applicant bank by proxy so-and-so not filed. So-and-so submitted, defendants filed with a prayer for directing applicant bank to produce documents listed in the schedule. IA is placed before the PO for further proceedings. Then applicant seeks time to file the reply on IA number 101 of the defendant, put up for reply of the defendants on Lords, wherever your Lordships is finding applicant is the bank. IA 101 of 2024 of the defendant. Lords, now when we file this application before the DRT, they merrily take time and the DRT merrily keeps giving time. Now what has happened in this process? Lords, may kindly take the synopsis which we have filed. Lords, if not for the intervention of this honorable court in this writ petition, I would have been only arguing for academic purposes. I would have lost all the properties. I just wanted to point out one malice on the part of the bank. Lords, with all these things happening, we were not aware. We went to banking ombudsman. That's only when we were told. Even at that stage, I went before them saying that, all right, please do one thing. Give us the permission to sell some properties. Whatever is the immediate due, we will discharge this dues. This was immediately after this 2023, we went to the bank. Lords, I'll just point out that document, Milords, what the bank did. In the synopsis filed at page number 26 crores. Selling at 26 crores. My notes. Permission, second synopsis. Lords, in the second synopsis filed on 16/9/2024 at page number 82. I'll just point out, Lords, page number 82. NOC letter dated 18/4/2023. The second synopsis dated 16/9/2025.
16/9/2025.
Lord, this was filed pursuant to the second order of the coordinate bench. We said you will have to file a shorter synopsis, which we have filed it. There we have produced this letter, page number 82. I'll just point out, Lords, what is there in page number 82. 13/1/2023 is the date of this letter. NOC and release, properties are released showing the values at which we are entitled to sell the properties. They say you'll have to sell this property at X amount. Then we are giving NOC. Now these very properties which they have said that I'll have to sell it at 26 crores, 8 crores they sell it. When I asked, I want to sell the property, they say if you are selling it at less than 26 crores, we are not giving you NOC. So therefore sell it at 26 crores. After 3 years, 2 years, they sell my property at 8 crores. Where should I go knocking, with all these things happening? Now, multiple proceedings are created not because I wanted it, because I never had any of the documents. Now, your lordships may kindly have a look at that memo which I have filed, Even today, do I have the documents? There is a memo which I have filed, Can I just persuade your lordships may kindly have a look at that memo? Notwithstanding an undertaking given, they actually sold the property and gave sale confirmation. But I will take it. But lordships may kindly see the memo, what they have given us.
Yes.
Page number 8 of that memo, lordships may kindly have a look at that. It is, I'm in a position to demonstrate, that there is something amiss with this bank if your lordships is not directing them to address these two issues. Now, I'm asking a very plain question. Show it to me at least now. Now we have said that this was valid up to 21/7/2022. You could not have crystallized this prior to that date. There was no question. Export bill which you claim is crystallized is already presented and you have encashed. These two facts are admitted now. They are not disputing. There is no contrary argument to that. Factually, there is no dispute. The third one, your lordship suggested, that since this is in August 2023, we need not look into because it's a subsequent event. On that basis, it would not have been treated as an NPA. If these two aspects they are not disputing, where is any disputed question of fact? Because the Supreme Court says that the moment there is a violation of the orders, violation of the guidelines which is laid down by the RBI, it is more than mandatory for the purposes of ensuring that it is brought in tandem with the RBI guidelines. It will have to be done in this fashion. That's page number 8 of the memo, Milords.
Yes. No, that they have not given the document is your submission.
No, it's not that. I have given the description of each single page because I was buried in this paperwork. I have given the entire set of documents page by page. I have given, that is whatever volumes, whatever is directed by this honorable court and what documents they have given has no semblance. There's no relevance at all. Let's see, can I just persuade your lordships to kindly have a look at that memo, my lords? The orders, what has been given. Volume number 1. This is the memo dated 17/11.
With all these volumes, where to see court is not able to understand. There should be some procedure of filing this, I think. All petitioners one side, respondent one side. Now even
can I just make this, Milords? I understand, Milords, that this is another 4 or 5 hours of working of this honorable court and there are other advocates waiting. Lordships may treat this matter as parted and have this matter immediately after vacation. Lordships may not.
No, I understood what your submissions are. I'll pass orders on that.
I am not concluded is what I felt, Milords. I wanted to
Because
still
I
pursue your
understand
lordships on
what
that.
documents in the second petition, what you have asked, they have not given. According to them, they have given. According to you, it is not given.
No, your lordships may have to record it because I have come on record to say that they have not given it.
That I will record.
They have not filed an affidavit saying that we have furnished the entire set of documents. If they file the affidavit, definitely I take steps against them.
No, in fact,
They don't come on record on the orally. They can't submit, Milords.
No, when a writ petition is filed, when there is a specific direction, when they have not followed, long back you should have filed a contempt.
Lords, contempt is filed. Notice is issued in the contempt. Lords, when the notice is issued in the contempt, it is thereafterwards they said that, again this honorable court, they said that no, you give us 1 week, 2 weeks. Like that they went on and ultimately they gave some set of documents which was absolutely irrelevant. Not the documents which I had sought for. Lordships may kindly see that memo, my lords. If your lordships is not otherwise satisfied with the statement which I am making, my lords, then I am in your lordships' hands.
That memo is not traceable. That's the whole problem.
In which petition, sir?
10807. This memo is filed on 17/11/20. ಯಾವತ್ತು ಹಾಕಿರೋದು? ಹೌದಾ?
17.
ಅಲ್ಲ, the memo is filed 4/12. The print date is 17/11, but it's filed on 4/12.
31/7.
ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಟು ಚೆಕ್ ಮಾಡಿ. 4/12.
ಈ ತರ ಇದೆ.
ನಮ್ಮ ಕಾಪಿ ಕೊಡ್ತೀರಾ?
ನೋಡಿ.
ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
ಮೊದಲು ಈಗ ಕೊಟ್ಟಿರೋದು.
I just gave us a copy. We'll give a copy.
Not filed. Just now this showed up on us. They not filed.
Maybe it's not put up.
Yes.
So it's page number 8.
Page number?
8.
Yes.
Lord, this is the first direction.
Yes.
They have given us volume 1 to 4, page number 1 to 1029. Full details of petitioner export bills which the first respondent has considered for crystallization, which were claimed to have been signed by the petitioner and the petitioner's customer for export bill collection or negotiation purchase, discount signed application for request for payment from the petitioner customer, and their bank details and the details of payment sought and rejected. I'll just pause here. If your lordships were to recollect my first part of the argument, this is essentially what we said. Until and unless you do this, there is no question of there being any crystallization. Now, if your lordships were to see what documents they have given up to page number 11, 297. Lords, what all they have given: Sonilex Industries, Jeevan Industries, FEMA application, Kingtexco, absolutely nothing to do with the customer with whom I am dealing. None of these documents pertaining to this transaction in particular. For the loan which I have arrived at, this is not the loan transaction for which this is done. This documents what they gave for this one is not there. Now, if your lordships wants us to go back and say that yes, we want to fight, I don't have the documents to fight, and we know how DRT proceedings are undergoing. And I should go to the DRT only in my capacity as a owner of the property, probably, or a guarantor to the company, because company is not there as of today. They are sitting there in the board of directors of the company.
14 been passed? No, what? I mean, all this
Yes,
is
secured creditor, they are the committee of creditors.
1 minute, sir. Has a 14 order been passed? Has the COC been formed? I mean, I don't know, my lord. There are no orders, nothing here. All that, the simple thing that I mentioned was they.
10814, there is already an order passed under section 7. 14 orders are passed.
14 ಆಗಿದೆಯಾ?
ಆಗಿದೆ. ಅವ್ರು ಕೇಳಿ ಅವ್ರನ್ನ ಹೇಳ್ತಾರೆ.
That's a law.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ, ಇದೆ
ಇರ್ಬೋದು.
ಸರಿ,
ಇರ್ಬೋದು.
ಹೇಳಿದ್ ವಿಚಾರ ಹೇಳಿದ್ ಅಷ್ಟೇ.
ಒಂದಾಗಿದೆ ಸಾಕ್ರಿ.
ಒಂದ್ರಲ್ಲಿ ಆಗಿದೆ.
No, in this company. No. In respect of this company.
Lord, so far as
there
are two companies.
This is all going everywhere, my lord. In respect of this petitioner company, my instructions are there is no such order under 14. What is it that you are saying? Which company is that?
Avishkar.
That is not a petitioner. My lord, I think
Avishkar is concerned. My lords, I wanted to say this.
These
are the two, both the writ petitions are there before your lordships. Avishkar is admitted. Karnataka is posted for hearing.
I am on WP number 24367, which is by somebody else, and that there is no 14 order.
Lords.
But what I mean, I thought that my learned friend was so confident. I thought that I had not been told.
My lords, I am very confident in saying that there are two companies.
No, but is there a 14 order with respect to the petitioner company?
So far as Karnataka is concerned, there is no 14 order, but section 7 application is already filed. Section 7 application is already filed. It is posted for the purpose of hearing on the admission. There is a section 7 application already filed. Now, lordships may kindly see page number 12. Second direction which is given. Full details of the petitioner export bills which the first respondent bank is considered for crystallization, which were claimed to have been signed by the petitioner, so and so. Then again, if your lordships were to see from page 298, absolutely nothing related to the present transaction at all.
I've seen that. You said no relevancy.
Lords, now the customer with whom we are dealing there will be transactions between us, and these are the documents which they have submitted, Milords, is absolutely not of any relevance for what we are seeking. We are seeking very simple, Milords. Once there is an export bill, that export bill for the purpose of its presentation requires consent by both parties. Which export bill has the consent of both the parties which is presented and which is bounced? That's all what we are asking. Now, the reason why I said burying us in the paperwork is because whatever they have given is not that. Whatever they have given, if your lordships were to see, is the Sonilex Industries fifth payment receipt, FEMA application declaration, Sonilex Industries invoice number so and so, which is for the purpose of purchase of certain raw materials, which is now now Milords in the stockyard of the port. Then direction number 3 at page number 18. Volume number 3 is given pertaining to this direction number 3, full details of the export bills which was responded. Even again, Milords, we have submitted, Milords, that there is not even a single document which has been given which is relevant of what your lordships have directed them to give it. Milords, with this set of documents, there is no way that your lordships is asking me to go and do this. So far as alternative remedy is concerned, Milords, it's very simple. If your lordships were to see the judgment in Virupaksha's case, why this principle came about, can I just persuade your lordships to kindly have a look at that judgment, Milords? Why did you not get, last time also you did not get this judgment? This is arising out of a criminal case. The question as to whether this section 17 can entertain the pre-section 13 disputes was not the question at all.
Yes.
Let's the paragraph number 2. Yes. Appellants herein were the petitioners in criminal petition number so and so, which was dismissed by the Karnataka High Court. By orders dated so and so, said order was passed by the High Court while considering the petition of the applicants for offences punishable under section so and so, so and so. Brief facts leading to this situation. Then, Milords, they have stated, as per the case of the Canara Bank, the complaint has not repaid the loan amount. In that view, having committed default, the account of the complaint was classified as NPA. On 15/1/23, the Canara Bank, thus having invoked the powers under 13th of the Securitization Act, had issued appropriate notices. Ultimately, possession of the asset was taken under section 14, and the secured asset was thereafter evaluated and was brought to auction by through the public notice dated so and so, fixing the price at 2 crores 28 lakhs. Though publication was made, no bids were received in the auction proposed on so and so. Accordingly, Canara Bank had revised the valuation, so on and so forth. Notice, if your lordships were to see, then the next portion in the same paragraph number 4. The learned single judge, having considered the matter, about 4 lines from the top, Milords, in para 4. The learned single judge, having considered the matter, apart from taking note of the contentions put forth by the complainant, had also taken into consideration the alternative remedy available to the complainant under the SURFACE Act. Accordingly, dismissed the writ petition with a cost of 10,000. Complainant assailed the said order by the writ appeal. The division bench thought the order dismissed the writ appeal. Complainant thereafter amended the remedy under section 17(1) of the Act, filing an application under section so and so, and also applying the same an application under section 5 of the Limitation Act. Application for condonation of delay and subsequently the main application were dismissed by the order dated so and so. Pursuant thereto, the complainant is stated to have filed an appeal before the DRT. In the said backdrop, the complainant before the complainant on section 200 of the CRPC of the Principal Civil Judge Hubballi, alleging that the officers of the Canara Bank in connivance with the auction purchaser caused wrongful loss, so on and so forth. Notice, it is in this background, if your lordships were to see what has been stated, absolutely nothing relating to section 17 was under consideration before the Supreme Court. Now, lordships may kindly see what has been stated, by the Supreme Court at para 9 is on the principles under Bhajanlal's case for the purpose of quashing. And the relevant portion, Milords, which is now read out to your lordships, is the last paragraph, Milords. Yes. This question itself has not arisen for consideration at all. This was arising out of proceedings, Milords, under the criminal procedure under the Indian Penal Code, for which offences were registered, and thereafterwards this was taken up. The auction, the proceedings was challenged before the DRT and then before the DRAT. Thereafterwards, they filed a complaint and then they said, no, you will have to go before this. But the scope under section 17 never came up for consideration, Milords. The judgments cannot be read as a statute by itself. It speaks of what is dealt with by the judgment. That is essentially, my lords, a series of judgments. Now, there is a compilation of judgments which I have filed, my lords, for your lordship's consideration as to why and in what circumstances the alternative remedy it can be. Because first and foremost contention is that there is no alternative remedy.
It's all settled now, Mr. Senior Counsel.
Pardon me, lords.
With regard to the alternative remedy and.
Lords,
all,
I
it's all
wanted to
settled.
say that alternative remedy, when it is being referred to, should be actually a remedy. Lords, now, in relation, something incidental to it, there is some remedy. Therefore, you take this also to that remedy, my lords, because it's a tribunal with limited jurisdiction.
No, that your argument with regard to 17 hours of what will be dealt with by the DRT, that is clear.
That's
So, I don't think we have to look at all these judgments. You please tell the court which judgment you're relying on and paragraph numbers. That is sufficient.
Lords, I'll
You can let your colleague point out in this.
I have it, Lords. I have a,
Give that synopsis, whichever paragraph is you're relying. I'll consider. Yes, heard, reserved.
very well, Lords.
Yes, next.
Lords, that interim directions, whatever is there, let it continue till the disposal at least, Lords.
Cell number 32. Pass over cell number 32.
Yes.
So the petitioner is in custody.
Hmm.
So one of the relatives are available for amount to deposit. So far he is unable to reach. Kindly have it on tomorrow.
Why is it adjourned? 28, 2025, already there is an interim order. Fails to pay them, huh? Not about that. If the petitioner fails to pay the maintenance or the arrears, the stay granted with this court shall stand automatically vacated without further reference to the court. Long back it is on 28, 2025. This is not after vacation.
Cell number
Yes.
41.
Lords, can I just prepare a short synopsis and then only of the judgments which relevant portions?
Whatever, you can give the.
Colleague will, Lords, Lords, tomorrow I'll give it to Lords because today it may not be. Morning.
Yes, yes.
Lord, appearing for the respondent bank. So, Lord, this is the case where already the essay was pending.
Where is he?
Cell number 41.
After vacation.
After vacation, my Lord.
Yes, next. Wait. 42 call, that no time for that.
Your Lordship,
Cell
42.
number 42.
Happy for responding to this matter. Lords, kindly look at the relief which they have sought. They are challenging, my lords, the award passed by DRT. If they are really agreed by a DRT award, the remedy lies elsewhere in terms of section 18. They will have to be filing an appeal before the DRAT, my lords.
Yes, Lordship, this matter is very similar to in which your Lordship has passed a similar order.
No, that is not a similar matter.
Yeah, Lordship, I come to the same matter. I come to the same matter, your Lordship.
No. In those matters, you are referring to the matters yesterday I've.
Yes, your Lordship.
No, those are all you are questioning the notices issued by the bank, position notice and all. Here you are questioning the order passed by the DRT.
Yes, your Lordship. I am.
That is not a similar one.
Lordship, for this, I will definitely make my submission also because here my right of property and my fundamental rights.
Submission is, DRT has passed an order. Why have you come before this court? Why you don't go to DRAT?
Your Lordship, because I am the lawful owner of this property from
Whatever it is, you have suffered an order.
Lordship, that I was not even party to that order also, your Lordship.
My lords, 2019 is the loan. And afterwards, my lords, after
No, what his case is, he is neither a borrower nor a guarantor.
he has purchased from our borrower. He has purchased from our borrowers, my lords.
Not
First
borrower, your Lordship. I have purchased from the landowner.
1 minute.
2019 is the loan.
When is the mortgage?
2019, my lord. 2019.
When did he purchase?
2020.
Lordship,
whom you have purchased?
I have purchased the property from the landowner and the developer.
I think you can name them.
R2, R3 and R4. As per the petition, I have purchased the property from R2 to R4.
Either of these people are your borrowers?
No.
The borrower is R5.
Well,
think
these
you
are
should
the
come up with
persons
the-
that R2, R3, they are the developers, my lords, who constructed these apartments, and they have agreed to sell to our loanee, the person to whom the bank has lent, my lords.
He has not sold, agreed to sell.
Agreement holder.
And he has a registered sale date.
In the year 2021, February 2021, your lordship. And I am in possession from 21
The counsel
onwards.
for the petitioner submits that he has purchased the property in the year 2020.
My lords, I
And,
have my loanee has got a sale deed much prior to that, my lords.
You're saying an agreement of sale just now.
No, agreed. I use the term agreed, and thereafter there is a sale deed which is prior to my lord 2020, which I can place it on record. May kindly call it tomorrow, my lords. I'll furnish the copy of the said
Tomorrow
sale
it
deed.
is not possible. This matter after vacation, learn counsel for the petitioner submits that neither is a borrower nor his guarantor. He has purchased the property from the builder, from the developer. The bank shall not take any coercive steps against the petitioner.
My lord,
This is matter.
my lord, they will take undue advantage of this interim order to be present.
Lordship, I am in possession
My
from
lord,
last 5 years. Undue advantage, I will
Stated that they
say.
are in possession
My
of the
lords,
property from the last 5
have a
years.
submission.
Whatever is the objection of the bank shall come
My
up
lords,
with their specific objection.
I can make an undertaking before this court. Till next date of hearing, my lords, no action will be taken. Instead of, my lords, if
Learned
interim
counsel
order is
admitting that the
passed.
bank submits that no coercive steps will be taken. So just adjourn this matter after vacation. Yes.
Number 43.
Oblige.
Appear for the petitioner. We
Yes.
question the possession notice, your lordship, in the manual.
Yes, interim order is there.
My lords, ಇದರಲ್ಲಿ 90 lakhs ಇವತ್ ಮಾರ್ನಿಂಗ್ ಪೇ ಮಾಡಿದ್ದಾರೆ 27/6
Yes, after vacation, interim order
Order,
granted
my
is extended.
1
Yes,
crore
next
40
44.
lakhs ಇದೆ my lord.
Yes, next
And
44.
44. Cell number 44.
Yes.
Hemant Rao.
This matter, my lord, can actually be disposed of.
No. For both the senior counsels, only 5 minutes. If it
No, I
can-
think it can be disposed of.
No, 5 minutes. 2 minutes for him and 2.5 for you.
No,
I would suggest,
He
Lord,
gives
that
me,
the
instead
matter
of
is
his taking
listed on
2.5,
19th
I'll only say
before.
what he wants.
Lords, the matter is listed on 19th before the recovery officer. Lords, our writ appeals, since notices were ordered and the matter came up before the registrar, though it was moved before the court, on the premise that some of the respondents were not served, against whom we had not sought for the orders. So now, if any date is given before 19th, the date on which the matter is now posted before the recovery officer, by continuing the interim management, pardon me, lords,
19th of January.
19th of January, any date before that date, we'll move the writ appeal, because now
There is nothing really left in this petition. The petition was because they were summoned by the recovery officer. Therefore, they challenged it before this honorable court. In the contempt proceedings, my lord, an order has been passed. May I just pass it on? Because they did not deposit the money, we had filed a contempt. Now, pursuant to this interim order, they've deposited the money before the recovery officer. Therefore, the requirement of them having.
pursuant to the order dated 23/9/25, yes.
That's what I'm
Lords,
saying.
your lordships have directed us to,
22nd September 2020.
No, no,
It's the order
lords,
in the contempt.
no, contempt has nothing to do with me, because I am neither I am a party in the contempt, nor am I served with any notice. I am not
my
a party.
learned is-
This is the name of
Let
the
me just
petitioner.
explain something. to my
Rameshwar
lordship.
Rao, recovery officer 1.
Mr. Anirudh Gupta and another.
Yes, my lord. Lord, may I just explain what happened? There was a direction by the learned single judge to repay certain sums of money which they had attached and withdrawn. So the recovery officer was not supposed to transfer it to Canara Bank, but he transferred it to Canara Bank. Therefore, my lord, ultimately, we filed a contempt saying all of this has happened and the order of the learned single judge is not being complied with. Then the learned division bench said the order is very clear that you must redeposit it. Therefore, if they don't deposit it, you make an application before the recovery officer. But by which time, Lord, recovery officer directed the officer to be present. Therefore, a writ petition was filed. This honorable court said, no, you would deposit that entire money. Now they've deposited the money before the recovery officer. Now we'll go to the recovery officer as directed, not in the contempt proceedings, and ask for payment of the money to us in terms of the order. If he gets a stay of in the writ appeal, he'll get a stay. But he cannot use this to stop the proceedings before the
Can
recovery
I just
officer.
persuade your lordships to see the orders dated 23/9/2025, my lords? I'm only saying this interim management may be continued till the second week. Contempt, I am not a party. I'm only saying, my lords, The whole reason is this. The money which was due to us, one of the properties mortgaged to us. This property which is mortgaged was acquired by an authority.
No, you're not a party to the writ appeal, I mean, to this order in the contempt.
No, I'm not
But
a party.
that revolves around the very same transaction.
That's the reason why I said, my lords, in the content proceedings, whatever order is passed, is directing them to go and approach the DRT. Let them do it. I'm not coming in the way. Whatever directions is given behind my back, my lords, in the content proceedings, I have no difficulty about it. Let them go and approach the DRT. Not that. Now the question is, if your lords were to see the orders dated 23/9/2025, passed by this honorable court.
Yes.
The petitioner, a bank is aggrieved by the second response direction to its managing director, chief officer, to be present in person on 24/9/25 to show cause as to why action should not be taken for non-compliance of the orders. And order is essentially because of the court's similar orders in WP number so and so and subsequent orders on a motion in one of these writ petitions. Petitioner, in terms of the court's order dated so and so in the opposite writ petitions, will have to refund the amount redeemed to the concerned beneficiaries. As submitted by so and so, for the petitioner, the court's order in so and so is already subject matter of challenge without an interim order. The concerned have also filed the proceedings under the Contempt of Courts Act 1971. Primary question is whether the second respondent could have assumed jurisdiction to direct the presence of the officers aforesaid. Question will have to be heard on the decision, and until then, there must be stay of this direction. The court, on careful perusal of the consideration, is of the view that the petition must deposit the amounts payable in terms of the court's order with the respondent within a period of 3 weeks from today, and the respondent must maintain such amount in deposit, the interest yielding, subject to further orders in the aforesaid writ appeals.
Or contempt proceedings.
Or contempt, that's the reason why, or contempt proceedings, while so directing emergent notices on second respondent on 13/11/2025. Now, if your lordships were to see, what has been directed here, that this has to be done. Now, the DRT is required to decide this matter if they make an application. Now, we are already in a writ appeal. DRT, the matter is posted on 19th. If they are to undertake, that they are not going to advance the matter, lordships may dispose of this matter, saying that, all right, because it should not become a fiat accompli. Your lordships may kindly appreciate this difficulty of us. We are a bank. Mortgage property is acquired by one of the acquiring authorities. Compensation is taken over by them. About some crores is taken over by them. 14 crores is taken over. Once the beneficiary takes these accounts, who is the actual mortgager, he routes this into various accounts of his kith and kin, and ultimately we trace that this money has gone and landed in some accounts. This is what we did at our end. When we place all these things before the coordinate bench said that there is non-compliance of a particular procedure and therefore directed that we'll have to give back the money. Now it is a one-ended manner, in which this is going to go. Because once they withdraw the money, nothing remains for the bank to again go and recover this.
By way of this interim order, what did the court do?
The court says the amount should be deposited. We have deposited the amount.
What is the amount?
Before the DRT.
How much is the amount?
2 crores in this. 2 crores, whatever is the amount was as per the directions of the honorable of the coordinate bench. We have
not 2 crores.
Yes, that we have already paid, deposited. It is already placed in the interest earning deposit. Now I want this leverage, Now they went in contempt. I was not made a party. There is no question of impleading somebody else in the contempt proceedings until and unless they make an allegation that I am in contempt of the orders of the court. Now, as things stands, what I am now submitting is, if they say that let the matter be taken up only on 19th before the recovery officer, I'll move the division bench in the meantime, and then your lordships can dispose of this matter by setting aside this part of the order, because it doesn't remain. The direction was to deposit the money. This honorable court directed to deposit the money. Money is deposited. So question of summoning the officers does not arise. One part of the dispute is over. The second part is, now the matter is before the DRT. If I'm now, we are in a vacation. If I'm not in a position to get this.
No, I'm sorry.
Come to the prayer.
Lordships. Prayer.
If you are appropriate passing the order dated 17/9.
Yes.
Please come to the order at that order.
Direction to appear. That's all.
No, there is
Now
no.
in that they want an interim order for the writ appeal.
No.
That's the reason why I said, the reason does not exist. The grounds on which we have challenged this, if your lordships were to see the grounds on which we have challenged this, is principally, if your lordships were to kindly have a look at the grounds on which we have challenged it. We said that we are in the writ appeal. This should not be done because we are on 16/9/25. The writ appeals were again listed for hearing, lords, which we have stated at paragraph number 9 and onwards.
Yeah.
Is essentially the ground.
Please see the grounds, my lord.
No,
The
9 and
grounds are,
onwards.
there's no power to summon them, that's
It's
all.
para 9 and onwards.
I think my learned friend should not.
Para 9,
Something
on
which is
receipt
not
of the
there
memo,
as a
the
ground.
recovery officer adjourned the matter to 10-9, awaiting the outcome of the writ appeals. However, on 8-9, the writ appeals were listed before the
That
honorable
is
court,
not
were
the
not
ground.
taken up for hearing.
Those are all the facts.
Facts.
Come to
Please
the
see the grounds,
grounds.
my lord. Please see any ground, what he has said.
Lords, grounds, my lords, what we have stated is pertaining to the jurisdiction and the paragraph number 19.
Yes, please.
When the Honorable High Court is seized of the matter in its appellate jurisdiction as well as in the contempt, the recovery officer has no jurisdiction to pass any orders compelling bank to comply with the directions of the learned single judge.
Which order is in appeal?
My lord, order may be in appeal.
No, which order is in appeal?
The order of the learned
The
single.
original
once
order
again,
passed by the learned single
let me
judge.
answer one question at least.
Madi.
Give us also a chance. Yeah, my lord, appearing against my learned friend, this is a problem. I don't know who to argue against. Is it my learned friend or to your lordships? But the order was that there were certain amounts of money which was recovered from various persons to the extent not that it involved amounts which was transferred by someone else, it was not interfered. With so far as money which we had our own money, that also was blocked. Therefore, court said you can't block all those monies, attach it and recover it and take it away. You must return it. Therefore, my lord, I went back to the DRT and said, please return the money. But DRT, what it had done was, by mistake, it had transferred the money to Canara Bank, which it could not have because there was only an order of attachment. Therefore, we said you couldn't have done it. Your transferring is in contempt, and therefore we moved the contempt application. The division bench said
no contempt.
The
division bench said no contempt.
I'll read what the division bench said because I think division bench has articulated it better than my learned friend has understood it. There's a little difference in. Please see, my lord, para 3 of the order of the division bench.
Yes.
There is an unambiguous page 4, my lord. There is an unambiguous direction for the accused to return the amount of 2 crores 46 lakhs 96,002 to the complainant, or 24 lakhs, not in this case. There are different cases within a period of 2 weeks. Learned senior counsel appearance complaint submits. Amount has been transferred by accused to Canara Bank. Said amount is now required to be recovered from Canara Bank. We find there is no ambiguity in the order. Accused shall therefore initiate proceedings for recovery of the amount from Canara Bank. If the accused fails to do so, the complainant has a remedy of approaching DRT for enforcing the orders already passed. Needless to state that as and when the DRT is approached, tribunal shall pass an order in conformity with the orders passed by this court. Therefore, Lord, this is the order. What they do is, when they are summoned, they come and file this writ petition, then they deposit it before the DRT, and then now they want, basically this is it, they want an order which they did not get in the writ appeal. Before your lordship saying, don't allow them to recover the money until the writ appeal is disposed of. That is really saying your lordship is not acting as a division bench in this matter. That can't be done. You challenge the order summoning. The order summoning has today become infructuous. Therefore, my lord, that can be closed. And so far as anything else is concerned, we'll make our submissions before the recovery officer.
Lords, I am making a statement. If they undertake that, they will
I'm
not
not
advance the
undertaking.
matter. Lords, it is something
Not
like this.
undertaking.
Yes,
They
if they undertake, they are not going to advance the matter
I'm going to
before the
advance
recovery officer. Lords, my difficulty is this. If they take the money, I will not get this money. We are a bank. It's a public money, my lords, which is
That's not
gone.
the scope of this writ petition.
No, lords, there is scope of this.
We questioned the order that's passed by the recovery officer.
Lords,
asking you to
that
appear
can be
before
done, my lords. I have no difficulty. Your lordships had already passed an order taking it into cognizance that this is subject to the orders to be passed in the writ appeal or in the contempt proceedings.
Yes.
Contempt proceedings, my lords, if your lordships have already seen paragraph number 5, they have to initiate proceedings for recovery of the amount from Canara Bank. This does not remain. If the accused fails to do so, the complainant has a remedy of approaching the debt recovery tribunal. So the complainant has to approach. If the recovery officer does not pass an order, there is a remedy to the debt recovery tribunal for enforcing the orders. Needless to state, as and when DRT is approached, tribunal shall pass an orders. Now, what was not brought to the notice of the division bench in the contempt proceedings was that they had already entered caveat in the writ appeal, and the fact that the writ appeal was already pending. Lords, what happened? Matters was, that's the reason why I took your lordships to paragraph number 9 and onwards.
They're traveling beyond the scope of the writ petition, senior counsel.
Lords, I am not saying anything, my lords. The lordships may consider the fact. I just point it out, my lords.
Yes.
Lordships may kindly consider that if this money is gone, I can't take it
By
back. It's a
any
public
order-
money, my lords.
By any order that is going to be passed, please 1 minute, by passing any order from this writ petition, nothing is going to happen. You are only aggrieved by a particular order. Now that worked out. You don't have to.
That is
appear
spent itself.
before-
That
Then
is spent
what else-
itself. I
what
have
else
no.
this court will decide.
Lords, that is the reason why I said, my lords, while passing an interim order, this honorable court has taken note of the fact
Here
that
at the final stage, interim order will.
that's true, my lords. This honorable court has taken note of the fact that there is a writ appeal which is already filed and pending.
The present writ petition is filed. Questioning the
If your lordships can have this matter immediately after vacation, my lord.
79.
Now, the reason is this, my lords, can I persuade your lordships on this?
For the recovery
Let it be
office
taken up even on the reopening day, my lords. I'll try at least my luck in the vacation bench.
for 491 of 2017. The facts of the case are the petitioner before this court is a Canara Bank. The petitioner bank has filed lawyer number 346 of 2008 against Chamundi Industries Limited and others before the DRT Bangalore, and the same came to be allowed on 15/9/2015. Then a recovery certificate for a sum of rupees 43 crores 44 lakhs 89,664 paise 43 was, along with interest and other charges, was issued by the DRT by order dated 15/9/2025. The bank initiated the execution proceedings because the recovery officer 1 DRT. During the course of the said proceedings, it came to the knowledge of the recovery officer that one of the immovable properties, which was mortgaged to the bank, was acquired by the KIADB, and the defendant number 6 NOA fraudulently received the compensation of rupees 16 crore 61 lakh 34,879 on 28/10/2016 by filing a false affidavit that she had lost the sale deed of the said property, and the said amount was diverted to the family to her family members. On 28/10/2016, on the same day, the compensation was received by one Mrs. Sarvan Kumari has transferred a sum of rupees 50 lakhs and 50 lakhs 58 rupees to the respondent number 1 herein. In turn, the respondent number 1 has invested the said amount in various mutual funds through his wife and son. In the light of the same, the recovery officer has issued various orders of attachment, attaching the bank account of respondent number 1. The respondent herein has filed a writ petition before this court. What is the writ petition filed in respect of this?
There is a next page.
WP
Lordships
number
have all the
4060 of 2017.
There are
480?
4 writ petitions.
Of 2017.
Totally, there are 4 writ petitions.
No, in respect of this.
In respect to this note, there are 4 different persons. So 4 different persons filed 4 different writ petitions.
Here they are taking the name of only one.
One note. That one was filed in 44799 of 2017.
44799 of 2017. And an order came to be passed on 19/6/2024, where the attachment order was quashed. Liberty is reserved to the recovery officer DRT for passing appropriate orders. It proved that petition is holding money on behalf of the defendants. Against the said order, writ appeals are filed by the bank. In the meantime, the order impugned is passed by the recovery officer. Where is the order?
Annexure A, page 17. Actually, page 19. Type copy is 19.
Whereby the Canara Bank was directed to comply with the order immediately and to file the
No, directing the presence of the MD and CEO.
MD and
That's
CEO
all.
for compliance of the order. Further directed the CGM within brackets recovery to remain present before the tribunal on 24/9/2025 and to file an affidavit as to why action should not be taken for the non-compliance of the orders dated 13/8/2025. This order, when this was questioned before this court, and a coordinate bench of this court has passed an order on 23/9/2025. Where is that order? The
23/9/25 minutes.
20?
23/9/25.
In this writ petition.
In the present writ petition.
From order concern have also submitted. The primary question is whether the second respondent could have assumed jurisdiction to direct the presence of the officers as aforesaid. And this question has to be heard for a decision on merit. Until then, there must be a stay. However, directed the petitioner to deposit the amounts payable in terms of the court order with the second respondent within a period of 3 weeks. Pursuant thereto, the petitioner herein has deposited the amount. Even the In the petitioner has filed a contempt.
Respondent has filed the contempt.
The respondent has filed a contempt. That is contempt, that is 974 of 2025. That came to be disposed of on 22nd September 2025. The same was, the said contempt was disposed of. And the division bench has observed that there is no ambiguity in the order of the then single judge. The accused shall therefore initiate proceedings for recovery of the amount from Canara Bank. If the accused failed to do so, the complainant has a remedy of approaching the debt recovery tribunal for enforcing the orders already passed. The senior counsel appearing for the bank submits that as the writ appeals are pending, till the orders are passed with the till the matter may be posted after vacation, they will take the steps to argue the writ appeal. It is submitted that if the amount, it will be very difficult for the bank to recover the amounts. It is submitted that the matter may be adjourned after vacation. Senior counsel appearing for the respondent submits that the order that is impugned before this court is the direction issued by the recovery officer directing the CGM recovery to remain present. Now there is no such occasion for that. Now as the amount is deposited by the bank, the CGM need not appear before the recovery officer, and this issue has become more of a academic issue. Having heard the senior counsels on either side, as the bank has already deposited the amount, now the question of appearing before the recovery officer does not arise, as he has already complied with the order. With regard to the amounts that are the submission of the senior counsel, that if the amounts will be transferred to the other accounts, it will be difficult for the Canara Bank to recover those amounts. Even if this petition is pending, those issues cannot be decided by the court in this petition, and the remedy is elsewhere. And that view of the matter, that they can pursue the division bench in that view of the matter. The petition is nothing remains to be adjudicated in this petition. Accordingly,
Let them undertake, they'll not withdraw it for a period of 2 weeks, my lords.
This we can't.
Because
It's not the scope of the writ petition.
I understand, my lords, but if your lordships were to see it's a public money involved, whenever your lordships is passing orders, my lords, any
Public money involved, at the same time, what is the list before the court? And what is that, that is, we are going beyond the scope of the writ petition. That's
very
what
well,
the
my lords, I leave it at that.
Yes, next.
Still number 45.
For the petitioner.
Yes.
On the last occasion, I had made submission that they had lost the survey report, after which I had undertaken to conduct the survey. Survey is conducted. 5-6 days, we'll get the report.
Yes, Mrs.
Miller,
Mata,
Miller,
after
kindly see the
vacation.
order passed by this honorable.
Still
This
number
unconditional interim order
46.
is operating against me.
My lords.
Kindly see the order for a moment passed by this honorable court last week. Okay.
What is that?
Kindly see the order passed by this honorable court on the last week. Miller, first and foremost, Miller, I never misplaced the survey report submitted by them.
Matter on 18/12, when by the time survey shall be completed, or else the court will pass orders on the benefit.
Survey is completed, my lords. Report is awaited 5-6 days. They'll give me the report.
This is matter after vacation.
Miller, date
Kindly.
tomorrow earlier granted. Some date in the first.
I request for the matter to be taken as parted since we have argued the matter.
Parted with Miller.
No, I'll be sitting only in surface at parted.
46.
I'm grateful.
HS Prashant, 46.
Yes.
Prashant HS.
Miller, it's the same matter, Miller, two petition by the same petitioner. One is Miller, one account Miller some 8,30,000 rupees. One account Miller some 30 lakh.
Yes, yes.
Today filing.
There is nothing to be, no arguments. When are you going to pay the money? That's the only submission I want to hear. Otherwise, the repetitions are not maintainable. I'll dismiss them. Both the repetitions I have to dismiss.
1 month, I think.
Huh?
1 month. To communicate the party.
Undertaking? Affidavit. When will you file?
Next day.
Huh?
Next day.
What is
Miller,
it?
in respect of second petition, Miller, they undertook before this honorable court, saying that I will clear the Miller first loan. so that my account can be regularized. This is undertaken given by before the honorable court. Pursuant to that, the honorable court passed on.
We are going to, I said I'll dismiss both unless the undertaking is filed.
Interim order is operating. They played a fraud.
They're going to, he will file it tomorrow. Affidavit tomorrow, or I'll dismiss it today itself.
Tomorrow file affidavit.
Huh?
Tomorrow file affidavit.
For filing of the affidavit, list the matter tomorrow. Yes, next 48.
Interim order may kindly wait.
Interim order is extended till tomorrow. Yes, 48.
47.
Respondent 1 year.
7, yes.
I am the neither borrower nor the mortgage of the property. Where the respondent 3 had obtained the loan. The bank
Respondent 3.
2.
What is the relation between you and the respondent?
They are my father's brother.
Father's brother.
Where the exchange deed had been taken place, father's brothers had been executed the deed to me in the year 1977, where the mother, including mother, father, mother, had been executed an exchange deed to me. Based on that, I had revenue entries had been obtained in my favor. Thereafter, before obtaining the loan, where the respondent grandmother had executed a gift deed in favor of the daughter-in-law, as against she obtained a loan, and nowhere concerned with me. Where the proceedings against me, where the revenue entries were which had came to me, I had been challenged before the.
Which year is the mortgage?
2022. 2019, my lord, this gift deed executed in my favor. Wherein, my lord, 30 years, from last 30 years, the property stands in the name of, my lord, those who are donee. And, my lord, we have taken the, my lord, legal opinion as well as all 30 years income certificate. Now, all petitions.
But he says revenue records is
No,
named.
it's not so. My lord, can you see the value?
The document to show
Yes.
that revenue records reflect your name.
My lord, in fact,
Show it.
Annexure D and D1.
Page numbers.
Page number 65.
Yes, Mr. Vignesh Shetty, look at it.
Kindly look into annexure C1 one. Page number 57.
57. Look at 57.
57. After exchange deed executed on 77. And
No, you are referring to the like from the last, right from 1973, your name is reflected in the revenue records.
Yes,
Is
ma'am.
what you are saying. Where are the revenue records?
57, page number 57. Translation version.
57.
NM Chandrasekhar.
Transfer to as per MC number so and so.
As per MC number so and so.
You're
He occurs
saying
in the
something
15
about 73. This is an MC of 1997.
Yes, 97 itself, the 77 where the revenue entries has been not exchanged, entries not being mutated.
Yes.
Thereafter it had been mutated.
which document?
Where in the year 21, 22 it came to my.
98, from 98.
Let have it, my lord, tomorrow, my lord. I will place the, my lord, RTC.
But they are going to conduct the action tomorrow 10:30.
Your lordship, I am for respondent number 1. RA is also pending before assistant commissioner, your lordship. Pending consideration. Regarding change of records.
2025, my lord, after becoming NP, my lord, it's nothing but a setup. I'll point out, my lord, tomorrow from the date of, my lord, I'll.
Let them not to conduct an action tomorrow.
Tomorrow 10:30. This matter will be taken up 10:30.
Please, my lord.
Yes, next.
Cell number 48.
Yes.
48.
Appearing for the petitioner. Your lordship, the petitioner has purchased this property under the registered sale deed.
Appears for the respondent.
Your lordship, this is a fresh case. Another matter which has been unearthed by one of the resident.
PNB Housing, he is appearing, what is his name, Ramesh? Huh? Suresh V. Where is he there?
It is Suresh V.
Tomorrow, Suresh V. Print the name of Suresh V.
Cell number
Inform him, Mr. Vignesh.
Thank you.
Give him the papers. He'll.
Okay, your lordship.
Yes, 50.
Cell number 49 urgent. Cell number 50.
To the petitioner in this case.
Rudra Bhushan.
Lords, in this case, I have challenged sale certificate, my lords. I may be permitted to serve a copy to the standing council of UCO Bank.
Question the sales certificate here. Why not before the DRT?
My lords, in this case, my lords, there are three aspects. Before the sale was conducted, 25% EMD was not deposited.
All that, why not before DRT?
My
Why
lords,
should it be here?
My lords, there is a question of law involved in this, my lords.
They can also decide.
My lords, I may be permitted to serve a copy, my lords.
Not
My lords, there
necessarily.
is a respondent number 2 in this also, my
With
lords.
all this sales certificate, with all this checkered history of this, the DRT will
Lords,
take care,
my
not this
lords,
court.
and also there are 3 sale notice.
Let's see,
Between-
all you
between
agitate,
15 days.
everything you agitate before the DRT, please come.
My lords, can I, For this
Whatever are the latches, that can be taken care of by the DRT.
yes,
not
my lords,
necessarily
but
that-
there are 2 sale notice, there are
Thing,
4
everything
sale
you
notices,
agitate.
there are 2
The
demand
written
notices.
File seeking the following prior.
My
Petition
lords,
has
can I
questioned,
submit this, my lords? Can I submit this? My lords, the valuation of the property is definitely illegal, my lords. And
That is
even
different.
today, my lords, even today, the petitioner is ready to
Tell
compensate the
court-
bank,
tell
compensate the
tell
auction
court
purchaser.
One simple reason why the DRT can't understand what all the
My
submissions you are
lords,
making
there
before
is
the court.
already a sale notice which was challenged before DRT and that got dismissed. That is annexatory. My lords, my only grievance before this honorable court is sale certificate and the DRT order and the
The
sale
notice
notice.
is dismissed.
My lords, the sale notice which was issued prior to,
This sale you have not questioned so far.
my lords, not questioned so
Question
far,
it, question
but my lords, even today, the petitioner is ready to,
After the sale certificate is issued, why should we do it?
my lords, in this case, my lords, the valuation of the property is more
all
than
the
20
questions
lakhs,
are
my lords.
open,
They
Mr.
have
Counsel.
sold it to 13.75 lakhs, my lords.
The prayer.
My lords, let it be posted after vacations, my lords. I will,
The petitioner has raised several grounds with regard to the irregularity in conducting the sale. With regard to the reserve price and several issues pertaining to the manner in which the sale is conducted have been questioned before this court. When it is the sale certificate, he wants this court to quash the order dated 26/4/2023 passed by the debt recovery tribunal and also the e-auction notice dated 8/10/2021 and the sale certificate. The petitioner has an effective alternative remedy. Petitioner can agitate all these issues before the appropriate forum, but not before this court. Accordingly, writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Yes.
my lords, days spent here may be
The day spent
excluded.
before this court, he is entitled for the under section 14 of the limitation. Yes.
Challenging the interim maintenance awarded
How much is awarded?
5,000 to the wife, 5,000.
How can
The
5,000
painter,
be?
painter by profession, my lord, the petitioner
But
herein
still
is
5,000 is a minimum. There can't be less than
In
that.
spite of having recorded, my lord, both parties have not produced any documents, my lord. And
5,000 I'll not interfere. Notice.
Cell number 52.
Yes.
my lords, I'm the borrower. I have made a notice proposal which came to be accepted by the bank. I've made full and final settlement of all the credit facilities. My lords, in the writ petition, KV Lokesh had appeared, so I'll take notice on.
Lokesh appeared, yes. Mr. Lokesh is ready to take notice on behalf of the bank tomorrow. Yes, 53. Any
Yes.
urgency or it can go after vacation?
Tomorrow, my lords.
Tomorrow.
Be permitted to file a memo seeking for dismissal of petition in respect of respondent number 2, my lords.
Memo is taken.
Because the petition has been
Memo
dismissed
is
before
taken
the
dismissal
trial
for
court also.
notice to
Respondent
respondent
number
number
1.
2, as he was set ex parte.
No, he was dismissed before the trial court also,
The relief against respondent number 2 is dismissed before
before the trial court.
Yes, 53.
Cell number 53.
51.
The
Serial
matter,
number
my lord, is the
51.
bank himself purchased the property. My lord, contrary to my lord, section 13(5)(a), which I pointed out. I'll point out my lord 2 documents. In fact, they filed a statement of objection only.
File a statement of
Yes,
objection.
they filed it. Please, my lord. My lord, I filed a memo before this honorable court dated my lord 12/11/2025. In fact, my lord, I assailed my lord sale notice before the DRT. DRT granted interim order subject to my lord 25% of the money, which I complied. It is not in dispute. Pursuant to that, my lord, DRT heard the matter. In fact, throughout the proceedings, my lord, they are not revealed who is the purchaser. I filed an application. My lord, kindly come to page number 8 in memo.
No, I think at this time, both your heated documents, it is difficult, it is little difficult for the court to take.
Yeah, only one. I'll 2 lines, my lord.
I'll hear it as a part heard after.
Grateful, grateful.
Yes,
Cell number
55.
54.
54.
Petitioner.
CG Malayan.
In respect of visitation right, this partly allowed. Only the winter vacation is asking for a half of the vacation, my lord. Child is around 5.5 years.
What do you
Is
say?
a
I am the
boy.
respondent, your lordship. I have today filed my wakalat
Your Lordship, the respondent is traveling on 25th. They have asked for Christmas vacation. Christmas vacation in the school of the child starts on 25th itself, 25th to 31st. And the respondent is traveling to her hometown, Your Lordship. Her father is quite unwell. Twice he has had a heart attack and he has a wheezing problem. And he has not.
He's coming back.
She's coming back on 31st. 31st she is coming back. 25th evening she is traveling, Your Lordship. Since they are Christian, my client is a Hindu. Since they are Christian, they are they want the child for Christmas. In the afternoon, she is ready that they can come and meet the child.
Where are the tickets that you're
Yes,
leaving
Your
to
Lordship. Yes,
leaving
Your
on
Lordship.
25th?
Yes. Please
Take that.
Going and returning, both tickets are done, Your Lordship. And with much difficulty because traveling to Kerala this time. 17th November, Your Lordship,
It's
she has
already
booked
signed-
it.
the Christmas day is given already by the trial court.
Visitation is
Lordship,
given,
the
my
trial-
lord. Overnight custody, I'm asking. Lordship, may kindly see.
In these circumstances, no, we can't construct.
No, Lordship, may kindly see. At least for a Christmas day, let me be allowed to be
Yes,
spent.
afternoon, certainly. Afternoon,
And
he can
thereafter,
always come.
Lordship, may kindly see. Once he come back, at least for 2 days in overnight custody, maybe.
That we will see after he comes back, not now.
Hmm.
It is submitted that the land council for the petition submits that during the Christmas vacation, there may be the father may exercise 50% of the overnight custody, 50% of the vacation, and he may permitted to have the overnight custody. Land council appearing for the respondent is placed before this court the tickets to show that she is traveling to Kerala on 25th and coming back on 31st. It is submitted that the father of the
30th, Your
respondent,
Lordship. 30th.
the father of the respondent is not feeling well. It is submitted that as far as 25th, when on 25th you are leaving?
25th, 8 o'clock is the train.
8 p.m.
8 p.m. 8 p.m.
On Christmas, the petitioner can exercise visitation.
Your Lordship, the next visitation is on 20th.
We are talking about 25th.
Please.
What is the time?
Morning till evening, my lord.
2 hours, 3 hours, Your Lordship. He has to
Can
prepare the
exercise
child for
visitation
train journey.
Between 10 o'clock to 4 o'clock.
4 o'clock will be sparse.
8 o'clock, you have a lot of time.
Your
Yes.
Your Lordship, 8 o'clock is the train starts, Your Lordship. The child needs to be prepared. Your Lordship, the child doesn't eat anything when he is with the petitioner.
Yes, next.
Cell number 55.
Please.
Cell number 55.
In this case, Your Lordship, the order passed by the Debt Recovery Tribunal in SCA has been challenged before this honorable court. Instead of approaching the DRAT, they have approached this honorable court. And one more writ petition they have filed on the similar grounds.
Where is that petition?
Lord's page number
First
180. Lord's
55 and 55/1.
Page number 100
is the order challenge, the order of the debt recovery is challenged. Order of the debt
Is
recovery.
the next writ petition?
Lord's page number
Correct.
179, your lordships may kindly take notes. Section 14 order has been challenged before this honorable court, and there is an interim order passed in relation to the treating of this account as an NPA, which has already been there, and this order is still in force in pertaining to one property. Section 14 order is pertaining to one property in relation to the entire loan transaction. Now they want to take action pertaining to the other properties. Lordships may kindly take page 179. Lords, the order is dated 23rd of July 2025 at page 180. And this is an order which they have not sought for vacating. Now they cannot say, since section 14 order itself was under challenge pertaining to one property, this is the order passed. Now they cannot say, my lords, that if you, can I just read your
There won't be, as far as the interim order is concerned.
lords may kindly see, my lords, what is the order? Lords, this is an interim order passed, my lords, by the court. Lords, page 180.
55.1.
Lords, 55.1.
55.1.
Oh.
Lords, in that, there is an interim order which has been passed pertaining to one of the properties.
Not one.
By recording there is a finding recorded.
What is that?
Page number 180.
$55.1.
This is posted before your lordships as 55.1. But this order sheet, I have produced it as part of the writ petition papers itself. In 55.
Yes, correct. 180.
At page 180. Exactly the same facts presented before this honorable court, my lords, in the earlier round of litigation. I'm only seeking parity. Learned counsel for the petitioner points out that the email addressed to the petitioner on 9/6/21 to the effect that petitioner's accounts were eligible for restructuring and resolution of framework under 20 schemes. Hence, petitioner submit that it is evidence of the fact that the prior to the loan being declared as NPA, petitioner is brought to the notice of the respondent bank regarding petitioner's loan account being eligible for restructuring under MSME. Attention is drawn to the order of at Annexure A and Para 11, and it is submitted that DRT has recorded a finding contrary to the orders of the Supreme Court in Pronit's case. Respondent bank to clarify, contention of the respondents availing alternative remedy is kept open. However, respondent bank to take a stand prima facie findings so and so is contrary to the observations at Para 18. Interim order granted is earlier is extended. You know, it's the reason why I'm submitting earlier there was an interim order granted because there was some agricultural properties also involved which was recorded, referring to Blue Coast case. Then it was also brought to your lordship's notice that this is the present state of affairs. Not if it is, this is the state of affairs pertaining to this very loan account. Now they cannot have a different stand unless this order is vacated. This order stares at their face. There cannot be a finding to the contrary to the orders dated 23/7/2025.
Oh, one thing is, it is always kept open. Now, why should you come here? Why don't you go to DRAT?
Lords, now this honorable court has already entertained one of the matters and this is an order passed.
So it is kept open. The court
Lords,
has
I have
not
no
given any-
difficulty. It is kept open. But what I am submitting is, if in the interregnum, Lords,
Feel is there should be some uniformity in the orders. Some people, one writ petitioner go to the DRT, some other writ petitioner, but it sends a very.
I'm
wrong
not saying that.
message.
May I just say this, Lords?
No, just
Now they want to.
Your colleague just now has appeared in one matter. I said you go to DRAT.
Lords,
According
DRT.
to me, this is not.
Lords,
an,
Lords, now this is, Lords, if a prima facie, now it is only kept open, Lords. This is an issue which your Lords may have to hear the matter. Lords, as to
whatever the interim order
Pronit's
is there,
case, if your Lords is,
whatever the interim order is there, let it be there.
Yes.
But in the fresh matter, I will not grant any interim order because there is an interim order in 55.1.
Lords, this is, can I just persuade this, Lords? If in relation to one item of property mortgage, if there is an interim order on the ground of Pronit's case,
As
whether
you
it
know,
can be
interim order
refused.
is not binding on the other judge. And
Lords,
it is
I'm not
for
saying,
me-
but parity, Lords, can I just.
When I'm adopting one way of dealing with the
The-
things, I
there
can't
is-
take a different
There is one
view.
judgment, my lords, which I will have to bring to your lordship's notice, which says that there should be consistency even in passing of
That
the
is
interim
exactly
orders.
what I'm saying. There should be a consistency.
In passing of the
these
interim orders passed by this honorable court, Lord, there is a division bench judgment also of this honorable court which said that there cannot be two types of orders pertaining to the same subject matter.
But because we can't interfere in these matters like this. One matter, there is no basis. One we give, we entertain a writ petition. Other we say go to DRT, go to DRAT, and the entire litigants are in lot of confusion. What to do?
Lords, I would, my lords, I would say this, my lords. So far as litigants' mind is concerned, having undertaken, they have absolutely no doubts in their mind. All banks wanted the litigations to be before DRT, DRAT because the results are known. All borrowers wants to come before this honorable court and seek your lordship's intervention. This is essentially how it is happening. I don't want to get into that, but your lordships will kindly see, my lords, that there is a parity which is required, my lords. The Supreme Court also takes the view that there is a requirement of parity of the interim orders. It cannot be, my lords, that in one case for pertaining to one property in relation to same cause of action, by recording reasons, my lords, if an interim order is granted.
Convince the court why the DRAT can't deal this issue. Why only this court can deal with it.
My lords, the Pronit's case itself very specifically stated, my
But
lords.
even DRAT will look at it.
My lords, no, the reason, my lords, Pronit's case was dealt with under 226. Even the subsequent judgment of the Supreme Court was dealt with only under 226. My lords, so far as the enforcement of the RBI guidelines pre-NPA is concerned, my lords, there is no way that section 17 comes into play. My lords, so far as enforcement of RBI guidelines, Sardar Associates case itself has.
Why did you go to DRT then?
Lords, DRT, what was challenged before the DRT was only the sale notice.
No.
Sorry, section 14 order, only the possession taking notice, nothing else. Now what we are challenging is that there is no way that this could have been, lords, once a finding is given, my lords, by a coordinate bench pertaining to the very same cause of action, very same subject matter, but one property. But the other properties also have to be safeguarded on the same lines, my lords.
If you want me to pass an order, I will record that and pass.
Your Lordship, in the earlier proceeding, they have approached the DRAT and there was the interim order. They have not complied it. Now it has been dismissed. Now in this case, they have approached this honorable court. Instead of approaching the DRAT.
No, they have not sought for vacating the interim order.
The present litigation is fine.
Reject ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇಲ್ಲ.
Taking the
Let it be after vacation, my lords. Of your lords is
The
passing.
date
an
may
order.
fix your lordship. They are due.
Come, what is
About
urgency for you for
70
the
crore
date?
is due your lordship without in.
No interim order I am granting, so why?
Well,
why
in
do
the
you-
earlier.
The interim order in the other case may be continued.
The first, second
Listen,
matter, the interim order may kindly be vacated.
The matters on 15.
Lords, the interim order in that
Order
matter
may
may be
kindly be
extended,
vacated.
my lords.
Order in that, in 55.1
15.1.
is extended.
Lordships.
Number 56, Rudra Bhushan.
Madi, Madi.
Yes.
My lords, I am for the petitioner in this case. My lords, I am seeking mandamus.
Because
My
already
lords.
the two matters it is rejected, so third
No,
matter
no,
I should.
no,
write
my lords,
order.
my lords. I haven't moved the memo, but
No, I'm saying
my lords,
two matters of yours I have not granted, so third matter I should consider
Lords.
without looking at the prayer. I am saying, not that you are.
yes, my lords.
Yes, where is the prayer?
My lords, the first prayer is quashing of the impugned sale certificate dated 8/8/2024. And the second prayer is issue of writ of mandamus directing respondent bank to consider the representation.
What is the representative?
My lords, representation is for clearing the outstanding dues. That is one. My lords, I may be permitted to show only one document, my
No,
lords.
no.
My lords, I may be
No, no, no.
permitted to show only one document.
The indulgences, I'll take it up, let it come up after vacation.
My lords, can this court at least issue notice to the bank as well as the auction purchaser? Yes,
Notice to the respondent.
yes. Both the respondents, my lords.
57,
Both the respondents, my lords.
All.
Yes, yes. Thank you,
number
thank you.
57, Jagannath Halwa.
Possession notice issued in section 13 at annexure D, page 30, my lord. This is sought to be quashed. It is an agricultural land. Your lordship will find it at annexure B, page 16. It is an agricultural land. It is agricultural loan exempted under section 31I.
Who appears for the bank? Which bank is this?
Notice,
Canara Bank?
notice is to be.
Yes, Mr. Vignesh Shetty, where is
Vignesh
he?
Shetty. Divya Purandar.
Give him the papers tomorrow. Yes, 58.
Cell number
Give
58,
so papers on him.
Please.
Yes, 58.
58,
Lords, can I just photos? Lords, one of the properties purchased by a mutt. Can I just pass on these photographs, my lords?
Which is the respondent?
Lords, respondent is a cooperative bank. Can I just persuade this, my lords? This stands on a completely different footing than the other matters. Lords, there is a temple. The property in question was purchased by the mutt in the name of the pontiff. There is a Raghavendra Swami mutt in this property, which is standing there for several years. They issue a 13-2 notice. We give them a reply. 2 replies are given.
From how long it is in existence?
Lords, this property is in existence from the date it is purchased. Lords, the 2004 we purchased the property. 2004, 2006 the temple is established. Now we get a notice from this bank called as Kuru Raghavendra Bank, Lords, which is under, Lords, all the directors are inside.
Bank?
Lords, that is Guru Raghavendra Bank is a bank, Lords.
Bank itself is Guru Raghavendra.
Yes.
Sahakari
That is the most intriguing part. Lords, what happens? This bank issues us a notice saying that this property is mortgaged. We give 2 notices. One saying that we have never maintained any account with your bank.
You received a notice under 13.
13-2, we gave a reply.
Where is your reply?
Lords, may kindly see page 27. Annexure C, page 27. We give it. We say we have given a very detailed reply, and again at page number 56 we say that please give us the documents. You are saying there's a loan, please give us the documents. We have specifically stated we have never maintained any loan account. Lords, then page 56 if your lords were to see me, lords. We say that please give us the documents. We have nothing. We have never maintained any account with this bank. Now after this 13-3 notice is given, Lords, the bank has not given any reply. Straight away 13-4. Lords, every day this is belonging to a mutt. There is a pontiff to this mutt, and morning till night Kainkaryams will be going on.
What is the date of 13-2?
Lords, 13-2 notice is given on 5/4/2025.
5/4/2025. When is your reply?
Section 27 notice is, page 27 notice annexure E is given on 30/5/2025.
No. 13-2 notice is 5/4/2025.
5/4, 30th of 35, 2025.
is your reply.
My lords, we have given two replies, 24/4/25 seeking documents,
24/4.
25,
How many days time you get? 60 days from the
60
date of
days time.
30 to-
Within 60 days, we have given this.
Hmm.
May I just persuade your lords, may I kindly have a look at this judgment, my lords. What happens when such a reply is given?
No, they have given any reply and.
No, my lords, they have
Then
not
after
given.
That what happened?
Lords, now straight away, they have issued a possession notice. It's a temple, my lords.
The, then senior counsel, the writ petition is filed, questioning the, questioning the, where is the prayer? Questioning the possession notice dated 9/12/2025. Then a counsel senior, then a senior counsel appearing for the petitioner submits that the petitioner is a mutt, which is established in the year 2000. They purchased a property in the year 2004.
2004.
And the mutt was established in the year 2006.
Lords,
Mutt
was established. Lords, this is, I just want to say this. This is the oldest of the mutts in Karnataka.
There.
It was there. The mutt is in existence. The mutt established the temple in 2006.
The mutt has purchased a property in the year 2004 and established a temple in the year 2006. When the bank has issued a notice on 5/4/2025 under section 13(2), they have issued their reply that on 13/5/2025 and 24/2025, it is submitted that as contemplated in the Surface Act, the bank has to give a reply to the said to the reply dated 35/2020, 24/4/2025 and 35/2025. Without following the procedure as contemplated in the Surface Act, the respondent bank has issued a notice under section 13(4) of the Surface Act. Considering the submission of the Lansina Council, they should be stay of all for further proceeding pursuant to the 13(4) notice to the respondent. Yes, 59.
So grateful.
59.
Yes.
May I seek for hand delivery?
Yes, hand delivery. Yes.
Appeal of the insurance company on the question of liability, my lord, regarding driving license, without even leaving liberty to recover. my lord,
And
the-
recovery is not ordered.
It's
What
not.
is the amount?
3,07,000, my lord.
It is submitted that the insurance company is on the question of liability, though there is no valid driving license, the principle of pay and recovery is not applied by the tribunal, and they shall be considering the submission of the counsel for the appellant. They shall be stay of all further proceedings 50%, 4 weeks. The respondents are at liberty to withdraw.
Still number 60.
Notice to the respondent is 60.
My lord, here, my lord, the question is regarding contributory negligence and quantum, my lord. My lord,
How much is awarded?
My lord, around 9,72,000 has been awarded.
What is the admitted amount?
Admitted, my lord, your lords may kindly, 11,94,000 has been awarded. Lords may kindly hold that, well, 50%. my lord.
That is usually you say.
Yes.
I said what is the
My
admitted
lord,
amount?
9 lakh, your lords may kindly appreciate. He was a student. My lord, 9,72,000 has been awarded under that future loss of earning. That's also under challenge. And
But
also,
what is that? It's a case of death.
my lord, injury case, my lord. He was a student.
It is submitted that the tribunal has granted the compensation on the higher side. And there is a contributory negligence on the part of the claimant, which was not considered by the court, 50%. The 4 weeks permitted to withdraw.
Still number 61.
Notice.
61. Ashok Kumar.
Yes.
Insurance company appeal, my lord.
Hmm.
Challenging liability
Hmm.
on ground that the insured was purchased from tractor for agriculture purpose. They have used for borewell lifting
What
machine
is
was
that, yesterday's writ petition, yesterday's MFA?
Tuesday 16th of the,
Number,
I give them.
give the number, same order.
Same.
There are two appeals
Yes.
filed.
Still
S62,
number 62. Still number 62 D Vijay Kumar.
no representation after vacation.
Still number 63.
Yes.
ECA matter, my lord. I have deposited the entire award amount. I am challenging the liability, my lord. There is no employer and employee relationship. And also, they have
insurance
implanted
company-
the driver also, my lord.
That there is no employer-employee relationship. That aspect was not considered by the court. Stay 50, it is submitted that the entire amount is deposited. Stay, notice,
Still number 64.
Please, my lord.
64.
64.
I'm appearing as a party person.
Selvaraj, good
What is
afternoon.
urgency?
Uh,
Urgency to hear it now.
because there is urgency because trial court has passed me the direction to produce
Exactly, let us see.
Not so that the entire set of the copies to me.
entire sheet. I have given 1 minute. So they have received the copy, entire set, they have signed it on 11. So this is regarding
Not RPFC,
writ
give the
petition. Writ petition, they have signed it, entire file has been submitted. And they have signed on 11/12/2025.
Where is impugned order, page number?
Annexure A. So actually, the maintenance for the ex-wife has been already dismissed. Annexure A, page number
Yes.
40. So
Number?
page number 40. The petition filed by the petitioner number 125 respondent has
Order is passed on 4th January 2018.
18.
What is urgency now?
No, there is one more order passed after that in RPFC connecting 34 and 60. So I wanted to stay together both because here and in RPFC 60 there is annexure B, one more is there. So page number 45.
This is a final order. How is the writ petition maintainable against this order?
No, actually there is a confusion about that one. That's what I want to submit. So in page number 45, annexure B, the maintenance awarded for both the respondents. Last line. So maintenance awarded was 10,000 in the lower court, and I prayed for a stay.
Argue all that. Impugned order is at page number 19. That is a final order passed in the criminal miscellaneous.
Yes.
When is it passed? On 4th January 2018.
Yes, I challenge.
Against the order, against the final order, you cannot file a writ petition. You have to file a RPFC. Number one.
Yes.
And why are you questioning an order of 2018 now?
So I challenged in RPFC 34. I filed RPFC 34. In that I got an order.
Then why are you filing now a writ petition?
In writ petition I filed because in RPFC also there is a problem in so in RPFC in 45.
The present writ petition is filed questioning an order dated 4th January 2018, this order is a final order and again.
Actually this is one submission. The ex-father-in-law is responsible for divorce and because they forcibly kept my son.
Please have your advocate. All this you can't.
Because they forcibly kept my son to harass me to join home in Salah. I provided all the CD and conversation, annexure C and other things.
Why should the court consider all that in a maintenance matter?
Because these are important. Because of that my divorce, everything happened. Maintenance happened.
The writ petition is filed against an order passed in 2018. Writ as filed is not maintainable.
Because
this court, there is no urgency to consider an order that is passed in the year 2018.
Because this RPFC also main is the RPFC, Your Honor. Because because of that I came here. Because she is MTech qualified, she is not entitled for maintenance.
See, after vacation there is no
because there is urgency. Because 20th tomorrow Saturday I have to produce the order. Kindly grant stay order. Because ex-wife is not entitled for maintenance. Kindly, my Honor. Because ex-wife is MTech, I am B mechanical, and it's granted maintenance for her.
How do you expect the court to grant stay in a 2018 matter?
No, it's a 2019 actually. It's a 2019 stay order granted in 2019.
Give that.
There is a order annexure B.
Yes.
28/1/2019.
Yes. Next.
So in that
We can't grant any interim order.
Because she is MTech qualified, my Honor. She is I'm B mechanical and
We'll see after vacation, not now.
because they are asking me to produce final on
Court
20.
asked, you said court has not granted.
Because on what should I have to produce stay order?
Or I will dismiss it. Shall I dismiss it by passing orders now itself?
No, kindly grant.
After vacation, yes, 65.
Kindly grant the date, please. First week.
6th of January.
6th,
Yes.
yeah. Okay.
There's a direction before.
Yes.
Lord, it has been quoted. I have admitted this school for the perseverance school for theoretic.
Give the order. 1 minute. Give the order. Take that from him. He has paid the daughter's fees.
Please, my lord.
Yes,
Place it on record.
Then true copy of the admission receipt admitting the minor son to Perseverance School from December 2025 to February 2026.
Yeah. He has done
He has
that.
also paid that amount
Yeah,
also.
yes, it's only a therapy, my lord, they are giving. It's not a school as such.
Correct.
Yeah.
Now, the school will not take the children in the middle of the year, isn't it?
No, like Delhi Public School has offered the seat. I have last time along with the memo I have.
Now he has paid this, let him continue with this, and for the next academic year, let the boy be joined in DPS.
No, he requires two other therapies, my lord. That is vision therapy and speech therapy are two things which he requires for his development. Even here also, there's a special course. Let them put to that. There's a special speech therapy and vision therapy. Doctors have advised that.
Why don't you do what is required?
My lord, I'll just make a submission.
Please,
They
Please
they
wait.
made an allegation saying that I have not paid the balance fee amount of the second daughter, my lord. When I asked for the enter password, there is some vulgar messages which has been placed to me. Then how can I communicate, my lord? When there is I have no time to communicate. I can't communicate. Without communication, how can I make efforts, my lord?
Ma'am, I've already shared the password. He is having the password. He's just making a false accusation that I'm not sharing the password. I've even shared
As
that.
per the order passed by this court,
Ma'am,
the petitioner has paid the fees for the second, for the daughter, and also a receipt is placed that for the school fee is paid for the, perseverance school.
Please, my lord.
School list is matter after vacation.
My lord, regards to counseling, my lord, if during vacation it will be on Friday because on Saturday counselor will not be there due to the vacation.
All the son, wife, and the husband shall on every Friday shall between, what is the time?
Morning 10:30, 11.
11 to between 12 and 2, they shall appear. They shall go before the mediation center. Before, as per the earlier order passed by the court, before the counselor, and counselor shall place a report. Yes.
My lord, interim order will be extended.
Interim order earlier granted.
See, 10,000 was the interim maintenance of that granted. That is wholly inadequate for that to maintain the grocery, children, and other maintenance.
We will see after vacation.
No, but you see,
For petitioner, my lord.
67.
Lord, challenging the maintenance order passed by the family.
66.
court.
Tejasan,
How much is granted?
My lords, 5,000 has been granted, my lords.
5,000 I will not
But
interfere.
my lords, the salary of the husband itself is 13,000, my lords, per month.
So 13,000, 5,000 is,
The
yes.
assets and liabilities has not been filed, my lords. Kindly-
I'll not interfere with 5,000. Yes, notice to the respondent. Next.
Millards, I appeal for the petition, Millards. Millards, interim monthly maintenance 35,000 has been ordered.
What is the income of the,
1,98,000 is the income of the petitioner, Millards. He is a doctor. Wife is also a doctor. Her income was 3,30,000 at that time of at that point of time, Millards. Same is not
as per
considered.
what is recorded by the court?
Millards, internal page, in page 28 can kindly be looked into, Millards. In page 22. Millards, she deliberately failed to disclose her salary. Para 22, Millards. According to further claim of PW1, her father helps financially maintenance of the petitioner, has a stipend of 47,000 per month since she is a student. However, it is not denied she is working as an assistant professional. She has not disclosed her monthly salary and assets and liabilities. Plus, whereas I have producing the exhibit 29, which is her statement of accounts which she produced, which discloses that she was earning.
Please tell the court where is the discussion about her income?
That is not disclosed, Millards. That is not discussed. That's why this petition has been filed. Whereas she has
Court
produced
has
account
not,
statement. She has produced accounts, her account statement as per exhibit P29, which I am producing, Millards, which discloses at that point of time she was earning 3,30,000 per month.
What is her qualification?
Millards, she is MBBS. She is more than qualified than the petitioner. She is a surgeon, gynecologist in Mysore city, Millards. In the memo which I have produced today, Millards, ink page number 12 may kindly be looked into.
This is sort by sort. This is for the daughter.
Please, Millards.
Not for the wife.
Not for the wife, for the daughter, Millards. But Millards, ink page number 12 of the memo may kindly be looked into, Millards.
What memo?
Now I have produced. Ink page number 12, Millards. Ink page 12, Millards. I have marked the income, Millards.
court has granted 35. Now you have a daughter, you have to take care, you have a
No,
responsibility.
my salary was 1,90,000. Her salary was 3,30,000, my lords. Some proportionality may kindly be indulged, my lords.
Please
That's
come.
my prayer.
The father is before this court questioning an amount of rupees 35,000 that is granted towards the maintenance of the daughter. It is submitted that the wife is earning more than the husband, and in terms of the same, they should be their contribution to the daughter should also be proportional to their income. Considering the submission, they shall be stay of all further proceeding pursuant to the order dated so and so, on the condition that he shall pay an amount of rupees 20,000 per month, and the arrears also 20,000. This is RPFC notice.
Then number 68.
After the 8th, what is it?
Which one, ma'am?
8th. Eighth. Yes, next.
Still number 68.
Petitioner counsel may please, it may be adjourned to after vacation, my lord.
No difficulty. It can be done.
Yes,
Lord, I've just taken notice for respondent 3. I got papers, my lord. I need to take instructions, my lord.
Yes.
No difficulty. Have it up.
Some date may be fixed, my lord. Some date may be fixed, my lord.
13-1.
Yes.
Still number 69. Appeal Dikshit.
What are your instructions?
My lords, they have filed an IA for winter vacation, my lords. For Christmas vacation, they have filed an IA. May kindly be dismissed, my lords, because the child is already visiting the father every weekend. The trial court has ordered that. And there are some plans with the maternal grandparents which the child wants to spend. So kindly, the IA may be rejected, my lord. What do you think?
My lords, your lordship's order dated 23/9/2025, my lords, wherein your lordships were pleased to grant Dasara vacations 4 days. All that I'm seeking is, my lords, from 28th till January 2nd, because Jan 3rd and 4th again is my visitation, as per the normal order that is.
The
written.
mother doing the vacation during the vacation.
But she has the first
My
half of the
lords?
vacation. May please, one second. She has the first half of the vacation. I'm asking for the second half of the vacation.
My lords,
20th to 20, the school.
the mother has planned a lot for the child, my lords. In church also, she has certain programs for the child conducted. So she also wants to spend some time. And moreover, my lords, the maternal grandparents have not spent a single time with the child. So it was a
When the
request which
holidays are starting with the child.
20th, my lords.
20th.
20th of December.
My lords, but any which ways, she's ready to send the child on the weekend.
My lords,
So,
then it may be reversed, my lords. I will take from 24th to 28th. Let her take from 28th January 4th, my lords. My lords, both are Christians. I'm not denying it here. Father has not got even a single.
Gautam, no, you can't argue. So if you argue, I may not grant. Yes.
Please.
Lords, we want the application to be rejected, my lords, because there's hardly any time
Like that say that the application has to be rejected. You have to be reasonable.
My lords,
you can say.
My lords, the
like
child
it can
actually.
Please understand. You can say it can be 2 days, 3 days, or whatever it is. But just like that, you can't say it has to be rejected.
My lords,
It is
it's
not
the
a kind
same
of ration
weekend.
that because he's having for some weekend that other on the vacation is not entitled. That's not that's not the solution. Why I have adjourned the matter. Now, if you are taking the child to the grandparents, when is that you're taking? What are the remaining days when he will have the visitation? That's how we have to look at it. And there is no difficulty with the child and the father are having he's having a good bonding with the father. Earlier also I
My
have
lords,
passed
the
orders.
child is actually having little difficulty in during
now
the
I have given you a clue.
No, my lords. Actually, the child is having certain difficulties during the visitation.
Anyhow,
she's just.
You are not a. You said father is a Christian.
My lords,
Father is a Christian, you said.
both of them are
Both of
Christians,
them
is
are
what I
Christians,
mentioned,
my
my lords. That being the reason, my lords told me I should not submit. But that being the reason, the first half probably I will. If I will take the first half, let her take the second half. That's the least possible option I could probably.
My lords, at least 2 days may be granted for that, my lords. So we don't want to give the entire vacation period.
No,
because,
he also doesn't want the entire vacation.
my lords, the child is not comfortable at all.
So let's see. Now the vacation starts
At
from
least
20th. Vacation starts from 20th.
My lords,
20th is what?
Can the mother also accompany the child during the visitation, if
Overnight
possible?
visitation, that
Just
is.
not overnight visitation, my lords. At least from day to evening, because the child doesn't want to stay with the father.
What is the age of the child?
7 years.
Trial court has granted me overnight visitation, my lords, during weekends. If I could submit this, my lords.
Oh, this is
For
a
the-
case when counsel for the father submits that the custody of the child is with the mother, and the mother had taken the child for a day for some function, and
Yes.
after that she had retained the custody. I remember this case.
3 volumes of adultery.
My lords, but she has compensated that, my lords.
Yes, when counsel for the petitioner submits that the custody, the 50% of the custody may be given to the father during the Christmas vacation. When counsel for the appearing for the mother submits that it is difficult for the mother. The boy wants to spend time with the maternal grandparents.
It's a girl
Hence-
child, my lords.
The girl want to spend the time with the maternal grandparents. Hence hence the request may not be considered by this court. This court earlier had passed an order on 23/9/2025, where during the Dasra vacation, where the father was permitted to pick up the child on 25/9/2025 10 a.m. and drop the child back on 29/9/2025 10 a.m. in the morning. Nothing is placed on record to show that the visitation on the earlier occasion is not fruitful, or the boy was not comfortable. In these circumstances, this court is passing the following order. The father can have the overnight custody on 22nd, 23rd, 24th.
My lords, that much may be done.
22nd,
25th.
23rd, 24th, 25th. 24th. 5th he'll spend time with the
24th,
mother.
Please. Grateful, my lords.
Yes,
Whereas 22nd, 23rd,
70.
24th.
Huh?
22nd, 23rd, 24th.
22nd, 23rd, 24th.
I'll pick
You
up
can pick up the boy at 10 a.m. on 20.
the girl, my lords. It's the
Girl on 22nd
Please.
and drop him back on 24th by 7 o'clock in the evening.
Grateful, my lords. Deeply obliged.
Cell number 70.
I appear for respond. I appear for a week's time to file objections. Today only I filed
The
the.
vacation next.
Cell number 71. Cell number
After
70.
vacation.
Cell number 72.
I'm for the respondent in 71.
72. I'm appearing on behalf of the respondent in 72.
It may be, my lord. Not
Point
sure.
one, petitioner.
Now we are in 71.
71, sorry.
For 71, I'm the petitioner husband.
Urgent.
He can't appear.
72, I was not even informed.
No, I have not taken adjournment.
Which
Not taken.
one?
72. Two.
71, my lord.
Somebody mentioned in the morning and they took it.
It is mentioned in the morning that it is already informed to the other side, and other side has no objection.
I was not informed, my lord.
No, both of us are waiting, but I didn't mention.
Morning, somebody has come and mentioned.
72.
72. Yes.
My lord, 71.
1 minute, 1 minute.
Published.
Sorry, madam.
My lords, I appear for the respondent in 72.
You have urgency in this.
They are the ones who had sought for custody.
No, but morning I asked, they said that, I even said, what about this no further adjournments? She
Well-
said, we have already informed to the other side.
Well, I would just like to make one submission. It was their request for visitation. The mother lives in Singrauli.
No,
Madhya
he has not come. This is matter
Very well.
after vacation.
I'm great.
Number 73.
71.
71.
For 71, for 71, I'm the petitioner husband, my lord. My advocate waited till 4:30, but he had to attend.
Help it.
Yeah.
You shouldn't, first of all,
Yeah.
you shouldn't mention, this is not a civil court.
Yeah. He had to.
Family court, that where the party will come and mention. It is for the advocate to do. Yes.
In
73.
71.1, my lord, in 71.1, there's some office objections may be overruled. I've already served the notice on them. He's the respondent in 70.
Addressing this matter now.
73. Sir, it is 73, sir. Rajendra.
He is representing in 71.1. What is urgency?
71.1. I'll ask after the vacation, ma'am.
Yes, after vacation. Yes.
Cell number 72, urgent 73. M.A. Rajendra.
Whereas maybe posted after vacation.
After vacation, 74.
74.
I'm for the petitioner of this case, my lord. My lordship,
Let's kindly have it
On
the vacation,
2011.
my lord. We have moved the matter on Monday and requested for the earlier date, but my lords told us, my
20th,
lords.
on 13/11/2025, my lordship has interviewed the child. If I can remind my lordship, this is the case where there's an allegation of POXCO Act on the father. And subsequently, it was listed on
We'll
20.
hear it after vacation is 74 after vacation, 75.
Serial number 75.
There's an order, my lordship. There's an order that I have to tomorrow for the Christmas vacation, my lord. That may be stayed. I'll argue this matter. If they want time, I'll argue this matter after the vacation. There is an order that I have to. There are allegations on the father, serious allegations of them. My lordship has also interviewed the child. Now they want to take time after the vacation so that they go and file execution on me. It may be stayed for this Christmas vacation, my lord.
I know the facts of the case. I think I can't interfere now in this order. Yes.
Because I have to hand over the child for Christmas vacation for a few days, my lord. On 20, on 20.
I lordship may kindly have this matter after vacation.
After vacation. Yes,
Serial number
77.
76.
My lordship, on the submission, that there is a interim custody for the Christmas day.
Which one?
Christmas, my lordship. 3 days of interim custody, my lord. In the 75 serial number.
75.
There is no any stay in that proceedings, my lordship. And they are not allowing us to see the daily
What we
visitation.
can do, you file execution. Yes,
76.
Correspondent, my lord.
Aleshappa.
Copy has not been served to
Yes,
us.
after vacation, 77.
77.
For petitioner in 77, your lordship, we have challenged the possession order, your lordship. The only urgency is during vacation, they may go ahead with the auction, your lordship. We are ready to deposit 1,50,000 in 2 weeks, your lordship. Only if the
What is the
auction,
outstanding amount?
outstanding remaining balance is 2,52,000, your lordship.
Which is the bank?
Francis David.
Where is the council? Lizzie's matter tomorrow. Yes, 78.
Serial number 78.
No, at this hour, I will not
Here for the
go into any
respondent.
arguments except the seeking the indulgence of the court for listing the matter tomorrow for the reason that the visitation right which was exercised by the petitioner on Saturday got fructified, and with a smiling face, there is a picture which I will place it on record. Kindly have it tomorrow, or grant one visitation right during the vacation.
Who appears for the respondent?
No objection. I appeal for the respondent. I have no objection, my lord. 20 on 31st is the child's birthday. I have only my only request is the learned senior advocate may
Let the birthday be
instruct the party to
celebrated.
give a gift for the
No,
child.
no. What he says is he has no objection for the visitation. When do you want?
Could be for 2
On
days, for
31st, child's
23rd
birthday.
and 24th. 23rd and 24th.
23rd. And what is the timing that was given? Time.
I maybe for 4 hours.
Earlier, like last time, what is the order?
The last time was between 12 and 2.
5 to 7 in the evening.
5 and 7, sorry, 5 and 7.
So on 23rd and 24th, 5 to 7.
Overnight.
Ma'am,
Overnight.
No. It never had overnight.
No.
I leave it. It's not, I will not at this time. I will not
It is submitted that by the learned senior counsel appearing for the petitioner that the order on 12/12/2025, this court has passed an order and the exercise, the visitation has went on well. List this matter after vacation. In the interregnum, this court is passing the following order on 23rd and 24th. The father can pick up the child. How it went on?
It's in the mall.
It went on well. In fact, there is a picture.
It's in the mall, my lord. The mother takes the child to the mall and leaves the child over there with the father and his friends.
Visitation in the mall between 5 to
7 p.m.
We have placed on record.
Whatever is the, no, we will see next time. Whatever is the last time order, only they change the time.
Would my lord consider giving a date, fixing a date, my lord?
After vacation, for what is 14th of January?
14th is the
That may call for another visitation or maybe earlier, little earlier.
8th.
Yes.
8th.
I'm
Yes.
greatly obliged.
Yes.
9th, I understandably my colleague.
Yes.
Serial number
No, I only have one
79.
request, my lord. The child, the parties are Christians. He may be asked to give the child. Apparently, he does not give the child any gift, or some Christmas gift, or something for the child to keep the child in good humor.
Where is the senior?
Sir.
Yes, I'm sorry.
He says parties are Christians. So when he is meeting on 23rd and 24th, give the boy a Christmas gift.
Undoubtedly.
My lord,
Undoubtedly.
may I make a submission on the last
Grateful.
Saturday. In fact, he gave a gift which was returned by the wife.
No. Undoubtedly, it will be a
But let the wife not do all that.
Very well,
super
Lord. I will
gift.
instruct her.
Given. I'm obliged.
Serial number
Great.
79, Nagaraj sir.
Your
But the
lordships,
request of the
before we
petitioner in this
begin,
case, my lord, for the
before we
father, my
begin,
lord.
your lordships, I am not on Wakalatnam. I do not have instructions. Another issue is that the copy that has been supplied to me is incomplete.
Lords,
The
previously,
index says it is 113 pages. What I've received is 40 pages.
Lords, simply to take time, this is what the submissions.
They have
made by
not supplied the
council,
actual
but
copy, your
it is
lordships.
regarding
We
the
give him
father.
today, tomorrow. Yes, next. 80.
Till number 18.
Lord,
For the
his
petitioner.
name may be taken on record, my lord.
Yes, he said, what is your name?
Copy, sir.
My name is Bhargav.
This-
Satvin is.
So this is it is submitted by the land council, Mr. Bhargav.
I have not filed my Wakalatnam, my lord.
His instructions.
I need to get
I
my.
said he has instructions to file wakalat.
Yes, your lord.
Because tomorrow I'm going to pass order, even if you're not there on
It's
record.
like,
So tell your client, so and so has instructions to file wakalat. Print the name of so and so, delete the name of so and so. Yes, next, 80.
Number 80.
Appear for the appellant, petitioner. My client is not good well.
Huh?
Dear.
After vacation, next 81.
Till
They
number
have to file
81.
an affidavit, my lord, for the
81.
outstanding.
They have not filed, they will only face the consequences.
My lord, the 81, I am for the petitioner. Mother has been denied the custody of the child. The mother is before this honorable court. But they, without arguing on merits, my lord, there is a vacation, my lord, from 20,
Let him complete.
from 24 to 4th January, there is a Christmas vacation to the child, my lord, first child. My lord, let me to have half of the vacation to enjoy with the child.
What was the earlier orders?
But earlier order, my lord, 13B petition was filed.
Please tell the court.
That is the.
Did you ever had the visitation
My lord,
before this?
Had not, this is a fresh matter, my lord.
So then we will say, no, these matters without hearing the other side, without meeting the child, I will not pass any order.
No, my lord, vacation, my lord, vacation.
That's why fag end of the vacation I will not do. The other matters, what you're seeking, or they're already passed orders.
Please.
After vacation?
My lord, it may be, I have it on 4th or 5th, my lord.
Yes, 5th.
Please.
Yes, 82.
Till number 82.
Waiting for the respondent, my lord.
My lord,
Challenging 50% of their custody, which is in vacation. my
firstly,
lord.
my name may be shown in the cause list, my lords. My name is not shown.
Anuradha Sinha.
The
Yes.
lead counsel in
The
this
second
matter.
round of litigation, your lordship already interacted with the parties, my lord, in the previous.
I
Now,
have
my lord, they're denying 50% of
I have
vacation.
challenged the order, my lords. Your lordship's order is at page number
Cue that.
47. Page 47.
So
my lord.
invariably, every order that is by passed for the family court should be questioned before the high court.
Well,
No,
this is
they
the
should,
first-
both of them should fight forever.
No, my lords. I've in fact kept the party present. My lords, your lordship.
What is the order? Let's see, not before Mama. Come to
Impugned-
this order.
impugned order
Respondent is
operative
entitled
portion
to
is at page
interim
37.
custody of his minor son for first 50%
That is
during
right.
Dasra, Deepavali, winter. So what is wrong with this?
This is this order has been passed for the very first time. But the mother has been in fact persuading the child, stating that you will have to go.
So forever
But
it should be day visitation.
definitely no, not definitely. My lords, I will not be someone who would say that, my lords. But my lords, what I would probably submit is, my lords, that to start off with, my lords, the child is expressing his inability in respect of staying overnight away from the mother. To start off, at least that could be reduced, and later, once he becomes more comfortable with the father, that is the
Feel
only
comfortable when he will become let mother tell. We will record that day he will have overnight visitation. He will never ever become comfortable.
Being an advocate, I represent always the fathers. I have advised her as well that one or the other day he has to stay with the mother overnight. I'm not denying that. But what she says is she's persuading the child. Child has no problem to spend time from morning till night. All that the child wants is the child has been crying apparently. I've been
No, my
instructed that.
I'll-
And
I'll
I'll have to
file
also
a
place the
objection.
medical record. One.
What is the age?
10 years, 9.5 months.
9.5 years. Your
Hardly
lordships, in
May
fact, have
attempt.
met the child also in the earlier writ petition. I was not the counsel.
Second round of litigation, my lord, your lordships are aware of the facts and nature of the parties. I filed my statement of objection, which shows photographs, my lord. Till now, there is no any complaint or any allegation as per your lordship's order, my lord. Now they come up saying 50% vacation has to be denied. There is no reason by that.
I'm not denying at all.
What we do is, you're saying that he has to get used to it. Let him used to it in this. What is the result of it? Basing on that, what is the next, what is coming?
Summer vacation.
Summer vacation we will not grant.
If he was really interested, he should have exercised this Deepavali visitations, which he has not.
Well,
This order was passed, my lords, subsequent to your lordship's order that was passed before this honorable court. The very next day, this order was passed before the trial court. He didn't even make an attempt to come and meet the child in
What
Deepavali.
happens? How he's making?
My lords, my only submission is.
That regarding we were
My lords, my only submission is at least that could be reduced, my lords.
What is to be
Straight
reduced?
away, my lords, 50%, my lords, that could be at least brought down.
Or else we'll do, wait a minute. Now this vacation, he has 50%
Please, my
vacation.
lord.
We'll do like this. One day he'll have the overnight custody. Second day he'll have the day custody. Then again overnight and a day custody. They sit very nearby, might be.
Please, no, he's already made a plan, my lord, to take.
Where are they going?
He has already made a plan to take Ooty, my lord, because to Ooty, my lord, the child has expressed, my lord. That's the reason I'm in the statement of objection where the photographs have been
Yes,
placed
we'll
on
see
record.
after vacation.
Please,
My lords, that is what they also want at the end of the day. My lords, your suggestion.
just She wants now-
We bow down to your suggestion, my lords.
But
One
just
day-
now the learned counsel appeared for the father. He sought
lord.
50% of
Sir,
vacation,
one
my
minute.
lord. Now he is denying the same.
One second, ನಾನು ಹೇಳ್ತಾರೆ ಒಂದು ಹೇಳ್ತೀನಿ sir. Let me complete.
Yes.
One day, my lords, one day, like your lordship suggested, I just now spoke to the client. She's all right with it. If your lordship, I bow down to your lordship.
But they are going out of the
But at
from
last
Ooty
moment,
every
my
day
lord.
he'll come back. Yes.
Please, my lord.
Sir,
Yes, after vacation, 84,
My lords, the
85.
date may be fixed, my lords, is what I could.
Date 6th.
Please.
1.
Yes,
83.
83
83, my lord. The lords may have it on
after vacation. Yes.
Cell number 84. Final
Yes,
hearing.
84, 85 after vacation.
Lord, 86, my lord. It was part heard, my lord. Could it be tomorrow, my lord? I'll take my chance, my lord.
It can be after vacation, my lord. There's no such urgency. We have deposited the
No,
entire.
it's a parted matter. Tomorrow or after that,
After vacation.
No, my lord, my humble
let it be in the list if you want to
Please,
take a chance, because
tomorrow.
all the more it may not be
Take a
possible
chance,
tomorrow.
I'll take a chance.
Yes.
So tomorrow is a half day, my lord. The leave of the
In you,
I'll take a chance.
yes.
My name may be shown in the cause list.
Lord, interim order has to be accepted.
82, my name.
Which item?
82 in the cause list.
86 interim order has to be accepted. With the leave. The last
In 86, one more request, my lord. Could it be on the top of the list?
Because
With-
tomorrow it might not be possible. Because
I'll take
other
a chance,
matters
my
are
lord, but
there.
could it be on?
What is the issue in that?
My lord, they have to approach the DRT, my lord. They had challenged the sale notice.
This parted matter on the top of the list tomorrow.
Obliged.
interim order has to be extended.
Intermod earlier granted is extended.
Please.
I'm great.
Much.
Madam.
Mega, see, this one is on the top of the list tomorrow. 86, no? 86. Huh? 85, huh? I think it is 6. On the top of the list. ಏನಂತೆ ಸರ್ ಏನ್ ಹೇಳಿ ಇವ್ರೆ ನಾನು ಒಂದ್ ಹೇಳ್ತೀನಿ ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ಸ್ ಇಲ್ದೆಲ್ಲ ನಾವೇನು ಮಾಡೋದಿಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡ್ಸಿರ್ತೀವಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ದಲ್ಲ ಇದ್ದ ನಾವು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಡಾಟಾ ಲಿಸ್ಟಿಂಗ್ ಆಪ್ಷನ್ ಇದೆ ನಮ್ಮ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ ಡೋಂಟ್ ಹೋಲ್ಡ್ ಇಟ್ ಮೂವ್ ಇಟ್ ಅಂತ ಇಲ್ಲ ಎಲ್ಲ ರೀಚ್ ಆಗ್ತಾ ಇದೆ ನೀವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಬರ್ಕೊಡಿ
ಸಬ್ಮಿಷನ್ ಬರ್ತಾ ಇಲ್ಲ
ಇಫ್ ಆಲ್ ನಮ್ಮ ಮೇಡಮ್ ಹೇಳಿದ್ರೆ ಹಂಗೆ ಅದೇ ಇಫ್ ಆಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಂಟ್ ಅಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಬರ್ದಿಯಾರಂತೆ ಎಲಿಜಿಬಲ್ ಇಲ್ಲ ಕಾಪಿ ಇದೆ ಒಂದೇ ಒಂದು
ನಮ್ಮ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್ ಅವ್ರಿಗೆ ಬರ್ಕಳಿಸಿದ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ಅದು ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಅಷ್ಟೇ ಸರ್ ಏನಾದ್ರೂ ಆಗಿರ್ಲಿ ನೀವು ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು ಸರ್ ನಿಮ್ಗೆ ನೀವು ಫೈಲ್ ಮಾಡಾದ್ಮೇಲೆ